Thank you, Justices.
Judge Msimang, I see your mic is muted.
Thank you. I'm sorry. Maybe I shouldn't move my mic. Yesterday, the matter was postponed, or it stood down rather, for Council, particularly for the Minister to give us the statistics of, as requested by the court, of all the registrations that had been made since the 21st of October. An affidavit has been filed, and I see it appears that there is also a response from the applicant, and I think in my system I also noticed that there's also a response from the intervening parties. I'm not sure because when I was printing I couldn't get to that. These affidavits have been filed. Is there any other affidavit that ought to be filed, or any person who requires an affidavit to be filed? And I'm not talking about the lateness or all that. Is there any other affidavit that is outstanding? That's the first thing I want to know.
Justice Msimang, on our part, there'll be a confirmatory affidavit that's filed by Centec. We're just waiting for that, and it will come during the course of the morning. That will be the only thing, nothing else.
And you say that's an affidavit by Centec?
Yes, a confirmatory affidavit by Centec.
Or a confirmatory affidavit by Centec, okay.
Yes, that's all, nothing.
Thank you, Mr. Mutau. That Mr. Ferreira on the screen there. Who else? In view of that, maybe let's wait until we get the Centec affidavit. And as to when the affidavits were filed, I think that should be deferred for later, because it will affect our schedule and our program. Yesterday, the last person to address this court was Mr. Ferreira, and he concluded. I think this morning the first person who must address us is Mr. Mutau.
My Lord, if I might, I'm sorry. I'm sorry, Justices. I'm afraid it's our turn to interrupt, as we've been interrupted yesterday. With respect, we don't see it the same way. The affidavits have been filed belatedly. Our undertaking, as you'll recall, Justices, was that, as we understood, our learned friends promised they would file by 4 p.m. yesterday. That didn't happen. They filed some 5 hours later. But nonetheless, our undertaking was by both the applicants that we would undertake to file affidavits in response by 9 o'clock this morning, which we've done. What's more, of course, is that by virtue of the late filing, the opportunity would then be denied to us as the applicants, who, as my Lord at one point put it yesterday, are dominus litis. We are also entitled, obviously, to present our case properly. And in the circumstances to present our case properly, it's only appropriate that we are able to, as we have already responded to these affidavits, and we would seek leave to properly deal with them. They're critical to the case, and we should not be forced to deal with them in reply. We are perfectly comfortable taking the court through them, given the nature of the affidavits and what they attempt to say. It is critical, with respect, that we're able to, in our main arguments, deal with what is said there, so that not only the court understands the position from the applicant's side, but also so that the opponents who have filed these affidavits have an opportunity to understand what our arguments are, rather than waiting to hear about these in reply. So we would, with respect, submit that the affidavits are before you. It is now incumbent on the applicants to complete their argument, rather than to have our learned friends effectively listen to all of our arguments, belatedly overnight file an affidavit, and prevent us from being able to make arguments on what are critical aspects of the case as part of our main argument. So we would ask that we would be afforded an opportunity to continue the argument. Mr. Marcus, of course, is not here today, but he did excuse himself so that I could continue in his place. And I have already discussed it with our learned friend, Mr. Ferreira, who, for the intervening applicants, would similarly wish to say something about the affidavits and explain why There are three features of them which are to be decided by this court as part of the main argument. And so we would ask for leave to be able to continue our argument in that respect.
That's fair enough.
Sorry, my brother. Mr. Du Plessis, how long do you think you would need to address us on the affidavits? Because speaking for myself, I would like to have the benefit of ETV and the intervening applicants' submissions on those before we hear from the Minister.
Yes.
How long do you think you would need? Because I'm obviously conscious that we are behind on where we thought we would be and do want to try to finish today. How long do you think you would need?
Justice LaRue, I'm going to give you my best estimate without supporting evidence, that I will be around 35 minutes to 40 at most. And I think I'm going to be able to curtail my argument because I've prepared, together with my learned juniors overnight, a short set of authorities which we will put up. They're already on case lines, but which will help me to be able to simply reference those authorities. The court can read them in its own time. They're at 021-327.
Yeah, and Mr. In fact, it's fair enough that you should address this court before Mr. Mutau, because in fact, initially we thought that it's going to be only an issue of getting statistics, but even in that regard, you would have had an opportunity to address this court first, and Mr. Ferreira. Fair enough. Mr. Ferreira, how long do you also want to address? How long is that going to take?
Justices, I will be no longer than 15 to 20 minutes.
20 minutes. Thank you. That will be 35 minutes and 20 minutes. That will be about 50 minutes. Then how do we reschedule our lesson? Because if we start, I wonder if we'll be able to finish this today. All these things, unless we are prepared to work all until overnight until we finish this matter. Is that are all counsel and judges available to run as long until this matter is finalized?
Indeed, my brother. So perhaps we should let Mr. Du Plessis start so we can start getting through things.
Yeah. Okay, Mr. Du Plessis, the floor is yours.
Thank you, Justices, for that indulgence. If I might start by just highlighting that our ETV affidavit has been filed on case lines. It's at 028-1. The court will already have heard from my prefatory statements that, as you'll know, the affidavit by the Minister was promised by 4 o'clock yesterday afternoon. It was only received by us in unsigned form at 20 to 9 in the evening last night. And a signed version was uploaded at just before 10 o'clock in the evening. But we've worked through the night, Justices, and we've attempted to do justice to the case because of the importance of the matters and the evidence, not just to the applicants, but to the very many millions of South Africans who are waiting for an answer from the Minister as to how she's going to be ensuring that they're not cut off in 2 weeks' time. And as I will highlight in a moment through the affidavit, there are no answers to how those millions of people will be protected, respected, or have their rights fulfilled by the Minister in glaring violation of her Section 7 obligations under the Constitution. If I might turn first, before I get to the facts and the key, what I will call key takeaways on the facts as we have them on the numbers, before I get to those key takeaways, there are 6 extraordinary features of this affidavit which we do need to reference for the court. You'll see it in the affidavit itself, where we've, at paragraph 8 of our affidavit, we've set them out. You'll know that we need to just be reminded, all of us with respect, that yesterday, during the hearing, the Minister's Council elected, through the Minister's instructions, he said, to surprise the court and the parties. And there he, for the first time, offered, through those instructions, to file before this court 2 affidavits. And those 2 affidavits were in order to provide an answer to the questions, particularly those that have been asked by each of the justices around the actual facts. What are the actual facts around the digital migration process and the impact that the ASO will have on indigent viewers? And the Minister offered to file the first affidavit yesterday, And after some discussion between the court and him, he agreed that he would do so by 4 p.m. You'll recall that he said because there was a separate team that would be working and exclusively on that aspect of the matter. And so we all expected, of course, as the legal teams opposing, to receive that affidavit by 4 o'clock. But he also, and this is critical, he also offered to file a further report after 31 March, which would then be a report dealing with the further progress of the digital migration process. And we double-checked that offer, and it was made, as you'll see in footnote 1, around 1 hour and 9 minutes into the hearing at approximately 11:21. And I'll come back to why that's important. You'll recall that the court agreed to receive this first affidavit by 4 p.m. And here's another important feature of what happened. And as we recall it, it was through Justice Lukaimane, who directed that the minister should also address in that affidavit why the minister had not previously filed such an affidavit in advance of the hearing, so as to obviously allow the parties and the court an opportunity properly to have regard thereto. What we then had is that the 4 p.m. deadline was missed by 5 hours. And I stress, with no apology, no courtesy of a notice to any of us as their colleagues that it would be late, or that it would actually even arrive last night, or if it was going to be late, by when it would arrive late. So we were forced to sit with respect, and this is the ultimate discourtesy in a case when you're litigating against opponents. We were forced to sit from 4 o'clock onwards last night, waiting for an affidavit, no indication when it would come, no tolerable reason for why it was late, and then simply dumped on us just before 10 o'clock last night in the form of it being formally uploaded onto case lines. There are 6 extraordinary features, we say, around this type of conduct. The first one is something that my learned leader, Mr. Marcus, stressed yesterday. This was a request that had been made to the minister for these facts and evidence already in ETV's replying affidavit. The minister was specifically and pertinently invited to file an affidavit setting out the relevant details regarding installations and registrations, and you'll see we've recorded that at paragraph 12 of the affidavit where ETV had made that invitation to the minister. That invitation, Justices, was not made recently. It was made on the 31st of January, more than 5 weeks ago. While this case was hurtling towards a hearing date, 2 things happened. One is the minister belatedly decided to declare the ASO date, a first surprise, no indications to any parties that that was going to happen. And then, in the course of yesterday's argument, a second surprise, that I'm going to, as the minister, update the court despite the invitation that had been made 5 weeks earlier. And you'll know that the minister declined to file any further affidavit over that 5 weeks period. It's not as though she sat back and was suddenly moved to do so yesterday because she recognized that there was an obligation on her to do so. Quite the opposite. She declined to file any further affidavit. She proceeded to file heads of argument without any updated or further information being disclosed to the court. And she insisted, until our learned friend's interruption of Mr. Marcus yesterday, that there was no duty on her to report to the court. So, yes.
Let me first start by recording, I'm sure, the full court's indebtedness both to the minister's legal team and the applicants and the intervener and applicants' legal teams for working through the night and early morning to get us additional affidavits. But on this first point, if I can call it sort of the conduct of litigation point, does this go to something substantive or on the merits that in terms of the type of relief that your client is seeking, or is this something that we would put into sort of the costs evaluation basket? Where does the conduct of the litigation point go for us? Is it just a costs issue, or is it relevant to some merits point as well? Because where we are now, fortunately, the court is in a position that at 10 o'clock this morning it had all 3 affidavits that it can now consider when it considers the judgment. I don't want to spend too much time on discourtesies and timing unless they matter for a merits point.
They do, for 3 reasons, Justice LaRue. They matter, firstly, as you say, for matter, obviously, of costs. But they matter also because they highlight what we've repeatedly complained about, which is a failure of transparency and openness. And that continues in the manner in which this litigation was conducted right up until the end. And it will feature, you'll see, in the ways in which we say that still today there is a failure of openness and transparency in the manner in which the particular facts have been conveyed to the court on the figures. I'm going to highlight that in a moment. And then thirdly, it resonates obviously for the court at the level of why it is critically necessary for a reporting obligation to be imposed under remedy. So I take your point, Justice LaRue, that we don't wish to spend too much time trawling through discourtesies. But sometimes it's important to recognize the type of discourtesy in a case because of what it says more broadly about the manner in which the minister sees her obligations. The minister has not taken her obligations seriously to be open and candid with the court. We've complained about that previously. But this is also a question of whether she's able to properly justify under Section 7.2 of her constitutional obligations the manner in which this litigation ultimately has forced her to explain what has been done in respect to millions of people. And as I say, it's also absolutely necessary to underline why when we say reporting is required, it is required. I turn then, Justices, very briefly to the second point and the manner and the timing of the offer that was given. And it's extraordinary because, as we say in that second point, what happened was we, with respect, say that the Minister's Counsel saw fit to interrupt Mr. Marcus's argument and for the first time to make the offer once he'd seen where the judicial wind was blowing. We don't know whether that offer would have been made at all had it not been for the fact that the court began to ask questions of Mr. Marcus around the facts of how many people might be left behind. And at one other point, I think it was yourself, Justice LaRue, said, perhaps that's unfair to ask Mr. Marcus, this is something that Mr. Mattal will have to answer. Well, quite so. It was at around that point that we had the interruption that took place. And so with respect, again, this goes to the question of how one litigates, not just at the level of costs, but also at the level of doing your duty to a court as a minister to assist. You don't sit back and wait to see how the judicial wind blows. And then when you recognize that it might not be blowing in your direction, to then say, well, hang on, we'll file affidavits. Recalling that when the case started, Justices, that morning, and all the counsel were asked what were their views as to what they were arguing, there was no indication from our learned friends that they were going to be filing this affidavit. None. Or that their instructions were to do so. The third extraordinary feature of the offer is that it amounts to an effective concession of the reporting relief. So, Justice LaRue, that's the point I was making earlier as to why this is necessary. It's necessary not just to show the manner of litigation, but it's also necessary to confirm our learned friends have now effectively accepted that they need to report to the court. They need to report to the court, and they've offered to do so both by the affidavit filed belatedly last night, but also by the further affidavit that I stressed. Our learned friend said the minister would file after 31 March 2022. The fourth extraordinary feature is that the minister does not in her affidavit respond to Justice Lukaimane's suggestion that the minister should explain why this wasn't done earlier. There's no explanation, there's no explanation at all for the lateness of the facts. The fifth extraordinary feature is that the minister in her supplementary affidavit only looks at her obligation through the lens of those who had registered. So this goes again, Justice LaRue, to the features of the particular affidavit and how it's constructed. We will take you in a moment to how those that have been left behind are not just left behind. They're ignored entirely in the affidavit. They are made, they are not spoken about. It's as though they do not exist. And so you'll see an extraordinary feature of the minister's affidavit is that her obligation is ring-fenced for her in her own mind. It's what our learned friend, I think yesterday at one point in his interruption of Mr. Marcus called the core group. He said the core group are those that had registered, and that's the KZN principle, he says. It applies to the core group and the core group only.
To be fair to Mr. Mattal, that was my characterization when I asked a question to Mr. Marcus. I think I introduced this core group label, however appropriate or not it is to the description.
I'm grateful for that correction, but I'm very sure that our learned friend would agree that that's what he's talking about, that there are a limited number of people that the minister needs to be worried or care about. Those are the people that registered in time by 31 October. The sixth feature is the manner in which the minister has chosen to convey the information in the affidavit, and I'm going to come back to that in a little more detail. It falls radically short, we say, not only of the 165(4) obligations on the Minister to assist the court by providing proper evidence to the court, but it also falls palpably short of the duty to justify under section 7.2 and where there's a reasonableness challenge under the limitation clause. So let me then turn, if I might, with those discourtesies and extraordinary features as framing numbers of things I'm going to say in a moment to the next heading. And that is that, and I'm going to try, Justices, just to give you the takeaway points. I appreciate that you need to go and read this in your own time, but just so that I can leave you with the takeaway points under each of these headings. The first heading is that we now know that the additional households, the hundreds of thousands that have already registered since 31 October, those additional households, the Minister reveals to be 260,868 households. They registered between 31 October and 10 March 22, and you know that on the figures of numbers of people in those households, it amounts to about 860,000 South Africans. None of those people will receive set-top boxes by 31 March 22. They will go months without access to free-to-air television, and the Minister's affidavit confirms that. You'll see, firstly, that at 21.1, we say registration is far outstripping installation. There have been 103,000 odd installations from 31 October to 14 March. Over that same period, from 31 October to 14 March, there have been 261, just short of 261 odd thousand registrations. And here's the critical takeaway. The Minister has made no provision at all for set-top boxes to be provided to these 250,000 households, and has not even applied to Treasury for the relevant deviation. So let that sink in for a second, if it may. As we saw the debate yesterday around the notice to people within 3 weeks, and Mr. Ferreira highlighting how originally they were told there would be an app that might be forthcoming. Justice Lukamano remembers the debate around the fact that there was an app, and then later in another notice, a month later in November, it was told, no, it's not an app. The app suddenly disappeared. There was going to be a website that one had to register on. Well, all those people that were encouraged to do something about getting onto the bus, so to speak, all for nothing, because the Minister has made no provision at all for set-top boxes to that 250,000 households. She tells you that she's not yet applied to Treasury for the relevant deviation. So when the Minister's department approached for funding, it sought approval only for those who had registered by 31 October 2021. And the Minister knew that that was inadequate, because she knew that more people were likely to want to register. That's after all why she was telling us about website apps and website links and so on. But now has made clear that that 31 October registration number is the cutoff date, and anybody, these 260,000 registrations that occurred from 31 October to 14 March 2022, those are simply not covered. So all of this.
Mr. Du Plessis, just to continue my trend of asking the applicants' counsel things that I'll also ask Mr. Matau, am I right that on the figures we had until this affidavit, we had the 800,000 boxes in stock, and if you took out the 596,000 that had been installed and the 671,000 that had been registered, we had 128,000 in stock. And so there might be a world where there are 100, I mean, we shouldn't be guessing, but there might be a world where there are 128,000 boxes in stock, but then that won't satisfy the 260,000.
Anyway.
Which is my maths right, though, that we had 128,000 in a warehouse, we thought, for people who registered after 31 October.
Yes, that's right. But your maths makes sense in as much as that's certainly not going to cover them. And to the extent that it's not going to cover them, while we're speculating, Justice LaRue, which is not what we should be doing, but while we're speculating, we know that whatever the shortfall is, there's not going to be a deviation sought for that from Treasury. So they will be out. So, and you can go and read with respect to paragraph 18 of the Minister's affidavit. It says it very bluntly. It's if the number of additional registration does not change, the project would just need to apply for a deviation from the National Treasury to increase the contract scope and value. That hasn't been done, okay? But then it says this is so because the National Treasury has approved installation for registrations, here you get it, up to 31 October 2021. They are not doing anything beyond 31/2021. Why? Because you see the final sentence. The number of late registration was an unknown factor which could not be provided for in the National Treasury approvals. So the entire focus is on that number, 31 October 2021. And anything beyond that is unfortunately left out. That's as best we can make out what the minister is saying in respect of what she calls the 260,868 households that registered between 31 October and 10 March 2022, representing just under 1 million South Africans. So that's the takeaway from that first point. The second takeaway, or the second point and some takeaways from it, is that what happens to those who managed to register by 31 October 2021, despite, as we know, almost no notice? So what happened to all of those that did register? And here you get the minister going from slothful or slow implementation and installation to palpably unbelievable light speed. And I'm going to explain to you why. Let's just look at, you can read 24, there are certain unexplained facts as to how the minister now gets to what she says is that 31 October there were 1.2 million households that had registered, and then she says of the total registered households, only 1.1 qualify for government support. It's not explained on what basis those were kicked out. Then she says of the total qualifying households, 12,000 could not be installed at their stipulated address, resulting in, this is her overall figure, resulting in 1.167 million households requiring installations. And again, it's not explained why those 12 million households couldn't have their set-top boxes installed at their stipulated addresses.
12,000. Sorry, 12,000.
Yes, 12,000, my apologies. But the point is that the failure to explain those facts and figures, let's just move beyond that failure to explain, because what we see at paragraph 25 of the affidavit, we're saying now this: on the minister's revised suggestion of how many set-top boxes the government on her own improper assessment has to install by 31 March, we're now told that of the 1.16 million requiring installations, 660,000 were installed as of 10 March 2022, leaving a total of 507,000 odd households yet to be installed. So between now and 2 weeks from now, the 31st of March, the minister's committed, because of her idea of what is this core bunch of people who have registered on time, she is committed, she tells us, to installing boxes for 507,000 households. But here's the question: how likely is this to be done, given the rate of installation that we have on the papers? And you'll see this set out at paragraph 26. The minister explains that as at the date of the answering affidavit, 556,000 households had been installed. And she says that since that date, the total number of installations has increased to 660,000, this new figure. And that means that there have been 103,000 additional installations. That's how we get to this figure of 507,000 households that still have to be done before the 31st of March, right? But in the minister's answering affidavit, the figure of 556,000 registrations was the number of registrations since 31 October 2021. So what we know is that it took the government some 4.5 months from 31 October to 14 March this year to install those 103,000 set-top boxes. So what's the rate of installation? It works out to approximately 23,000 per month. 23,000 set-top boxes installed in households per month. That is current figures. That's at today's date. That's not an historic rate. So the deponent to the affidavit would now have the court believe that despite that current rate, the government can install these remaining households who are between now and the end of March waiting for 507,000 set-top boxes across the country in just 2 weeks. In light of those facts, with respect, it's just palpably not possible that in the final 2 weeks, the minister can project, as she does. You'll see there's a projection that the minister projects. The minister projects that there will be a certain number of boxes that are installed over a period of time leading up to 31 March. But that projection will then mean that you've got to jump to over 35,000 a day on our maths. 35,000 installations a day would have to take place over the next 2 weeks in order to meet the 507,000 installation target, when the current evidence is that the current rate is only 23,000 per month. So it's simply an impossible projection. Projections without any facts, or projections that are contrary to the facts, are incredible and fanciful, and as we say on the usual Pascal Evans tests, could be rejected out of hand. But all the more so in this case where there's a duty to justify properly. So we say there's absolutely no specificity in this regard. The bold allegations are made in one paragraph, where you'll see the minister says at paragraph 14, we project that the department will have installed a range of set-top boxes over the space of this time, satisfying the outstanding amount of 507,251. And as you'll see, we've said in the affidavit at paragraph 30.1 and 30.2, if you just think about it practically, on the basis of two large provinces like KZN and Eastern Cape, and the distances between the various centres, local, regional, and heads of capitals in any of those provinces, you just can see for the maths that it's not going to be possible at the rate that we know is 23,000 per month to get anywhere close to rolling out the 136,000 odd outstanding households that need to be completed in KZN and the 146,000 households that have to be completed in the Eastern Cape. And so we know with respect on the minister's own evidence that it's not going to be possible. In any event, as I then highlight, and I'm going to give you simply the authorities in a moment when I finish my address, all of this is on the basis of unsubstantiated hearsay. So it's the DG, the acting DG, who makes the affidavit. That affidavit was put up last night. We're now told on the eve of the morning, after our learned friends have filed their affidavit, that they're going to be putting up a confirmatory affidavit from Centec. Well, one would have thought that the confirmatory would have been filed last night, even if it wasn't signed. They would have at least had a confirmatory affidavit ready and provided to the parties so that we knew that Centec's affidavit was available. But quite aside from Centec, it's the post office that has got installations. It's the post office that is central. It houses all of these set-top boxes, supposedly. There's no confirmatory affidavit from the post office. So anything that one has in this affidavit about these speculative averments is immediately undercut by the fact that they are ultimately simply hearsay. I will, as I say, draw attention to the authorities on hearsay evidence in a moment when I get to the question of failure to justify. But before I do so, let me just finish the final section of this affidavit, which really is the forgotten millions, if I may put it that way. And that's the paragraph 40 onwards section, where we talk about the vast majority of the 3.75 million households that still require government to provide them with set-top boxes. Fatally, we say to the minister's justification, the minister makes no attempt, there's simply no attempt to deal with a number of households that the evidence says have not currently been able to migrate to digital migration. And the minister just ignores them. There's no deviation that will be sought from them. There's no commitment to explain how they can simply be ignored. The minister has fixated on those that registered by 31 October. That's her full answer. Anybody that comes afterwards, as I've already explained to you, there's no evidence in relation to how those that registered after 31 October, the 200,000 that need set-top boxes, the 260,000 registrations, how they're going to be accommodated. But this is the forgotten millions. Beyond that, what about all the other millions of people who are on the minister's own showing, on her facts, going to be left behind?
Mr. Du Plessis, on that, isn't it that the entire exercise, the purpose of the exercise of getting these figures was because these are the only tangible figures that we can be able to say, these are the people. And that registration process tells me that it's working because there are people. These are the figures that I'm happy with, that I can work with because they are tangible. See, touch, and feel. These are the figures that I can. But the other millions, those would have been based on the 3.7 million. And if you read the minister's affidavit, it says they estimated, it's a thumbs up, the 3.7 million, as far as I'm concerned. So I don't think you should really, I know your case is based on the fact that there is missing millions. If you say missing millions, then you must have some scientific way of calculating how those millions are. Who are those people? The other way, for example, maybe for example, if the court says, okay, fine, we are going to suspend the cut-off date, maybe until the 31st of May, and permit all the people who have not registered, so that we should have a tangible figure. That's the only time we can talk about the missing millions. But for now, these are the figures that are tangible. These are the figures which we can say there are people out there who need these set-top boxes, these decoders, and who have registered.
Yes, thank you, Justice. Yes. So if I might respond very briefly in three ways. The first way is to tell the court that in fact, the figures are available. You want hard figures, I'm going to take you to them in a second. And they're figures which we put up in our affidavit about the number of people who are indigent and the number of people who are viewing, and the minister did not deny them. So I'll take you to those in a second. Those are the tangible figures. But to the extent that my Lord is concerned about the fact that these are outdated figures, and we've heard my Lord saying, well, but these are statistics from 2018. Well, then that's a fatal blow to the minister, because the minister, of course, has taken her decision on the basis of outdated figures, statistically or otherwise. And that's then something that the minister can't get right. It's not our problem, it's the minister's. And then third and finally, if I might just highlight for the court that, of course, it is critical to look at the very many other millions that are involved, because the minister promised in her media statement of the 5th of October that all South Africans who were indigent, and who received less than 3,500 Rand per month were part of what, under the heading in her notice, was the Broadcast Digital Migration Program. So it's not appropriate or constitutionally accurate, with respect, to say that we can simply ignore those millions. The minister didn't when she issued her 5 October statement. She said the following. She said, the government undertook to assist beneficiary households earning total salary of less than 3,500 per month with installation of set-top boxes to ensure universal migration. Justice Msimang, that is at case lines 001-215. That's the minister's public statement on 5 October. So she recognized that there were there were a large number of people, and you'll see that in that particular paragraph, she says the process of registering beneficiary households to be supported commenced in 2015, and to date 1.184 million qualifying households have been registered out of the estimated 3.75 million qualifying households. She's speaking about those individuals that need set-top boxes in order to ensure universal migration. She said it in black and white in paragraph 2.1 of her own media statement, publicly made to those that were entitled to recognize that as the means by which their rights would be protected. So, if I might then very briefly, Justice Msimang, because I understand that you want the hard figures. Well, here they are. You'll see it at paragraph 41 of the affidavit. The figures that are referenced here, Justice Msimang, are accurate in two ways. Firstly, they are the accurate figures from the Broadcasting Research Council that prepared them. That's the expert body. In the equivalent of what my Lord was saying yesterday about wanting some type of report, like a road accident report, they are the equivalent of the Road Accident Fund. They are the Broadcasting Research Council that have these facts. That's the first point. The second point is that the minister did not challenge their accuracy, and I'm going to show you in each of these figures, the minister admitted them. So the first figure is that there are currently 15.8 million television households in South Africa. It's 90% of the population, right? Now, how many of them are analog television watchers? And you'll see at 41.2, Justice Msimang, it's undisputed that 36% of the TV households, that 5.7 million households, still receive free-to-air television via analog transmission. You'll see we've given you the references at footnote 16, where it's in the evidence and it's not disputed by the minister. Even on the minister's evidence, so before I go further, 41.2 is the applicant's evidence not disputed by the minister, which is at 36% of the households, 5.7 million people. or households rather, still receive free-to-air television by analog transmission. Even if you accept the minister's evidence, you'll see that at 41.3, we've tried to be fair to what the minister said. Even on her figures from 2018, which the minister again relies on here in a supplementary affidavit, she says there are 3.6 million households that still rely on analog transmission. Very large sums, whether it's 5.7 or 3.6, I want to stress a point here. These individuals' rights, individually, not collectively, the people who sit in those homes, each of whom has a right to be respected, those individuals have their rights threatened. And I want to make that point, Justices, because when one gets to a constitutional case, you have the right under Section 38 of the Constitution to complain that one's rights have been violated or threatened. And a court is entitled to grant relief in respect of rights that have been violated or threatened. And so in this context, that is the sense of the range. We're talking between 5.7 million households and 3.6 million households whose rights are threatened. Even if you don't agree that they have actually been violated because the evidence is a little unclear from the minister's side, you at least know that that is the range of people whose rights are potentially at risk or threatened. And of course, you see that that's 3.6 million households that still rely on analog transmission. So if you turn over the affidavit and you see
Mr. Duplessis, yeah, I hear you on that. These figures from the Broadcasting Research Council, they are figures as at what date? Do you know?
Justice, I will get that for you, but they were put up as part of the MMA's affidavit. And I'm sure either my learner junior or Mr. Ferreira will be able to provide that information.
Yes, when you provide that information, what I want to check to find out is will it be affected by these installations that have since happened, these STB boxes that have been installed after these figures were put up?
Well, I'm going to get to just how, even assuming for the minister that there had been installations, it can't get anywhere close to the millions that are not able to, without set-top boxes, watch analog television. So that Justice Msimang is made clear, the second set of numbers that are relevant. You'll see that at paragraph 42. The minister, sorry, Justice Larry, sorry.
I don't want to interrupt your flow on numbers, but another factual question I had is, where in the papers do we know the expected, we don't know registrations by province, do we? Of that 260, let me tell you what I'm wondering. I'm wondering whether that 260 are predominantly in the 5 provinces that have been shut off. So are we seeing the effect that Vodacom indicates, which is people will be motivated to register when it's switched off? We don't. I don't know if you've probably studied the affidavits more closely than I've been able to. Do we know by province?
I don't think we know.
No, it's not. The information is not provided by province.
Of the 260 new registrations.
Let me just see. I think, no, not of the people that have since registered, no.
No.
Yeah, you have the 10 points, the paragraph 10 of the minister's affidavit that is the 507,000 registered and how they're going to be done by province. But of the 260 new registrations, we don't know if they had that Vodacom effect of registering on cutoff.
No, we don't know that. The best we have is the speculative projection, but it's not by province, at paragraph 14, that we project the department will have installed 197 by that date, 184 by the next date, and so on. But we don't know where that is.
507... Sorry, the 507 is registered by 31 October, or that includes the 260?
No.
No, it doesn't include.
The 507 does not include this.
Yeah. Okay. Thank you. Thank you, my sister.
Sorry, I'm appreciative of the fact. Thank you, Justice Lukamane, for assisting me to clarify what I know. I'm trying to get through as quickly as possible because of the undertaking to not be longer than 40 minutes. Could I then return to the concerns I think that in particular Justice Msimang has about how many of these households are in fact going to be able to receive any form of assistance in set-top boxes. We know that, as I've already highlighted to you, we've got whether on our evidence 5.7 million households who receive their television from an analog television, or on the minister's affidavit 3.6 million households. Well then, we interestingly see at 42.1 that the minister estimates that the numbers from Stats SA show that there will be 3.75 million households who are eligible for and have been promised government set-top boxes. And what that immediately shows you is that there's a correlation between what the minister had said, which is that there are roughly 3.6 million households that still rely on analog transmission, and what she herself says is around 3.75 million eligible households who have been promised government set-top boxes. So the indigent, the poorest of the poor, who continue to watch their television by way of analog, the number that the minister gives of 3.6 million households correlates neatly with the number of indigent households that the minister herself accepts is 3.75 million. So that represents over 12 million South Africans, and the minister again in her supplementary affidavit relies on Stats SA numbers from 2018. That's her choice, Justice Msimang. Those are the numbers she relies on. I'll get back to a moment how that, if you think she shouldn't be permitted to do so, is a fatal flaw in her argument. But for present purposes, let me take those facts as they stand. In the context, then, of this case, the minister now makes clear, you'll see at paragraph 43 of the affidavit, she now makes clear in the supplementary affidavit that of those 3.75 million households who are eligible and reliant on government to migrate them, the minister is only going to install, Justice Msimang, this was your question, does it take into account that number? The minister is only going to install 1.167 million set-top boxes by 31 March. That's assuming that she can even get the 2 weeks gap closed on the 507,000 that are still outstanding. So the best case for her is that there is this large number of 3.75 million households that are indigent and that happen to correlate with her 3.6 million households that she says watch analog television. And here she tells you that she's only going to install, by 31 March, 1.16 million set-top boxes. So what does that mean? What does that mean? It means that at paragraph 44, we've said it, we know that come the ASO date of 31 March, of the 3.75 million households, if you do the maths, 2.5 million households, that's 3.75 minus the 1.167, 2.58 million qualifying indigent households, over 8 million South Africans will not have been migrated. And yet the minister simply does not deal with that in this affidavit. It's as though, as I said, they're the forgotten. It's as though they do not exist. They are at home right now, or this evening.
But Mr. du Plessis, if these households are there and they exist, and they don't take up the registration process, how is it that we are able to say they are actually there? Because the only way we can be able to tell is when they register. I mean, if they register, we know. But as I say always, is that the basis of the 3.7 million or whatever, unless the people register and say and raise my hand and say I need that thing, how do I take account of a fictitious person out there unless I know this is X or Y or Z?
Well,
and maybe in also answering that, do you know what happened? Because say there was a hype of activity during October and November. Maybe I'm also just ignorant of media notifications, but do you know what else was done after November to try and get people to register? Because maybe between 5 October and 31 October, because of the nature of the communication, some people might have been left behind. But do we know what actually happened? Maybe even after the 29th of November, during November when it was said there'd be a website, what further steps do you know were taken to try and get people to actively register?
Du Plessis, just if I could have a sub-question to my sister's question, what has your client done to communicate to its viewers that they need to register?
Well, let me answer the questions this way. We don't know, it's the Minister's duty to have provided, obviously, information about the registration. It's wholly impossible for us to answer that question. We can only tell you what's on the facts. And the pleadings in this case show that there was that statement on the 5th of October by the Minister around, we'll wait for a WhatsApp that's in development, it will be coming your way soon. And then thereafter was I think it was the end of November statement by the Minister around, there's a new website which you can go to. Aside from that, I don't understand, I speak subject to correction, that anything further is on the papers put up by the Minister to show what was done to ensure registrations. And that was incumbent on the Minister, because remembering in reply, we had asked the Minister to explain what had been done in order to ensure that this rollout had happened. In respect of the question of, well, what has ETV done? Again, I'm not sure that ETV has any duty to provide that information to the public. I'm not sure on the facts. I'll again have to double check. My
question was to its viewers that it knows will be affected. Has it communicated to its viewers that if you want to continue to see the program you're watching, your favorite soapy or whatever it is, you must register? It was a question about their viewers, not the public at large.
Yes, no, I'm not sure of the answer to that, but I will double check. But in answering Justice Masimang's point, the reality, Justice Masimang, is that when you talk about these indigent people, that's the problem. It's not appropriate for the Minister to have made as though they don't exist. It is entirely duty bound, or the Minister rather, is entirely duty bound to have ensured that this information is properly analysed. And in particular by doing, for example, a report, a study, before the cut-off date had been imposed, to understand precisely what numbers of individuals were going to be ultimately cut off. And in this context, the reality is we know that by the time that the cut-off is going to take place next week or 2 weeks from now, the Minister's affidavit that has been filed in this court refuses to engage with those facts. The Minister's affidavit refuses to engage with it. Now, Justice Masimang, you say, well, how else were people going to get registered? They needed to be encouraged to register. Well, we've already made our submissions that the 3-week period was seriously irrational and unreasonable. It was such a short amount of time that it effectively ensured, as we've just highlighted, that large numbers of millions of South Africa, we say that around 2.5 million indigent television households were not able to register on time. The suggestion by Vodacom and others, well, that's tough luck to them, they just didn't register on time, is first of all belied by the facts. As we know, Justice Lukamane, after October up until March, the Minister has now highlighted that there were numbers of households that attempted to register. So they tried to register. And I've given you the submissions on that. What happened to the additional households, 260,000 of them that tried to register? On the Minister's affidavit, they don't get a set-top box. There's no deviation. The Minister's not applying for a deviation. She's only applied for the numbers of set-top boxes and the finance necessary to install for those that made the 31 October deadline. So there's no trying to make sure that those additional who in fact registered were in any way catered for on her numbers. But as I say, quite aside from the 260,000 that happened to show registration, what about those that never registered? There's just no indication that the Minister's in any way concerned about the fact that, as I said, 2 weeks from now, they will ultimately find that their televisions are switched off. So,
Mr. Duplessis, I hear you. Those other people who have just registered, as my sister, then said, some of them will be counted for by those boxes that are still there. But if it turns out that they are not sufficient, there is maybe 200 set-top boxes that are there, then this court can be able to do, because we know those people are there and actually those people physically exist. But those others, let me say, the other millions that we are always talking about, because I asked both Mr. Marcus and Mr. Perina about the practical approach, because all the court needs is that you must be practical about this thing. That's why I'm saying to you, if the court will then suspend, for example, as I'm just giving an example, I'm not saying that's what's going to happen. If we said the court says then, okay, the cut-off date promulgated as the 31st, the court suspends that date, maybe to the 30th of June, for example, to enable, and say the first 2 months, to enable all those who have not register, and even say to the minister, you must advertise this in the local newspaper, so we'll make sure that people, and let's get the figures there. And then perhaps say, then minister, you must then be able to make sure that the treasury and those people are catered for, maybe by the 30th of September. And those boxes are inserted. And look, I'm just saying, practically, what is it that we can do? Because at the end of the day, we need a practical answer to this practical problem. Have you any suggestions on what you think? I mean, we want to hear what all the parties think and what the parties can contribute to the practical solution.
Yes, Justice Msimang, we have thought about it. And that's what's reflected in the relief that we seek, because it's for that reason that we've attempted to ensure that there are declaratives which say that the minister has not consulted and has not actually taken the appropriate steps to ensure that people are not left behind, and then to report on how this is going to be done properly. So that's contained in the relief. We can have a debate further about whether there are any changes that might be required to that relief. That's open to us as the advocates in the case and the court alongside us. But if
for me, there is an additional complication that arises in terms of some of the relief that we might consider. And I think the Ministers' Council must be ready to prepare us to prepare an answer on that. But I'm just mentioning it here because it arises from this conversation. Given that there hasn't been any provision made for a deviation for anything additional, I don't think that we can sit here and then provide for things where a deviation for funding has not been requested when it actually binds another party, which is the Treasury, which has its own considerations as to what it will allow funding for. So on the manner in which this matter has been handled thus far, and the tendency to limit everything to the people that have registered, we are actually left with a problem that we cannot determine whether a proper outcome can actually be found in the short term, given that there are all sorts of other things that must be considered. So I think Advocate Mutau must just make sure that we are addressed on some of those issues when they do come up.
Thank you, Justice Lukamwane. And we take note of that. If I might answer both of the questions raised around this in this way. Justice Msimang, it's not a question of what's practical. That's at the level of remedy. What's practical, just and equitable is something that I think, Justice Lukamwane, you're raising. It's the difficulty of how to deal with the fact that there aren't proper facts, and there's not a sufficient amount of justification to explain why what I've called the forgotten are simply going to be left behind. But there's a prior question, Justice Msimang. It's whether what the minister has done is reasonable under the Constitution. And if it's not, and it's not been justified as reasonable, then the court has no discretion. It must declare that to be unconstitutional. It has to do so. In the failure to justify, that's where the court ultimately has to do its work. And
Mr. Duplessis, surely the review relief would be sufficient.
We don't think it would be sufficient. It would certainly set aside the ASO date. But what we think would be required in order to ensure, and we're attempting to be diligent and responsible constitutional citizens alongside the minister, is to try and figure out a remedy that ensures that if one takes seriously that there needs to be...
No, but I'm saying review relief plus the practical solution may or may not include further reporting to the court, as opposed to the declarator?
Well, I think that's the point that Mr. Ferreira made, that you don't need the declarators to get the review. We would say that the declarators, in light of what the Constitutional Court has said is important about declarators, they help to assist the minister to understand what her powers are and her duties are. We'd stand by the need for the declarators. But if I might try and round off, sorry, I recognize that I've now spoken a little bit longer than I'd promised, and I hope that that's on account of the questions, and that I've nevertheless been helpful. I just wish to then briefly finish by highlighting what is in our note on authorities for argument, because as I now have stressed for the court, what you've effectively got is a situation where the minister has failed yet again, even though she's filed this affidavit, she's failed properly to explain numbers of features of the case, and she's done so in a manner which ultimately we say fails her obligations to justify. So if I might just quickly highlight, it's at 021-327, it's on case lines, and I need to just deal immediately, you'll see, with the first topic, which is the duty to justify. This is not something which is a Plascon-Evans duty to justify. This is a constitutional case where there's been very serious allegations made about many, very millions of people whose rights have been violated, and there's a duty then to justify. And you'll see that we've said that it's a constitutional matter which entails limitation of right. It's not for us, and I stress this, Justice Masimong, I think you were saying yesterday at one point to my learned leader, Mr. Marcus, that we're dominus litis. It's with respect not for us as the applicants to provide this evidence. If we are able to show, as we have, that there is a legality risk, and there's a violation of rights or a threat to rights, then, and we've done so credibly with respect, we must have, because the minister herself has recognized that numbers of people are entitled to set-top boxes precisely because they're poor. Then the debate becomes, well, has the minister justified the failure to properly ensure that those set-top boxes are rolled out to those that have registered, and to ensure deviations, to cover the shortfall, and to ensure that the forgotten many millions are actually even top of mind? She hasn't done any of that. And so we've referenced Khalil. You'll see in the footnote, the Supreme Court of Appeal has said, whereas here the legality of the actions of the officials is at stake, it's crucial for public servants to neither be coy nor to play fast and loose with the truth. On the contrary, it's their duty to take the court into their confidence and fully explain the facts so that an informed decision can be taken in the interests of the public and good governance. And that goes strikingly to the very question that Justice Lukamane put. Well, how do we do this? How do we take account of these facts or the gaps in the facts? But that's because, Justice Lukamane, with respect, the court wants to ensure that there is good public and good governance in this particular context. And that's why evidence was critical. The second case we've referenced is New Clicks, and the Constitutional Court there was dealing with regulations that had been passed or drafted, and ultimately those regulations impacted on the professions of very many millions of people, potentially who were employed as pharmacists. And the Constitutional Court said, where there's a duty of accountability, it imposes a special responsibility for the minister in that case and here to show that it has taken all reasonable steps to assess, take account of, and justify the knock-on effects, in that case of the pharmacy profession, in this case on television viewers. And then critically, the more the risk, the greater the intervention. Here, we're speaking about not a risk of hundreds of people. We're not speaking about thousands of people. Even in the minister's own case, even if you exclude the forgotten, we're speaking about around 200,000 people who she says were registered, but she's not going to be able to get a deviation in time to ensure that there's going to be televisions that with set-top boxes allow them to continue watching after 31 March. So we've also highlighted for the court NICRO. And NICRO is important because that was a case, again, where the Constitutional Court stressed that we're talking about a violation of rights under Section 36, as my learned leader, Mr. Marcus, pointed out. You have a duty as the government when there's been an allegation of rights violations. You have a duty to put proper evidence before the court. And to answer the question that Justice Masimang, you repeatedly raised, I think correctly, which is, where is the report? Where was a report by the minister in this case as to what this would mean on 31 October when all of this happens? Well, we're talking about the need for such a report when you've got 800,000 people, 260,000 households. Earlier I said 260,000 people, I meant households. We're talking about 260,000 households that are going to be left behind, 800,000 people. You need to have done your due diligence, so to speak, as a minister to ensure that they are not going to be left behind. I leave the authorities with you. You'll read them in your own time, but I wish to put them before you because they explain why, to answer Justice Leroux's earlier questions to me about the manner in which this affidavit was given to us at the lateness of last night. This is not how you, as a government minister, with respect, justify a serious rights violation. You don't ignore a request to provide that information, which was asked of you 5 weeks earlier. You don't put it up at 10 o'clock at night so that your opponents have to scramble through the evening to draft a response. We have kept our undertaking, we've done so. And in keeping that undertaking, we have highlighted for you, on oath, where there are critical gaps in the minister's own affidavit, where she's not explained how she's going to be doing the necessary due diligence to ensure that these rights are not violated. And so in those circumstances, it justifies not only the relief we're seeking, but also it explains why the minister's conduct in terms of the case law, Khalil and Nuclex and NICRO, simply fails the constitutional test for justification. Thank you, Justices, for the indulgence. I appreciate that I have gone a little over time, but hopefully that has been helpful.
Thank you, Mr. Duplessis. Once more, echo my sister's sentiments. We thank you for having really worked overnight to prepare this affidavit. We don't just take it for granted. Thank you, sir. Mr.
Maybe before Mr. Ferreira starts, I see it's 5 minutes to tea time. Maybe we take an early tea time and then we come back earlier, and then so that we don't interrupt him at the beginning of his.
Okay. Then we take a tea break for how long? 15 minutes?
10 minutes, yeah.
We'll take a tea break for 15 minutes and the court will adjourn.
Thank you.
I'm sorry. Can you hear me, Justice?
Yes, we can hear you.
Yes, we can hear you, Mr. Ferreira. If you are on, can you go on? Proceed, please.
Yes, thank you, Justice. I was just saying that thanks to Mr. Duplessis' comprehensiveness, I expect I will be able to be very brief indeed. If I may divide my submissions into the two categories of people of concern, as I referred to yesterday, in relation to the first category, in other words, persons who require assistance to migrate, but who have not yet registered, there's really not much to add to what Mr. Duplessis has said, other than to say that in our supplementary answer, we put up an annexure which demonstrates, as common sense would suggest, given the decline in the South African economy, that the Stats SA estimate of indigent households from 2018 will indeed likely be a lowball figure. In other words, there will now be more indigent households than there were as a result of unemployment having increased. That is at paragraph 10 of our supplementary affidavit at page 029-5. Other than that, we endorse everything that Mr. Duplessis has said. I have nothing to add in respect of those who require assistance but have not yet registered. In relation to the second category of concern, those who have registered but who have not yet had set-top boxes installed, we make the following submissions in relation to the Minister's projections of the extent to which the intention is to accelerate installations. The overall submission is that what one finds in this supplementary affidavit is a very laudable intention to accelerate the rate of installations, which is utterly out of touch with reality and historical performance. And in fact, if you scrutinize the figures on their face, the projections are simply impossible to be achieved. And I say so for the following reasons. What we've said in our supplementary affidavit, the court will find at page 029-6, starting from paragraph 12, I'll direct the court there. What is promised in the supplementary affidavit is an utterly extraordinary acceleration of the rate of historical installations. On the Minister's numbers, you see at paragraph 12.1.3, the rate of installation that was achieved between 28 November 2021 and to date nationally is about 1,401 set-top boxes per day. What the Minister says in the supplementary affidavit is that between today and the 20th of March 2022, in other words overnight, that will be increased to 32,869 installations per day. In other words, a 23-fold or 2,300% increase on current rates. And you'll see as we go down through paragraph 12.2, in relation to subsequent weeks, one sees similar promised increases, a 26-fold or 2,600% increase in relation to the period between 20 March and 25 March 2022. And so it is an extraordinary increase in the rate of installation which is being projected or promised, and one has absolutely no explanation on the affidavit whatsoever as to how this extraordinary increase is to be achieved. All that is said is that Centec has increased the number of installers available to 8,000 installers nationally, but that explanation falls down when one looks at the provincial breakdowns, which we put into 12.3, because what you see is when you look at the Minister's breakdowns of promised daily installations by province, what you see, for example, if you look at, let's look at the two of the most populous and geographically large provinces, the Eastern Cape and KZN. In the Eastern Cape, her projections entail 8,635 installations per day. That's page 029-8, paragraph 12.3.6. In KZN, 8,011 installations per day. So even if you assume that every single one of the 8,000 Centec installers could every day install one set-top box each in the Eastern Cape and KZN, which they could never do because of the geographical constraints and the size of those provinces. Even if they could do that, that would mean that there would be no installations happening in any other province throughout the country. And so the practicalities have simply not been taken seriously. They have not been engaged with, and in fact what it looks like has happened is that somebody on the minister's team has sat with the numbers that remain to be carved up and said, how many do we have to put into each week that there is left between today and the end of the month? And they have carved up those numbers in such a way that produces these projections, which, to use Justice Msimang's words, are an utter thumbsuck and utterly incompatible with the historical rates of installation that have been achieved. And frankly, absent a confirmatory affidavit from Father Christmas, these rates simply cannot be achieved without some form of magical ability to fly across the land and install multiple set-top boxes in houses throughout the land. And so on the Plascon...
Sorry, Mr. Ferreira, just a question on that occurs to me with respect to relief. Just to, and again, just to get your reaction to an order that made the numbers and the provinces that you set out in your 12.3. An order that said install this many boxes in this province by this date. What's your reaction to that formulation of an order?
Lady, I would be concerned about it because the court must be anxious not to give an order which cannot be complied with. And if the court says install 3,100 in Free State every day between now and the end of the month, it may be that that order is breached due to no fault of the minister, but because of practical constraints on their ability to install at those rates. And what the court doesn't have is a realistic, fact-based assessment of what kinds of rates of installation are possible. One has only this thumbsuck affidavit from the Deputy Director General. And so the court must be cautious of not giving an order which is a brutal fulmen, in other words, shouting into the wind, but there can be no assurance that that order is capable of being satisfied. Justices, so the numbers are incredible. They are incredible in the sense that they're not capable of being credited or believed on their face. And moreover, what we also put up in our supplementary affidavit is that because the minister relies entirely on Centec to conduct these installations, we attach at page 029-25, Centec's report to the Department of Communications in relation to what it has achieved in the second quarter of, this was in the second quarter leading up until, this is a February 22 report, so it would have been the second quarter of this year. And what one sees from Centec's own report, when one compares its target for set-top box installations to those achieved, is that you can see its quarter 2 target was 480,000 installed. I'll just direct the court to the page. It's one of these pages which is portrait, so one tilts one's head. I apologize. It is possible to rotate a page on case lines. But what you see is that their target was 480,000 in the second quarter, and what they achieved was about less than 10% of that target. They achieved 46,993. And so even assuming... Yes.
Could you help me? There's so many acronyms in this case. What is a POD on that slide? So project being delayed by post office downtime, no automated PODs being issued at SAPO issuing them manually. What's a POD? Yeah,
Justice, I don't know, but I would imagine it's... No, I don't want to take a guess, but I don't know. And we say in the affidavit that the explanation of that failure to achieve that, the targeted rates of installation, all relate to difficulties in the South African Post Office. Now, we've got no indication anywhere from the Minister or the Post Office that those difficulties have been, I'm sorry, Milady, it is actually in our affidavit. At paragraph 16.3, you see that POD stands for proof of deliveries.
Yeah, the minister's that affidavit, which of course Mr. Matau will very shortly start addressing us on, I hope. Para 21 of that affidavit, it says, the department's deploying people, district coordinators, allowing installers to go directly to households instead of starting at post offices to collect decoders. I don't know if that relates to what Semtech says it's struggling, I don't know.
Well, I mean, with respect, it illustrates the difficulty when an organ of state comes to court with this kind of inadequate evidence and explanations for its conduct. So our submission in relation to the second category of concern is that this application must be decided on the basis that even in respect of those who registered before 31 October 2021, there are hundreds of thousands that the Minister and Semtech will not be able to install set-top boxes before the end of this month. And so even in respect of those to whom the Minister accepts that there is a promise, that promise will not be fulfilled, and so the determination of the date of switch-off must be unlawful. Milady, I have some submissions in relation to how many set-top boxes are in warehouses, because your ladyship was asking about that, if that would be helpful. What we know from the Minister's answering affidavit, this is at paragraph 262 at page 009-80, she said there were some 800,000 set-top boxes in stock waiting to satisfy existing demand. Since that date, we're told in the supplementary filed last night, there were about 100,000 that have been installed. So that's at paragraph 20 of the supplementary affidavit. So that leaves about 700,000. And we know that there are about 500,000 remaining indigent households who registered before 31 October who still have to be installed out of that stock. That's in the supplementary affidavit at page 027-4, paragraph 8. So that leaves about 200,000 out of the 800,000. And we then know again from the supplementary that there were 260,000 who registered after the 1st of October. So just in respect of set-top box stock on hand to satisfy registered households, there are 60,000 set-top boxes short at the very least. And we've explained in our affidavits the consequences of the global chip shortage, the manufacturing delays, the supply chain problems. And so again, on that issue, one can be clear that there are not enough set-top boxes in stock to satisfy just those who have really already registered.
And when we say already registered, we mean up until the even those who registered after the 31st of October.
Yes, that little calculation I just made included both pre-31 October registrations and the 260,000 we are told who registered out of time.
If these figures are correct, then the set-top boxes that if maybe for everyone who's registered to date, if there should be a set-top box, then we're short of 60,000. Is that what you're saying?
Correct.
Thank you, Mr. Ferreira.
Justices, if I may just briefly take an instruction that Justices, those are our submissions in response to the supplementary evidence.
And Mr. Ferreira, there's something I've been pondering. Maybe you'll be able to help. These set-top boxes, do we know how much each cost?
Justice Msimang, I don't know offhand. The figure I have in my mind is about 3,500 Rand, but I'm not sure whether that is the correct figure on the papers. I'll have a look, and if the court requires that, I can provide the figure later.
Oh yeah, you can maybe later. Even Mr. Motau and the other parties probably would be able to give us that figure. Because when you talk of tangible figures, you are able to project, you are able to do so many things, you understand? Because even the court should know, you cannot just order 1 million set-top boxes when you don't know how much each one costs and how much it entails to procure it. No, but thank you, Mr. Ferreira. Anything else for my sisters?
No, nothing from me.
And
Thank you.
from me to thank the intervening applicants team as well for your.
And thank you as well for I know the pressure has been put to wait until you get the affidavit. That's why I was, uneasy when Mr. Motawi said 4 o'clock. I actually asked, hey, are you sure you deliver at 4? Because I know getting the minister they are busy, and I wonder if he knew where the minister was at the time. But nonetheless, the minister came to the party. We have the affidavits. Everyone has got the affidavits. Thanks, Mr. Ferreira. Mr. Motawi?
Thank you, Justices. Justices, because of the nature of how the case has been presented, it is important that we understand the last exercise through the prism of the facts. And the facts you can only get through the pleadings. So it is important not to interrogate or seek to criticize. And as we will show, ultimately, that the criticism is not only unfair, but it is entirely unjustified on the facts having regard to the policy, the obligations and or commitments that government has made within the ambit of that policy, ETVs and the interveners case, which was entirely premised on obligations outside and even in contradiction with the policy. And we will show that their case was about the many millions, as they put it, without factoring into those many millions the applicability of the policy and the limitations that it imposes vis-a-vis government's commitment. And once that is so, it will also become simpler to understand when we get to it later that the minister's tender was made in the context of the debate that was unfolding between the court and our learned friends, and that tender was had not been indicated as a tender to provide an affidavit. The minister had said to assist in circumstances where the court could say, no, we don't need that tender, or the court could say, yes, we will benefit from the tender. And that discussion progressed from the tender in the form of a report to an affidavit, and Justice Leroux will recall, she's the one that came with 4 o'clock. It wasn't of my own making, because the tender was for the minister to file a report to assist the court if the court was so inclined, after argument but before judgment. So it's quite important to understand that when the court then indicated its preference to receive an affidavit, and even earlier, to even indicate 4 o'clock, within those confines and faced with the practicalities, the minister has done the best she can to put up the information, which was not as part of her plan, that intention, because of the ambit of the case that is pleaded and what the policy regulates. So it's quite important that we've got to go slowly back to the facts to understand aspects such as, does a qualifying household translate into a need and therefore a duty to provide a set-top box in circumstances where that qualifying household that qualifies only as a matter of counting statistics, that has not raised its hand to indicate a need, ought to be used as an indication to somehow criticize the minister's approach on the basis of irrationality. And I'm going to ask the court to bear with me, because you would have seen that if one has regard to the case that's presented both by the interveners and ETV, the interveners simply echo ETV's case, and you'll see from their notice of motion. So they've had plenty of opportunity through a repetition of the sound of voice to redirect the case from the pleadings to what may seem to be appealable under the rubric of some constitutional obligations and a referral of some constitutional rights without engaging the contents. And if I may, because it's going to become important to ultimately, when we get to the constitutional assessment, to understand what is the content of freedom of expression and what does it provide. Just put loosely, and I'm not addressing that topic for now. Does freedom of expression mean you are entitled to a particular type of service, i.e. you have a right to a free-to-air service in circumstances where government is making access to the signal available to all so that all will not be left behind? And in that same statement, which is being misquoted, and I'm going to have to take the court through that statement, that in that very same statement where the minister says, as government, to show that we are a caring government, we have decided to assist financially challenged households, to use the language of the Constitutional Court in the previous round of the litigation between the parties. And against that, may I begin to redirect the court back to the facts, because it is easy for one to fall for the temptation of the seductive propositions that have been thrown and bandied around without reference to the pleaded case. I indicated the topics that I was going to deal with yesterday in light of the submissions that were made. I'm going to confine myself to those topics that require answering, and then I will deal with those that are important for purposes of our case. But we should be understood that we're not abandoning any of the arguments in our heads of argument that we've made. If I may commence with a question that Justice Msimang asked yesterday, and the court will recall I had indicated that part of the topic or topics that I'm going to cover is ETV's obstructive stance to digital migration. That topic is important to cover because, as the court would know, delay is an important aspect to remedy. And it is also important in the context that ETV criticizes government for delay without explaining its own conduct and its contribution to that delay. And we seek to illustrate that this delay to which ETV has consciously contributed is premised on a clear strategy of adopting contradictory stances. Nothing new in this litigation, but something that has also raised its head in the litigation that went all the way to the Constitutional Court, in which both these applicants were involved and they lost. But what they had through that unmeritorious litigation was the benefit of time through which they delayed the rollout of digital migration. And they come before this court washing their hands and pleading innocence as if they did not contribute. And this is important because even if we get to review relief, which we'll address about its incompetence and the court were to be against us, what is just and equitable ought to take delay into account. In other words, from the parties that seek to benefit from what they call a just and equitable remedy, the court would need to factor that delay. But for purposes of the review, we will seek to illustrate why that relief is not only incompetent of the papers before you, but it is also not warranted by the facts. I may then comment by asking the court to, perhaps it's not even necessary to do so. I'll give the reference. The court is aware that ETV in its founding affidavit laments government's delay in completing the digital migration process. It says that the minister's predecessors have dithered and delayed. That reference the court will find in ETV's founding affidavit at pages 001 to 10 to 11. That's at paragraph 3. As I indicated, it's not necessary for the court to go there. Then, as I indicated, ETV does not account for its own contribution to the delay. And in this regard, it is important for the court to appreciate that the litigation that occurred between the parties lasted between the years 2015 and 2017. And in that, during that period, we submit, ETV impeded the digital migration process by seeking to challenge the minister's 2015 amendment to the BDM policy. And the court will recall the issue there was to encrypt or not to encrypt. And ultimately,
no, go on, Mr. Mutawi. For some minutes, I thought maybe we've lost you. You can go.
I'm here, Justice. And as I indicated, we know that the court, per the majority decision, found in favor of the minister. In other words, it dismissed the arguments of unlawfulness and or any procedural unfairness that had been launched. And in reaching the conclusion, it is important to note that the Constitutional Court was critical of ETV's motives. It noted in particular ETV's changing stance of the BDM policy. In the following respect, it noted that ETV had at first submitted strenuously that STBs should not be fitted with encryption capability, and later submitted that the policy should provide for STBs to have encryption capability. It was on this latter basis that ETV challenged inter alia the rationality of the policy. And in this regard, the majority in the Constitutional Court had the following to say in paragraph 45 of the judgment. We are now virtually grappling with ETV's own battle of ideas. Its position is particularly striking in that it has been able to articulate quite forcefully at times, or quite forcefully at times persuasively, two diametrically opposed viewpoints. Initially, against the inclusion of decryption capabilities in set-top boxes in order to save, this is the argument that they advance, the taxpayers' money and avoid enriching individual entities at government's expense. And coupled with that, to promote competition, but later to change in favor of the inclusion of decryption capabilities in government-supplied set-top boxes. The latter, the court continues, is now said to be done for the promotion of competition and the advancement of the best interests of the public by ensuring that there is fairness and diversity of views, broadly representing South African society. So if I can pause, I'm going to continue with the next paragraph, but if I can pause, it is important for the court to note that the two positions that ETV had advanced. On the one basis, its initial stance was it was adopting that stance for purposes of saving the taxpayers' money and not allowing individual broadcasters to ride on government's infrastructure for their own commercial benefits. And during that process, it changed and adopted an entirely different stance, which is diametrically opposed to that.
Just to ask a question on that, I also seem to remember that your clients also had a different view. Your clients also moved from encryption to no encryption. So are you saying that in this whole process, your clients were always of one mind, and it was only ETV that had a problem with either encryption or no encryption? Because I seem to remember that your clients also couldn't make up their minds for some time as to encrypt or not to encrypt.
Justice Lukaman, it is important for the parameters of the submission to deal with what was before the court, not what.
Yes, but we are dealing with a delay. So if we are to consider a delay on something that happened in 2015 or whatever, the delay still has an impact today. So if we are to attribute certain aspects of the delay to the applicants, I was just asking to say, didn't they also ride on some sort of lack of decision making from your own clients?
No, Justice Lukaman, for purposes of the submission we are making, perhaps there are 2 points. The first is, government does not state that there was no delay on its part. So it's not government's case that no delays are occasioned, but on account of its conduct. But for purposes of this issue that we are raising, we submit it is important to stay within the confines of the pleading and the issue that the court was dealing with, which issue would not, having regard to the judgment, answer Justice Lukaiman's question. So what perhaps, many of us have been involved in that litigation on different sides and for different entities. And we know that even in the state capture inquiry, that issue arose. The SABC multi-choice encryption or not, or to encrypt or not to encrypt. But that's a wider issue beyond the submission that we are making. And the point to which we will point or direct the court with reference to the facts before it will go directly to the issue that Justice Nsimang had raised, because ETV attempted to provide an answer but didn't give a full reference of the papers in which it indicates, or which papers indicate that they indeed adopted a position contrary to the one that they are adopting now in these proceedings. And if I may then proceed, the court continued in paragraph 55 by stating the following: ETV would want to be able to harvest more profit in the same way it accused others of seeking to do in its representations to the Minister Matsipe Kasaburi policy proposals. This it seeks to achieve by having decryption capabilities incorporated into the government-supplied STBs designed to benefit financially challenged households. This is the same government subsidization of profits of a single conditional access provider. It complained in its comments on the minister's policy proposal. It has in effect branded the position it previously embraced and fought for as irrational. What it considers to be irrational now is what it previously said was unconstitutional and presumably irrational. And we make the following submission that the court noted presciently that unlike other broadcasters who had commercial interest in government's policy, ETV's actions threaten to stall unduly the full-scale rolling out of the STBs for which the nation has been waiting for about 10 years. And that the court expresses in paragraph 57 of the judgment. And did ETV learn anything from the criticism that was expressed by the court in its judgment? We submit no, because we submit ETVs damaging temporizing is again raising its head in this litigation. And the court will recall in Telkom's challenge to the 2020 Spectrum ITA, Telkom had asked the court, among other things, to require the minister to complete the digital migration by no later than 30 June 2021. And this the court will find in the papers. ETV's notice of motion, the court will find at P006-76, in which paragraph 1 deals with the intervention, and at page 006-76, therein the substantive relief is set out. And what is important for the court to note is that in its intervention, ETV intervened as an applicant, and it requested the court to admit its founding affidavit to use the words that are used in that notice of motion in support of the relief sought in Part C of Telkom's notice of motion dated the 22nd of December 2020, which included the prayer to expedite the digital migration, i.e., for the minister to complete the process by no later than 30 June 2021. And yesterday, the court had submissions from our learned friend to say, but well, the minister knows that ETV has always been consistent because it referred to certain deficiencies in the process that needed to be accommodated. But our learned friend, in his referral to the papers, never pointed the court to any qualification that ETV's support of the relief that was sought in Part C of Telkom's notice of motion, which included expediting and finalizing and or completing the digital migration process by no later than 30 June 2021, was qualified. There was no qualification impacting on that relief, and thus the words, it must be admitted as an applicant in support of the relief sought by Telkom, being the operative words. That's an important consideration. So, to the submission that somewhat the minister has accepted ETV's consistency as the submission was made in response to Justice Nsimang's question, may we indicate to the court why that submission was incorrect? If you can just ask the court to go to the minister's answering affidavit. At page 009, -10. The lead to that paragraph, sorry, the lead to that topic is at paragraph 24 at page 009-10, wherein the deponent says, before I proceed to deal with the regulatory framework, it is important that ETV's approbation and reprobation regarding the BDM process should be noted, since it is relevant to the ambitious relief that it seeks. And then on page 25, so paragraph 25, in the previous spectrum auction litigation that had been brought by Telkom, and in which ETV intervened as an applicant, Telkom's argument was that the conclusion of the BDM process needed to be expedited and brought forward to be concluded by 30 June 2021. And ETV associated itself with that position. And we now know that ETV has since adopted a position which is yet again diametrically opposed to that position that it had adopted, in that it now seeks an order that the process of digital migration cannot be completed and ought not be to be allowed to proceed until what it terms preconditions have been complied with. And the question then is not whether government had taken a view which changed by way of whether to encrypt or not to encrypt, but whether with reference to ETV's own conduct, where we are dealing with an important scarce resource, and everyone agrees the spectrum needs to be freed up, having regard to the economic benefits read with the country's international obligations, to now take a position that seeks to hold to ransom the process of finalization. And we will illustrate that there is nothing that had happened in the telecom litigation that is not present. In other words, there's no change of circumstances between its support in its intervention in the telecom litigation, that the process be finalized by no later than 30 June 2021, and the current circumstances. And it is thus important, we submit, that the litigation should be viewed from the prism of that conduct by ETV. So in other words, in the previous telecom litigation, what is it that has happened, if anything, that has changed to justify ETV's departure from its initial stance to now? And the court will recall, the minister sets out in the answering affidavit that in respect of that telecom litigation, she even provided a letter of support of settlement of the dispute between the parties, taking into account that the parties had adopted a stance that expedition was warranted than delay. And when that settlement was reached, ETV then filed its new notice of motion, now saying that expedition on the basis of which the minister initially supported the settlement or had supported the settlement is actually a breach of some or other rights. And we ask the court, how on the pleaded facts can that constitute a justification to finding a case dressed up as constitutional breaches, which were not present in the telecom litigation but are now seem to be present on account of this expedition which ETV supported?
Mr. Patel, speaking for myself,
yes,
I have a horrible echo.
Yes, I can hear it.
Speaking for myself, I can understand your client's evident frustration with the history of how we got here. And certainly the court is well aware from all of the papers of how ETV has conducted itself and the opportunities it's taken, and the benefits it might receive from the delay, etc., etc. But speaking for myself, the difficulties and where I would appreciate your assistance is with respect to the intervening applicant's case. Because, the relief that is being sought by both sets of applicants is the same. And, whatever criticism and whatever inconsistencies and whatever opportunism we may see or we may sense in the ETV case, we still have Mr. Ferreira's clients before us who don't, as far as I'm aware, suffer from that same history. And obviously I'm aware that the current minister is not her predecessors. All of the history to where we are today is unfortunate, to put it mildly. But, certainly I would appreciate your assistance, because the notice of motion that we face in the intervening applicant's case, focusing as it does on where we are with 31 October and the 3 weeks notice period on that, and on the shut-off date on 31 March, those are the things that are particularly preoccupying me at the moment. So I hear you in terms of how ETV got us here, but we do have the other case which doesn't suffer that baggage and that history. So obviously I don't want to constrain you in how you address us, what topics you feel compelled to argue, but I would certainly appreciate assistance on, the MMA SOS notice of motion and where we are now, and how this court can assist all parties in their arguments and their positions on that case as well.
Yes. My lady, the first observation that the court needs to make is that both the intervening parties were party to that litigation. So the defects to which we refer equally apply.
So just
yes, and I will deal with the intervener's case, because in our submission, that's a simpler case to deal with.
Sorry, can I just understand, because I may well have just missed it. The intervening applicant's participation in the Telkom litigation, was their stance the same stance as Telkom and ETV? Is that the submission?
No. We started with the Constitutional Court litigation and the delay. The intervening parties were party to that litigation. That's the point. In this,
what was their position in that litigation? On the delay or on encryption? I mean, did they have a substantive stance there?
Yes, perhaps let me just take one step back. In the SCA judgment of that same matter, the court will see that there were two SOS fractions or factions, as it were. Mr. du Plessis was acting for the one which was pursuing ETV's case and or arguing a case consistent with ETV, and I appeared in the SCA litigation for the other SOS entity, which had adopted a position in favor of the minister. In other words, or consistent with the minister based on the interpretation of the policy and the regulatory instruments. Then when the matter went up to the Constitutional Court, our faction of the SOS, for lack of a better description, did not participate in that litigation. And it was the one component which has again intervened in these proceedings, and coincidentally their position also accords with that of ETV as it did in the previous litigation. And I should indicate that in respect of these proceedings, the applicants were not, also the interveners had not intervened in the Telkom application. At the outset, they intervened in this litigation after the new notice of motion was filed. In other words, after ETV had changed its stance from expediting to no, slow down, to almost it can't happen. But Justice Leroux, I'll indicate once we've navigated the facts, why MMA's case is the simplest case to deal with, because you will see.
I'm relieved to hear there's something simple.
Well, in fact, the case itself is ultimately simple, and perhaps let me illustrate why. Just with these broad submissions, one needs to navigate the following aspects to determine the case. One needs to navigate what is the legislative scheme.
Legislative framework.
The legislative scheme, yes, or the legislative framework. How is it that policies get to be promulgated or published by the minister? Where do regulations sit in that scheme? The fourth point that the court would need to deal with is what undertakings or commitments were made by government, and in which of the policy iterations, given the amendments of the policies, does that commitment sit? Do the legislative instruments, this is the fifth topic, do the legislative instruments impose a duty to consult? And if so, which ones or which iteration of these policies create that obligation? Allied to that is, did that obligation remain the same? Or was there a change in respect of the consultation requirement? And for this purpose, the court will understand the process started in the context where there was a duty to consult, and midstream that requirement was removed.
And Mr. Matao, I'm sorry, when you say midstream that duty was removed, are you implying that because the objectives of that duty were met?
Justice Nsima, I'm not going that far for purposes of this formulation of my suggestion of how to navigate the issues. All I'm pointing out is there was a 2012 policy that required that the minister should consult with cabinet and broadcasters. And that requirement to consult with broadcasters for purposes of determining the ASO was removed in the 2015 policy. But all of that was midstream because the process precedes that amendment. So there had been engagements and consultations that were unfolding under the auspices of the previous iterations of the policy. But fortunately for the court, is that even if the court comes to a finding, as we will seek to illustrate, that once the policy was amended, there was no duty to consult with the broadcasters for purposes of the ASO. As a matter of statutory interpretation, that position, despite at the level of fact, there was consultation, so there were consultations. We will take the court through those. But in all of this, sight should not be lost of what commitments did the government undertake, because it is against that principle, or it is against that understanding that one would assess the KZN principle, what it provides for, and whether ETV is correct in its interpretation that those commitments, when applied to the KZN principle, yields a commitment larger and wider beyond that which government had stipulated. And once that factual matrix is understood together with the legislative framework, then the next question will be, what rights, if any, are being violated. Because you can only, we submit, violate, as we will show, rights in respect of a defined right that guarantees a specific medium of expression. I.e., if the court finds that there is a right to receive these services only through the FTA, so i.e., if the court finds that freedom of expression includes being guaranteed that you are going to receive news through the Business Day or the Mail and Guardian, and that absent government banning content that newspapers such as the one that we've listed should publish, the mere fact that people should pay for those services constitutes an infringement of freedom of expression.
Mr. Mutau,
yes.
Mr. Mutau, so now that you mentioned this, which you add, freedom of expression, I've restrained myself not to ask that question, but maybe one should. If government promises or undertakes to provide the population with free broadcasting, and it does so, would you say, if it has got a public broadcaster like SABC, then it fulfills that obligation? The question is, can it be extended to private broadcasters like ETV? I'm just mentioning it that so that when you answer, you must because when I see going through these papers, ETV says you must provide our viewers with this and this and this, and let's say, because if government provides that and provides that through the public broadcaster, that I understand, but ETV is a private broadcaster. I'm just mentioning it. I'm just throwing it in the mix as you are addressing this point. Maybe you can have a word or two about that.
And Mr. just related to my brother's question, if I can get your submission on this, does your client accept that free-to-air pre-digital migration is equivalent to free set-top box post-migration in the for a qualifying indigent household?
Is for qualifying, i.e., those that sit within the remit of the policy. I wouldn't quibble with that proposition.
Okay, so not so much ETV versus SABC, but free to air versus free set-top box. If you're the qualified, you would accept that could be a legitimate framing of the constitutional rights, freedom of expression argument.
Yes, in fact, I think Justice Leroux, the proposition that you put in is not in any manner different from what Justice Nsimang is putting to be. It's simply the difference is that he put the labels in terms of the broadcasters, but underlying that is the following. Government has an obligation to provide a signal. You would have seen from the papers, there is no general obligation for government to provide a device through which that signal is accessed. Because that is important to understand as a point of departure.
But what happens when government interferes with an existing mode of how I was receiving certain things? Because what is at stake here, at least for the for the households that will be left out is the fact that things used to be normal for us without us having to do anything. Now that you have interfered with that by requiring certain things, we still need to be able to get what we were getting.
Well, thank you, Justice Kukaman, for that question. Let me leave out what I was going to address and focus on the proposition that you put into me. In practical terms, when, let's say, pre-digital migration, in respect of ETV's situation of free-to-air, let me use the free-to-air. In relation to that, government would provide a signal, and from that signal, service providers or broadcasters would connect to that signal and provide it to its target or its audience. What then government does is it changes the mode of the signal in accordance with international obligations. It says analog, for the reasons that have been pleaded, which are uncontroversial, has been overtaken by technology, and as a global player, we need to play at the level and or using digital. And let's then take it from there. What then happens? Government provides the signal like it did in the analog. So it provides a signal, and as a consequence of that, a change has to happen. What change needs to happen? You need to have devices that are compatible. And those devices should be borne in mind. It is not only the STBs. You have TVs, you have all sorts of other methods through which that signal can be accessed. So the decision to convert from from analog to digital must be understood in that context. There can't be a challenge that is on them. It's the consequences. And for one to look at the consequences, and the consequence is this. Because even in the analog era, government's obligation was to provide you with a signal, not with a device through which you would gain access to that signal. That same framework cuts across to digital. So in the digital era, government's obligation still remains, which has been the same obligation even in the pre-apartheid era.
Yes, Mr. Motau, we know that. But now, yeah, Mr. Motau, let me know that when the ministers informed the public that there's going to be digital migration, now there's going to be a more efficient transmitting system or that thing, media. Government then said they are qualifying members of society, a community that earns about a certain limit, and government made an undertaking to provide these STB, the decoders, to those people that qualify. That's where government's obligation starts. So the question is, who are the people who were promised? Was government promised? Are we able to make out from the promise of government and establish exactly who are the members of society who have been promised these STBs? And are we holding government liable, or are we holding government to its promise? Are we saying government will make a promise?
Where has Mr. Motau gone to?
Yes,
Mr. Motau, are you still there?
We seem to have he has left.
I don't see him on my screen, but
Well, you are not in the meeting now.
Even the icon, yeah, the another looking at the icons is not there. Technology is failing. Let's see, very. Gusani Dada comes. Oh, Mr. Mutau.
Yes, I apologize. I lost connection. That is being sorted. Justice.
Oh, okay.
I apologize. I didn't hear.
And you've renamed yourself.
Yes.
Are you able to proceed? Are you able, or do you need some time to connect?
No, Justice Msimang, I can proceed on this one, and then once that is sorted, I'll reconnect. We can proceed.
Okay. My question to you, Mr. Mutau, is that yes, we understand government should provide a signal. There was a change to digital to a new signal, and government itself made that undertaking, made that promise. So we should first look at the promise. Secondly, who are the people who have been promised? Third, whether should we say to government, make good your promise, or should we say to the people, to you, to say promises like pie trust are made to be broken? Should we permit you to break that promise, Mr. That's the issue that I've said from day one. That's the issue.
Yes, no.
Are you able to address on that?
Well, may I just raise just one issue? I understand that the discussion now happens in the context where the court has had submissions by those that have argued before me. And in the course of that debate and engagement, there are issues that occupy the court's mind. And that's what has been happening thus far. Justices have been expressing those concerns. There's just one logistical issue that I'd like us to perhaps keep in mind so that we can have a meaningful way through which we can navigate these issues. Let me give an example. When Justice Leroux asks a question that is of concern to her, and I'm unpacking it, Justice Lukaimane comes in, picking up from a particular point. And when I'm addressing her concern, before I am even done addressing Justice Leroux's question and even Justice Lukaimane's question, Justice Msimang comes in from, and I'm not saying
the nature of the beast.
Yes, I'm not saying there's anything wrong, but all I'm simply saying is I do not want a situation where concerns that were raised when judges go back to consider the matter find no answers. In other words, let's just illustrate. If Justice Msimang has asked me a question, which in the process or in the course of trying to respond to, Justice Leroux asks me something different. For purposes of Justice Msimang, when he goes back, he doesn't have an answer in his notes for the proposition that he had put. So might I suggest the following, and subject to the leave, to the court's leave. With the benefit of the debate, one is aware of the concerns that have been raised and where those arise. And that is why I had indicated that perhaps let me leave out the other issues. What is going to be important here is what is the regulatory framework? What were the promises? Were those promises made? And could government make those promises only to the limited number that it did, having regard to the regulatory instruments? And did government, or is government going to keep its promise? I accept that. And the issue is ultimately that simple. But there are a number of distortions at the level of facts which have been thrown in over the day, yesterday and this morning, which requires that clarification be provided on why, for example, because ultimately, as I indicated, you're going to have to look at the KZN principle. Say, how does it apply? Does the principle apply inflexibly? Can it apply even before the rights have vested and so forth? That That ultimately is where the issue is going to turn. And
I think that the issues that you indicated to say, what did government promise, what is the regulatory framework and all that, you just need to fit all our questions in there. I think our consternation is coming from the fact that you seem to be addressing all these other things independent of the case that even at the beginning you said, this is how I want to argue my case. So if you go back and just take your case step by step, I can assure you that the way that you put it in the beginning, all these issues would arise and then we will pick them in there. I think we are getting into this issue because we are being led by you. And instead of sticking to what you said you would do, you are now sort of wanting to answer those things outside of the issues that you say we should concentrate on. So just double back and then proceed in that manner.
Thank you, Justice Likamana. Perhaps let me then deal with the process, the digital migration process. We know that process commenced in September of 2018, oh sorry, 2008, I apologize, through the publication of the policy that was published by the then minister. And this is annexure PR4 in the papers. It's at page 021-234 and in paragraph 24. Sorry, it's P. I apologize. It's P001-255. That's PR to the paper.
Is the case is 021?
No, it's P001.
Yeah, but on page slides,
yes, it's page 001. So what I'm saying, when I say P, I mean page 001.
Okay.
Dash 255.
001-255.
It's annexure PR24 to ETV's founding affidavit.
That's fine.
Yeah.
You can proceed.
Then, that being the policy, the legislative framework within which that policy operates is firstly the Broadcasting Act of 1998, the Electronic Communications Act, i.e. the ECA, and the ICASA Act. In terms of Section 3.1 of the Electronic Communications Act, the minister may make policies on matters of national policy applicable to the ICT sector, consistent with the objects of the Act, and other related legislation. We've got this in our heads of argument at paragraph 19, if just for purposes of the note. And under chapter 2 of the Broadcasting Act, the following is stated. The minister is responsible for the achievement of the constitutional mandate of broadcasting policy development. Being empowered to act on behalf of the nation, the minister has the ultimate responsibility to fulfill certain obligations relating to use, protection, and access to broadcasting resources.
Is that on your side?
And fortunately not on mine, my lady. And then in terms In terms of Section 3(2) of the Broadcasting Act, the minister is ultimately responsible to develop policy that is required from time to time. And pursuant to her powers in terms of Section 3(1) of the ECA, the minister made the BDM policy. And it is that policy that provides for the switching off of analog transmission. This we deal with, if the court can make a note, it's in our heads at paragraph 21. And the policy sets out the relevant context to the publication of that policy, which is the South African commitments under the ITU Treaty to migrate from analog to digital broadcasting services by 2015. That obligation is in Annex PR 24 in the 2008 policy. So that the need to convert is an international obligation that binds South Africa. So there's no choice on whether to migrate from analog or not. And then the next policy is perhaps before I deal with the amendment, one will note that in terms of that policy, that 2008 policy, the obligation to migrate is carried across to the various amendments that followed. And there were 3 amendments to that policy. The first amendment was the amendment that was published on the 7th of February 2012. And that the court will find in Annex PR 25 to the founding affidavit at pages 001-274. The second amendment was published 10 days later, being the 17th of February 2012. And that amendment, it substituted all the paragraphs or all the paragraph amendments that were introduced by that first amendment, so that we understand the lay of the land. You have the amendments that come in on the 7th of February, 10 days later, all of those amendments are substituted. Then you have the third and final amendment that was published on the 18th of March 2015. That's Annex PR 25. Oh, sorry. That's Annex PR 27. I apologize. Page 001-305. And under this policy, I'm going to deal with 2 topics. I'm first going to deal with the duty to consult, and then I'm going to deal with the public promise that was made. The court will note that the original ASO date had been fixed as 1 November 2011. And that is in terms of paragraph 3.3.1 of the original iteration of the BDM policy, i.e. the 2008 policy. The court will see that in terms of paragraph 1.1.11 of that policy, it drew inputs which had been received from the public and other stakeholders through a public participation process. And you will also then see that the original date was fixed following a process of public consultations, because that is what the policy provided for. And the minister in the answering affidavit at page 009-11, paragraphs 27 to 29, states that following consultations, that date had to be moved because the consultations revealed that that date was not achievable. There's no dispute about that because none of the parties in their replying affidavit dispute that that movement of the date was a product of consultation, and as the minister states in those paragraphs 27 to 29, it actually illustrates that consultation was approached with an open mind, not simply going through the motions to ensure that ASO is set by any means necessary and or without due regard to the practicalities. And the court will note in paragraph 8.1 of that original policy, provision is made for the establishment of the digital Dzonga, which was to be comprised of representatives from the public, government, industry, organized labor, and consumer groups. And key among its function was education, awareness, liaison with relevant stakeholders, including ICASA, STB manufacturers, for purposes of monitoring the implementation and providing regular reports to the Minister of Communications. Then paragraph 12 of that policy, the next legislative instrument to plug into that legislative framework is the amendment policy. And paragraph 12 of that amendment policy specifically did away with the original fixed date for ASO. And it introduced instead a provision that stated the date for the final switch off of the analog signal will be announced by the Minister of Communications after engaging with Cabinet and other relevant stakeholders and assessing the extent of the take-up by audiences of the necessary equipment to facilitate universal access to broadcasting services. So therein, one finds the duty to consult with the relevant stakeholders. And the second amendment to which I've referred, paragraph 12 thereof, reads exactly the same. And we make the submission that since the Dzonga, or the digital Dzonga, was the body through which stakeholder engagements were to be undertaken, any consultation undertaken with stakeholders were as mandated by that policy at the time. In paragraph 6 of the third and the final amendment to the BDM policy, it is stated that the date for final switch off of the analog signal will be announced by the minister in consultation with Cabinet. And what the court will observe is that that final amendment did away with the requirement to consult with other relevant stakeholders, thus requiring the minister to only consult with Cabinet for purposes of announcing the date. And it's important to understand that the announcement of the ASO is the final step of the digital migration. And it is understandable why in the legislative scheme, the requirement to consult is only stated in relation to Cabinet for purposes of the minister. And now we get to the question of the public promises. And it is important to deal with the issue based on the premise.
Sorry, Mr. Matau, before you move on to the the public promises. I don't know if you want to address it now or if it's coming up, but if you could just please deal with the submissions by the respective applicants, that as I understand it, the consultation case also relates to, in this litigation, the answering affidavit saying no date yet, and then only on 28 February, the Gazette with the letter, where it's now finally ASO determined, and there were submissions made about the reasonableness and rationality of announcing the cutoff 28 Feb for 31 March. If you could also just address us on the consultation angle of that decision, that announcement.
Yes. It is important in that context to appreciate that the complaint, insofar as it relates to the determination of the ASO, has to be understood from the prism of paragraph 6 of the final, i.e. the third and final amendment to the BDM policy. In other words, the starting point is whether in announcing the ASO, was the minister required to consult with the relevant stakeholders other than consulting with Parliament? If the answer is no, as we submit on the plain interpretation of that amendment, then there can't be a case premised on that lack of consultation. But as I indicated, and I'll deal with consultation. So for our purposes, it is important for purposes of the interpretation of the legislative scheme that a court pronounces whether in the face of or having regard to the third and final amendment to the BDM policy, the duty to consult somehow can still be founded in this instrument. And the court saw, these are the reasons that why we say the judgments of Justice Bakwa and Justice Sutherland clearly misstate the position and are obiter, because that's not what the court was dealing with. The court was not dealing with ASO. The court was not dealing with the minister's duties to consult. So it is this judicial enthusiasm that the courts often warn us about, that when pronouncing on matters, do not go beyond simply what the matter poses by way of questions and answer only that, because you go into the terrain where you've had no benefit of the submissions, because none of the parties were alive to that as an issue. So simply just on this, it's not even necessary then to address those judgments, because the policy simply, to the extent that Justice Sutherland, with respect, refers to the 2015, and it's clearly an error, because the duty to consult went with the 2012, and it was done away or jettisoned on account of the third and final amendment. So just to conclude on that point, simply on the basis of the statutory framework, no duty to consult anyone else than the minister in determining the ASO is a requirement that is imposed by the legislative scheme.
And
Mr.
Yes.
I see my sister also wants to come, but what you basically saying is that the minister has actually been required to announce only, not, what you're saying is that all that was to say announce, nothing else, and because all the other consultations and things should have been done prior to that, but what's important is that all that she was doing was to announce.
Correct, Justice Msima. That's what the legislation requires, and it's important to understand it, because there is a complaint that on some or other basis there was an inbuilt duty having regard to the legislative scheme that created an injunction on the part of the minister to consult relevant stakeholders prior to announcing the ASO. But that is plainly wrong. And again, I distinguish this part, that the court, fortunately for purposes of this, in other words, after the court pronounces on this interpretation, which is plain and simple, it will fortunately, when I deal with the consultations, also see that in any event, there was consultation, and I'll deal with that issue comprehensively. Yes, if I may.
Sorry, Mr. Patel, the question I had was just, so this argument is the answer to their prayer 2 about declaratives about consultation before ASO.
Correct.
You would then have to still separately, the court would then separately consider 28 Feb to 31 March and its reasonableness and rationality. So this argument addresses the prayer 2 argument, and it has some role in whether 1 month's notice is sufficient, given everyone's been consulted since Digital Zonga. But there may be a residual reasonableness rationality assessment of that 1 month as well, separate from consultation.
Sorry, Justice, I'm going to try and migrate digitally from this device to the next one.
From my side, I prefer, I can hear you more clearly and see more of you on this device, but... Okay. But migrate if you need to migrate.
Okay. Then that's fine, I'll proceed using this device. Yes, Justice, I am going to deal with the consultation. And perhaps by way of this next topic that I'm going to address, the court will understand that it is a distortion of the process that had been undertaken from as early as 6 years ago to simply look at the window that somehow the last call for final registrations impedes some rights and or some consultation. And perhaps let me begin by...
So just so I'm following you.
Yes.
So if the court were with you on the consultation argument, the court would then still have to think about the registered people and installation likelihood and all of those issues. That would be then where we would then go.
What's the promise? What does government say on the papers? Will government be able to keep its promise? I'll show you when we deal with the KZN principle. Contrary to what my learned friend said was a concession, what I simply made is a submission consistent with the pleadings, because the minister deals with the pleadings, and she says, I am going to keep that commitment that I've made, even through this affidavit that was filed. But we'll deal with that.
I think I just don't need you to drop the initial question from my sister, that even if we agree with you on the issue of consultation, the decision itself must still be subjected to reasonableness. And I don't need you to leave out something that is important because you think it's covered by something else. So I just need you, even as you sort of explain it to yourself what we mean, that the decision still doesn't escape reasonableness.
Yes, I'll deal with that to the extent that it is an issue that perhaps should still occupy the court. And let me start by referring to the media statement of the 5th of October of 2012, because both applicants rely on it to find a basis for what was promised. And from it, they seek to say, well, even the reasonableness of the date is an issue. So that statement, if I can use annexure PR 17 at 001-214. Oh. The court will see that in terms of the statement, it was not a first-time call for registrations. It was, in fact, a final call for registrations in a process that had been opened for 6 years. We deal with this in our heads of argument just so that the court can navigate it easily, and for purposes of note-taking. It's in our heads of argument at paras 12. So at para 12, together with para 203.3.
And Mr. Mchas, just again, so I'm clear, 5 October must also be in the context of the SONA announcement.
Yes, no, I'm going to deal. Okay. I'm going to deal with consultations separately. I'm starting with the statement and its import. Perhaps let me raise this issue, because the public promise, as per what was put up, I've dealt with the policies to the extent that some or other promise was located, either for purpose of consultation or these rights that are sought to be ventilated. I've illustrated that no such is found in the policy. And the next category is that there are promises that were made for purposes of holding government to that promise and or commitment. I'm going to deal with consultations separately, i.e. commencing prior to the SONA, then the SONA and so forth. I'm going to in detail deal with that. So the court will see that in terms of this statement, the minister makes it clear that the registration process has been opened since 2015, and that the court will find in paragraph 2.1 of the statement. And not only that, what that paragraph gives us, it gives us government's undertaking. The undertaking by government is to assist beneficiary households, in the language of the Constitutional Court, financially challenged households, earning a total salary of less than 3,500 rands per month, with installation of set boxes to ensure universal migration. The process of registering beneficiary households to be supported commenced in 2015, and to date, 1.184 qualifying households have been registered out of the estimate of 3.75 million qualifying households in terms of Stats SA's data. So there is the promise. Register if you are below 3.5, and you will be assisted by government. What will be implicit from this? There is no promise that says whether you have registered or not, so long as the 2018 SA Stats data reflects you or indicates that you are a qualifying household, government has a duty to come and deliver a set of box at your house. That is
not out of that paragraph. I mean, if you closely read that paragraph, it doesn't say what you say it says either. Just the literal meaning of what I'm looking at there just says we are within a process of registering beneficiary households, still keeps the 3.75 million qualifying households. This is just talking to process. At this point, there is nothing that says you've got to register to get a set-top box. from that paragraph, if you just read it.
Well, if I go to the second sentence, the process of registering beneficiaries' households to be supported commenced in 2015.
Yes.
And that process of registration, we know what that means.
No, we can't read it in there. I mean, now we are all sort of, we've got we are trying to find this area where a big number has now suddenly been curtailed to a smaller number, which is fine. It might be there somewhere. I just don't want us to read it into where it is not. That just says we are following some sort of process to register these 3.75 million households. Where we are at now, we have registered 1.184. It doesn't as yet set a condition for you to get a set-top box, to register to be able to get a set-top box.
Well,
it might well be that I agree with you that the language changes somewhere in between. It just doesn't change there. There it's something completely different. So it might be that during the lunch break or whatever, you are able to sort of take us through where that comes in, because certainly at the end it is there. We just can't locate where it happened.
Okay, might I perhaps just tie in this, because I thought, and I must thank you, Justice Lukamanda, for pointing this to me, because I thought this was an uncontroversial part of the case, that these registrations, the call for registrations to qualify for the set of boxes is not an issue. I thought...
Mr. Natao?
Yes.
Thank you. I see it's now the lunch hour.
Yes.
Maybe you'll also take time to put your thoughts together so that you should be able to answer that question of my sister. But as far as I'm concerned, I would have preferred that if you address the issue of the promise, it's easier if we say the promise, the first promise, 2008, said this. So we should be able to know what the promise is and when the promise was made. And then that would be our point of departure. Because you see, each time there is a notice, there is this promise of 375. Are you able to say when the promise was first made? The promise was made on this, that was the first time, then shouldn't we use that as a point of departure? Can we go for lunch? You can answer that after lunch.
Yes, Justice Msimang, just to leave one thing that I should mention. The reference, if the court wants to have a look at it, I'll start with it. Paragraph 4.5.2 of that annexure at 001-218. And I must apologize. I see the error in my presentation because I'm assuming that there are issues that are not controversial, and therefore it's easy, with the benefit of the court having read the papers and the heads, to see.
Well, the other party keeps referring to the 3.75 million. That is why it's important for you, when you want us to concentrate on the curtailed number, to actually show us where exactly does it start, this curtailed number. So it is relevant because they are talking about a bigger number and you want us to focus on a smaller number.
Yes, paragraph 4.5.2. Can I just leave the court with that? And then what I'll do is I'll elevate the other points and plug them out from the heads into the presentation of the promise, because I understood that this is the case and this is the promise. But I'll trace it back.
Thanks, Mr. Mutau. Please, it will help, because the thing is, I think we're vacillating from point to point. And if we talk the promise, I would prefer to say the promise. Then the promise was made on this day. This is the promise, because I suppose the same promise keeps on meandering down as the years go past. You understand? Yeah. So let's say the promise started on this day. This is the promise, and we should all be adhered and say, yeah, that was the first time the promise was made. This is the promise. Then we take it from there.
Then I will do.
Thank you.
I'll do it like that, Justice.
Thank you, my Thank you, everyone. The court will adjourn. Should we adjourn until 2 o'clock? Or I remember yesterday we made an undertaking to have a short adjournment.
I think 2 o'clock is fine. Already
2 o'clock. The court will adjourn and we stand down until 2 o'clock. Thank you.
Thank you.
online.
Let me check it right now.
Okay, thank you.
The starting point is that ETV states that government's promise is that everyone who currently receives analog broadcasts will be given the means to migrate before the set dates. And this you will find in ETV's founding affidavit at page 001-85, para 206. Then they proceed to say qualifying households were promised the provision of STBs before analog switch off takes place. And for this they plead in paragraph 81. So against that, may I ask the court to have regard to the 2008 policy? Page 001-256 is where the policy starts.
001-256.
Yes, 256.
255. I have it. 256. Yes.
That's where the policy starts. And if one looks at, so if one wants to find what numbers did government estimate and what did it say was going to happen, one goes to page 267 of that annexure.
267.
267, paragraph 2.1.3.
2.1.3, yes.
There in the court will see the policy states universal service and access, or the availability and accessibility of broadcasting services to all citizens, is a key component of successful digital migration. In order for households to continue to receive television services on their current analog TV sets after the analog signal is switched off on 1 November 2011, the court will remember I touched on that earlier ASO date. STBs which convert the digital signal into analog signals are required. The total TV owning households in South Africa are estimated at 7.5 million. So that's where your first estimation comes in, of which approximately 94% rely exclusively on free-to-air broadcasting services. Of these 7.5 million TV households, about 4.5 are poor households who would find it difficult to afford STBs by November 2011. So there's the first iteration of the numbers, those estimates. So then government says, what has it decided to do with that situation? In the next paragraph, it says, it has decided as a matter of policy to consider. And those words are important. To consider finding means of making STBs affordable and available to the poorest TV owning households. This support by government should be seen as part of its commitment to bridging the digital divide in South Africa. Accordingly, for South Africa, the STBs will have special features which enable access to e-government services for all citizens, especially those who thus far have had limited or no access. Digital broadcasting also enables the provision of services in a multiplicity of languages, thus increasing access to information, which, in line with government's information society vision, is an important tool for societal and economic development. This is essential to meet our poverty reduction goals. So, we know, emanating from this policy, government is going to consider. Then we go to the 2012 policy. If you go to Annex PR 25, 001-274.
What's the case of phase 9?
Yes, 001-274.
Yes. 274, yes, I'm there, Mr. Mutawu.
And then if the court can go to paragraph 9, which is on, also which is at page 279.
Yes, sir.
The court will remember we're talking about the estimated number of 4.5 poor households in the previous paragraph that we dealt with. Then if one looks at paragraph 9, it says it substitutes 213, which is where the 4.5 million was in the previous iteration. It substitutes paragraph 2.1.3 and 2.1.4 and the others that are indicated. Then it says the following paragraphs are hereby substituted with the following equivalent numbers. Universal, this is 213, the new 213, universal services and access and the availability and accessibility of broadcasting services to all citizens is a key component of successful digital migration. In order for households to continue to receive television services on their current analog TV sets after the analog signal is switched off, STBs which convert the digital signal into analog signals are required. The total owning households in SA are estimated at 11.5. So the number has increased from 7.5 million to 11.5. Of those, approximately 72% rely exclusively on free-to-air, as opposed to the initial 94%. We now have 72% estimated. And of these 11.5 million TV households, about 5 million are poor households who would find it very difficult to afford STBs. So then, in respect of that estimate of 5 million, at 2.1.4, government says it has decided as a matter of policy to consider finding the means to support or means to make STBs affordable and available to the poorest TV owning households. This support by government should be seen as part of its commitment to bridging the digital divide in South Africa. The government has therefore decided, as mandated by Section 88(1)A of the ECA, to subsidize poor TV households through the Universal Service and Access Fund. In supporting the South African bid to host the Square Kilometre Array, SKA, government will also subsidize affected communities using satellite technology. The government will also consider extending the incentive scheme to households that can only experience free-to-air television services via DTH platform to ensure 100% coverage, which includes the digital signal distribution realities. And then 2.1.5, just perhaps for purpose of completeness. Given the particular South African context, STBs will accommodate and facilitate special features which enable access to e-government services for all citizens. So to go back, the estimated poor households is 5 million, and government has decided to find ways to make it affordable and has decided to subsidize. Then we go to the 2015 policy. That is to be found at Annexure PR 27 at 001-305. And therein, if the court can go to 001-306 in paragraph 5. The paragraph 2.1.3 that the previous iterations had referred to was amended. And the substituted 2.1.3 provides as follows: universal access, the availability and accessibility of broadcasting services to all citizens. Sorry, there was a noise. Thank you. Universal access, the availability and accessibility of broadcasting services to all citizens are a key component of successful digital migration. In order for households to continue to receive television services on their current analog TV sets after the analog signal is switched off, STBs which convert the digital signal into analog signals are required. The total TV owning households in South Africa are estimated at 13 million. So the number has gone up, of which 65% rely exclusively on free-to-air. So you have those numbers fluctuating. It's now gone down from the previous one to 64.
To 65, but the comparator is not the same unless I'm reading in talking about the 5 million and the 4.5, it was talking about poor households and whatever, but here it's talking about not poor households but people that exclusively rely on free-to-air broadcasting. So the comparison is not to the same number, just that we must keep that in mind. That some people might be free-to-air but not be poor. So suddenly the numbers are not really comparable because of that.
Yes, no, Justice Lukaman, you actually anticipated the next point I was going to make about the fact that that estimation, and you will see in the documents that follow, that 5 million still remains as the number. So the purpose of this is that we are still carrying the estimated 5 million being poor households. Then paragraph 3.3.1 is the one that deals with the earlier point that I had dealt with regarding consultation. Then the next document is PR 29. It's page 001-312. So this is a statement made on the 10th of March 2015. And the very first paragraph, therein we find that number again of 5 million. It says more than 5 million poor television household owners will receive free STBs from government, stated the Department of Communications in a release on Monday. Then, if I can ask the court to turn over the page at 313, on the 13th of May, 3 days later, there is a statement that is issued in respect of increase in applications for free STBs. Sorry, I apologize. This is 2021.
Yeah.
Sorry, apologies. But the point here is, if the court looks at the fourth unnumbered paragraph, the decoder brings a much better, and then underneath that, the government plans to switch the whole of South Africa to digital television broadcasts by April next year. You will then need a set of boxes to continue watching TV on your current television set. Then SAPO said in this statement, the post office has advised people who want to apply for a subsidized set of boxes to bring the following documents. So you have the poor households that have been estimated. You have the post office indicating availability of STBs, and then it outlines an application process. And in the first bullet, the court will see that the initial threshold was an income of 3.2 per month. That's in the first bullet. And if I can ask the court to turn over to 314. The post office issues a communique on the requirements to qualify for a free STB. And again, the court will see the post office countrywide have seen a dramatic increase in members of the public who want to apply. So the process of application is inherent in this particular process. And I must indicate, while I'm on this point, that there is no dispute between the parties that the registration process had been open since 2015.
Yes, that is true.
So we understand up to this point what the promise is. You poor household, it's 3,200 rands. You bring those documents that are outlined for purposes of applying. You qualify, you receive the STB. And it is clear up to this point, before I even get to the statement of the minister, where I'll take the court to regarding only the promise. The court will see up to here, there is no promise that everyone in the terms as defined by ETV, which is where I started when I gave the court the two references, is consistent with that pleaded case of ETV. So it is clear up to this point. When we go to the media statement of the 5th of October, if we don't find anything consistent with that ETV case, we will submit that. That will illustrate the falsity of that premise of ETV's case.
Well, I still don't find the contrary, but you can continue. I mean, here I see people saying you can come and register, but I don't see where it says if you fail to register, this is what will befall you, sort of. So people can say, so to set something up as a qualification actually means if you don't do it, you fall out. But this is almost like come register and you get a set-top box. But that's besides the. I think we'll still remain on this for a while, but you can proceed.
Yes, I mean we're making our submissions on the basis of the understanding of what we put across.
Yeah.
If we can then go to the media statement, that same file, page 001 at 214. So,
and Mr. Mataz, I mean this to me is where the shoe starts to pinch for the minister, because now we get to the 3-week issue, which the minister has foreshadowed, but now it's the 3-week.
Sorry, Justice Leroux, I'm going to deal with the promise only. I've divorced it from the awareness, because I'm going to go back. What I'm going to cover next is the issue of the awareness, because I complied with the request of the court. I had indicated I was going to present the case differently. I was asked to isolate only the promises. And so it would be a conflation to move from the promise to get back to 3 weeks without going back to the awareness process. So if I might just ask that we follow that perhaps necessary discipline for present purposes. And I will indicate why that should not be a concern. Because I would accept if it emerges for the first time that people needed to register, maybe there's a debate to be had. But let me deal only with the promise in the statement and nothing else. If the court goes to paragraph 2.1 of that statement, 001-215.
031-215.
No, 001-215. Just the next page of where we were.
It's fine. You can proceed.
Yes, 001-215, paragraph 21. 2.1. I apologize. Under the progress status of the BDM process, the government undertook to assist beneficiary households earning a total salary of less than 3,500 rands per month. So there's a movement from 3.2 to 3.5 with installation of STBs to ensure universal migration. The process of registering beneficiary households to be supported commenced in 2015. And that point is going to become important to the question that Justice Leroux wanted to jump into. And that's why I was indicating earlier, there's no dispute that this issue, the registration had been opened. I'm going to deal with the awareness aspect. The process of registering beneficiary households to be supported commenced in 2015, and to date, 1.184 qualifying households have been registered out of the estimated 3.75 qualifying households per the State SA 2018 data. 2.2, since the inception of the BDM program, 556,954 beneficiary households have been migrated from the current total of 1.184 million. In addition, almost 10.5 million households out of just over 14 million TV households per those same stats self-migrated through private satellite boxes as follows, and the breakdown is provided. And in 2.3, Centec has been able to switch off 84 sites, multi-choice analog transmissions, then 105 out of 288 being 37% are SABCs, and 4 of the 95 of those are ETV. If the court can just note that, I'm going to come back to another point. and I'm going to add this to the freedom of expression point. There is no case by ETV that the switch off of the 4 analog transmitters in any manner, form or shape infringes the freedom of expression right. So it is important when we get to that debate that. Sorry, there is some echo.
It's on your side, I think.
Yes. No, I can hear it on my side, but there's nothing that we've done here. Okay, I think it's gone. Thank you. So there is the promise. It's very clear. You qualify, you register. And the next point I'm going to get to is the call or the calls for registration, because it's important to understand that to locate the minister's call of the 5th of October 2011, because viewed in isolation, perhaps there can be some debate, and I'm not sure about its ultimate result, but viewed from the context of the proper facts, we will make the submission to the court and illustrate that there is absolutely no substance in that complaint. As I indicated earlier, the minister's statement, that statement of the 5th of October, states that the calls for registration was not a first-time call, but it was in fact a final call for registrations in a process that had been opened for 6 years. And we deal with this in our heads of argument at 021 to 2226 in paragraph 12.
Mr. Matad, just so I'm clear, the first bullet in 4.5.1,
yes,
you accept that's part of the promise. Qualifying households who register on or before 31 October will be connected before ASO.
Yeah, yes.
That's
perhaps,
part of the deal.
Perhaps let's just add that. Let's add 4.5.1 and 4.5.2 to that.
Okay, so the government promise includes if you're registered by 31 October, we'll connect you, and now we can fill in before the ASO to mean before 31 March.
Yes.
And then after 31 October, 3 to 6 months, so
yeah,
from ASO.
Correct. Okay. Including that first bullet of 4.5.1. And then, yes, and then as I indicated, let's just, for purpose of completeness, also deal with 4.5.2. We call upon all eligible households to register at the nearest post office on or before the 31st of October to receive government assistance for your STB installation. We are also finalizing a registration app, and the details will be announced in the near future. I'm going to come back to the app issue, which emanated for the first time in argument, and the court will see that there is no such complaint in the founding papers. So there was no need to answer that point. But I'll illustrate to the court.
So now what is the last point? The app issue?
No, the app issue. The
app issue. Okay.
Is that the app issue arose in argument? It's not in the pleadings. So and also I will contextualize it in the context of the minister's statement. So the next point we make is that the calls for registration by qualifying households for STBs was made at least from 2015 when registrations opened, as the court earlier on indicated, agreement that's an uncontroversial issue. We deal with that in our heads in paragraph 83, so 183 and paragraph 2.9.1. Then the calls for registrations were also made over the years through various means, namely the government Imbizo campaigns, The court will find that in our heads in paragraph 13, together with the references in the papers. The SAPO, the South African Post Office Awareness Campaign that was ran, we deal with that in our heads in paragraph 79. The door-to-door campaigns, we deal with that in paragraph 80 of the heads, together with provincial and local awareness, character generator on analog broadcast platform, then television and radio messaging. The court will find that in paragraph 81 of our heads, it provides the references to the papers, the road shows, SMS messaging, together with social media. All of that the court will find in paragraph 81 of our heads. So that's the context of the need to register. And it is clear, we submit, that qualification to receive a set-top box is contingent on registration. Because as I illustrated earlier, the mere fact that a household is, according to Stats SA, it falls within the category of financially challenged or poor, does not in and of itself invoke a duty on the minister, absent registration. That's the earlier point I was referring to, Justice Msimang's point about raising your hand. And it is the reason why, Justice Leroux, you asked our learned friends yesterday, Mr. Marcus, whether registration is an appropriate proxy to determine the scope of the numbers that stand to be affected. That point was made by Justice Msimang in also a slightly different way, but the essence is the same.
And Mr. Matau, on that, does your client is your client's submission that registration can be used as a proxy for scope of STBs needed?
Yes.
Okay. Okay.
Yes. And you'll recall we deal with two categories. I'm going to get to the two categories. So it's registration constituting a reasonable proxy by which to indicate the numbers to whom STBs should be provided. And then in that category, the pre-31st October registrations and post-31 October registrations. And it is very important to understand that over the 6-year period, the following have been made clear to members of the public. There will be digital migration. There will be migration from analog to digital, put loosely or put simply. There is a registration process through which you qualify to receive a set-top box. And there is an illustration of poor households, in other words, eligibility. It is poor households. And if the reasonable inquiry is entered at all, and we will deal with the legal principles of whether rationality, or whether reasonableness as a test finds application and assists the applicants at all. Assuming on the basis that they have formulated it without accepting that the principle is correctly accepted, then the notification to the public of the issues that I've outlined, conversion, device, application, what you need to bring to prove that you fall within the policy, have been in the public domain for these years. And I will perhaps I should deal while I'm at this point. The court had a submission by a learned friend for ETV yesterday saying, well, it is, I'm trying to paraphrase, extremely cynical, and it is a cynical contrivance by the minister to talk about this 6-year period when in January to October 2021, the process of rolling out of STBs had come to a grinding halt. The court recalls there was that submission that was made. But of course, missing from that submission is the fact that the registrations, which have no bearing for purposes of this point, remained open. So it would be perhaps of some materiality if that process of halting the rollout of STBs was somehow linked to inability to continue to register. So if that period of registration remained open, as we say it was, then that point we don't understand its relevance. And we're not going to throw labels into that because we are dealing with a bona fide dispute here of parties that are affected or stand to be affected by the policy and the undertaking of a commitment that government made. So I'm going to refrain from categorizing that submission. Safe to say it is false and thus sensational to label my client's case as being cynical or constituting a cynical avoidance. And if
Mr. Matau, just, and I'm sorry if I take you off your plan, but if I don't ask, I'll forget to ask. And it is something that goes to paragraph 7 of your supplementary affidavit, your client's supplementary affidavit filed overnight. So you agree with me that registration is a useful potential proxy for scope of the number of STBs, and you've explained, everybody knew they had to register and they knew they had to qualify. Is where we see, for example, in para 7 that, 1.2 million registered, 1.18 qualify. And we know, you'll address us in due course on the submissions that were made about we don't know what it means to qualify. But the qualified number means I'm below the 3.5 and need my subsidized box. Yes. So there's registration for the number of boxes, and there's qualification as a.
No, we've dealt with that up to now. You are below that threshold you have applied. I thought we've addressed that issue.
Okay. Okay.
Yes. No. So it's clear. It's application. Sorry, it's the threshold and application. I'd made that point that.
No, I'm just trying to understand because there seem to be a category of people who managed to register but weren't qualified. So the qualified people are actually the better proxy for how many we need. The lower number is actually the better proxy. Yes.
No. We can accept that. That's fine. But the parameters of the promise have been indicated. The measures that government embarked upon to ensure communication and heightened vigilance on the part of the public has been set out, and it's not disputed on the papers. Then the minister in her statement continues in paragraph 6 of the statement, page 001-218. To ensure that this plan is executed, I have established a project steering committee which is constituted by CEOs and technology executives of all affected and participating stakeholders. The steering committee is chaired by the minister and meets on a fortnightly basis to lead the switchover process. I have also appointed a project manager to oversee the digital migration and ASO process. We will report to the cabinet on a monthly basis and update the nation about the progress at least once a month. We are in October. The minister says updating the public will occur at least once a month. And you will recall there was this complaint by the intervening parties. They said, well, go to the statement of the minister in November. This is after the fact. This is after the cutoff date of the 31st of October. What's the point? Because they say, in the minister's statement, she spoke about the app, and then now the app has disappeared. There is a registration link. But how does it assist? Because this registration link is given in the media statement of November. The court doesn't need to go there, but it's a statement of the 24th of November 2021. It's at 019-210. Just for purpose of the record, I don't intend to deal with the for now. But what the court will find in that statement, in paragraph 1, the minister makes it clear that in line with updating the public on a monthly basis, on at least a monthly basis, I hereby report. So the purpose of that statement, you'll see in paragraph 1 thereof, it connects to this paragraph 6 at 001-218. But also importantly, government is still running the process of registration. In other words, the process of registration is open and has remained open post the 31st of October. So there are new people that are registering as per even this affidavit. And there is still a need to communicate with those people to update them about what is going on, where things are, and so forth. And the point about the app, as I've indicated, the court will not find it anywhere in the intervening parties' founding affidavit. So there was no need to answer that point. And it is important to also note that it is not ETV's or the intervening case in their founding affidavit that the registration method chosen is inappropriate.
I don't think anyone even suggested that.
Yes. No. Yes. Thank you, Justice Lukeman. And then the minister explains in the answer the extensive measures that have been undertaken to inform the public of the need to register. And this we set out in our heads of argument at page at 021 to 278 and 280, paragraphs 178 to 183. So therein the court will find the list of the measures that were undertaken by the minister as pleaded. Now, we now know what the promise is, and we now know what numbers were estimated. We come to a situation just to complete the issue of the numbers, and then we can deal with the KZN principle to the extent that it is relevant, and deal with the alleged infraction of the rights. We now know that what then happens following that call for the cut-off date of the 31st of October. If I can just deal with that category, then I'll come with the post 31st October registrations. The number that we are dealing with for purposes of people that have registered, one can go to that paragraph 7, to which Justice Leroux was drawing me to earlier, 027-4. And one will see that those numbers at 7 must be understood from the prism of what is stated in paragraph 4. In other words, those estimates by Stat SA, the number of households that owned TV sets, the number of households that have self-migrated, and on the basis of that, this is paragraph 5, the department estimated that there may be 3.75 million households that may be eligible for government assistance. Because it's for that obvious reason. Poor does not necessarily mean you are eligible. For a number of reasons that have been pleaded, even. But just by way of example, you may fall into the number that is eligible at the time when the stats are taken for purposes of estimation, and you can get a job that allows you to afford the cheapest of packages, that 29 rands package. So the number might show that you qualify, but it doesn't necessarily translate into need, because for various reasons the numbers vary, and they may go. Yes. Mr.
Motau, yes. I hear what you say, and I think basically the 3.7 million is a tool from where people who are eligible could come. Yes. But that does not mean that the 3.7 million people is a promise to them. Correct. Is that how you understand it? It's just a pool. And yes, as you can say, you can jump in and out of the pool depending on employment or being unemployed and all that. But that is the pool.
But importantly, Justice Nsimang, let me add these two qualifications. You may fall into the pool and be eligible, but if you don't apply, then, or if you don't register, then you have not brought yourself within the remit of the policy. That's the first issue. The second point that I was making, which is earlier, it is that you may even register, because these are the facts that are pleaded. You may register on the basis that you're eligible, but come the time of installation, your circumstances have changed. You have self-migrated. So for that reason, while you are in the box or while you are in the number, the STB is no longer needed for your purposes. So that's why the only complaint in our submission in respect of the first category can be, I qualify, I registered, I wasn't provided with the STB. Absent those, the estimates are simply estimates. And in paragraph 6, the affidavit states that process started in 2015, and then it distills the numbers as at the 31st of October in accordance with the minister's statement. The 1.2 had registered, the 1.180 qualify, and perhaps let me pause here. Justice Leroux, you had asked about, but what does qualifying mean? Let's give this particular example. You fall within the range that is identified, and you would qualify for the provision of the STB. And you will see what then happens in that statement or in that paragraph is that there are installations that could not take place. And I was giving that one example of how that could have happened. But it is of no concern to the level of materiality, in that, as I've indicated earlier, there is no case that says I have applied, I have registered, I have been cut off, and I stand to face the risk of a blackout come 1st April. And I must indicate, while I'm at this point, that the fact that one has labeled litigation as constitutional does not mean that the rules do not apply. The rules of pleadings. As the court would know, there are 3 affidavits in pleadings. There is no automatic right under the rubric of a duty to account or the duty of candor that entitles you to file a 4th set. The principles of filing a 4th set of an affidavit are a principle of our law. But let me indicate, because much was made about the minister's tender and it being a concession and accepting these duties. The court will recall that in the course of this debate, the court was worried about, but where are we now? And how many people have registered post 31st October? On the minister's conceptualization of the case, that ought not to be an issue for the reasons that I've submitted, because there is a policy, it was widely communicated, people know what the criteria is, people apply, and STPs are rolled out, and there's a commitment that they will not be switched off. So those are the 6 pillars that do not necessarily pose a concern. And following those the discussions, the minister then offers to step in by offering a tender, as I've indicated, which the court may have accepted or have rejected. The court may have said, it's not necessary, and the court had not heard me at that point about what are the parameters of the case and is more needed. But in order not to be obstructive and to assist, and in not breaching the rules of court, the undertaking was to file a report, not an affidavit. And I've explained how that developed into an affidavit. So it should be very clear that the tender which migrated into from a report to an affidavit does not in any manner point to an acceptance that on the pleaded case there is a breach of duty of candor, accountability, or as the applicants have labeled it.
Certainly, and certainly, just speaking for myself, the provision of the affidavit has certainly assisted us. And let me say again that what we've said previously, which is shout out to you and your team and your client's team to pull this together for us overnight. Can we now talk about the likelihood of 8, 9, and 10 of this affidavit?
Yes.
Happening?
Yes.
With 285 installers.
Yes.
So we know there are 8,000. Can we now actually talk about
let's deal. Yes.
How are we going to install 507,251 households?
Yes.
By 31 March? Well, that's what I'm most anxious about.
My lady, there is no reason for you to be, because the minister has made, well,
let me tell you why I'm anxious and then you can
yes,
address. Because the stats on the rate of installation so far have not given comfort that previous performance will give us comfort about future compliance in the next 2 weeks. In particular, this issue about, 200, actually only 285 installers have been busy, even though we know that there are 8,000 engaged. So on the facts, and I'm certainly not inviting a further round of affidavits, but on the facts here, how can we be comfortable that 507,251 split out in the provinces in para 10 can happen, and some of them you say can even happen in the next 10 days?
Yes. No. Let me deal with that issue. There is a need to distinguish between installations that happened pre-ramp up and installations that are going to occur post-ramp up. That's the first point. The second point is the department, as the executor of the plan, says to the court, this is the exercise that I've assessed. These are the resources that I require. These are the numbers that I'm going to achieve within the time frame that has been stipulated. And again, I must tie in this particular part of the tender, which the court has not taken up. But I must indicate that that tender is still available. The minister has not withdrawn that tender. The minister says, I'm prepared to assist the court by even providing a further report post the 31st. In other words, post the 31st of March, in having regard to the fact that the court has been requested to give its judgment prior to the 31st. In other words, nothing to do with the relief that is sought, which is termed report relief. But the minister says, I, as a government official, have put together a plan through which, as a government, we have committed to undertakings. I have gone to cabinet and cabinet has given me the go-ahead to publish ASO. So there are commitments not only to the court, there are commitments to cabinet. And the minister says, here is the information. The numbers will be met as people on the ground with the teams that are there. And she gives other variations. She indicates that in paragraph 13, there is also room, because not all provinces have the same challenges. Others are small in numbers compared to other larger provinces. So there's that possibility of deploying those resources. And in addition, we've deployed our staff to do away with the collection of boxes directly from the post office by persons who have applied and who qualify. Let me use that language, Justice Leroux. So,
can I?
Yes. So,
can I understand do we know the status of the Centec affidavit yet?
Sorry, I'm told it's uploaded. Yes, I'm waiting for a reference.
Okay. Can I just ask?
Yes.
On reliance on this commitment to have done certain things by 31st of March 2022.
Yes, Justice.
I think I would have been comfortable to consider the ramp up and everything if, when this information was provided as it is now, had actually pointed towards a situation in the provinces that had already been switched off that is more positive. But if I look at this and I consider that there are provinces that have already been switched off, so we are literally sitting with people amongst these numbers that are switched off as we speak. Why was there no agency? I mean, I would have been more comfortable to say, okay, we can get to the ramp up and everything, and that if on these numbers, I could have gotten a sense that the provinces that had already been switched off where actually people were prioritized and their need and everything was taken into account. But it doesn't look like it happened at all. In fact, those provinces almost sit like everybody else to be considered in this ramp up. And that just doesn't make sense, at least to me, to then rely on this promise that in 2 weeks, I will do something for people that I couldn't do to others that I have. Some of these people, we might say, are not yet switched off, yes, but I couldn't do to those that actually are now sitting with a problem, but I now undertake that in a shorter period, I'll do for everybody. I just think that that is why I have a problem in accepting this, because where there is an agency, where people are already sitting with nothing, they are still sitting with nothing and now being lumped with everybody else.
Yes, Justice Zimmerman, before I deal with the issue, if you can just allow me a moment.
My brother, my sister, on my case lines, I don't have another affidavit uploaded yet. Do either of you have an upload on your case lines? I don't yet. I just want to make sure I haven't missed it. Perhaps Mr. Matar is getting an instruction on that. Let's see.
I'll let you use the other computer. Unfortunately, when I use this one, I interfere with with the signal and all that. So I'm not sure.
Yes, thank you, Justice Lukaman. I'll come back to this issue. Yes. I just want to make sure that there's an alignment between my team and I. If I may just give the reference for the confirmatory affidavit, I'm told it is at 012-4.
Let me go there.
And the court will recall that the allegation in relation to Centec deals with that Centec has since augmented the installer capacity. This is paragraphs 11 and 12. Across provinces to fast track the outstanding installations, the contracting process, and that it has since engaged 8,000 installers to complete the project. So those are the Centec related allegations. And if I may then continue to return to Justice Lukaimane's point at the appropriate time. The case that the minister puts before the court, she says in paragraph 22 that the department is satisfied that the deadline will be met in respect of the households that registered prior to the 31st of October 2021. And if I may then just return to the issue regarding or perhaps if I can then touch on the post 31 October registrations. It is important to bear the following principles as indicated in the affidavit, or the following facts. If one has regard to paragraph 18 of that affidavit,
affidavit, can you give me the number of case lines, please?
Sorry, 027-7. That's the additional affidavit, the supplementary affidavit.
You are now talking about the 260,000 odd people.
Yes.
Yes.
Yes, Justice Lukama. The one that I mentioned in paragraph 17.
Yes.
You recall Justice Leroux was asking yesterday, so do we know how many people have registered post 31 October? Then, so in response to that, there's that 260,868. And in paragraph 18, it is stated that if the number of additional registration does not change, the project would just need to apply for a deviation from National Treasury to increase the contract scope and value for the required additional installations. This is so because National Treasury has approved installations for registrations up to 31 October 2021. The number of late registrations was an unknown factor which could not be provided for in the National Treasury approvals. And to go back to 2022, so to paragraph 22 where we were earlier. I read only part of that sentence, registered by 31 October 2021. I continue, and it will accelerate installations for those that registered post 31 October 2021 once the aforementioned unknowns have been ascertained and the information crystallized. Now,
Mr. Mutau, on that one, because we know that people who are registered, up until October 21. If we look at the number of those people and the number of the sets that are at the post offices, if there were no registration post 21 October,
yes,
then there would have, exactly, then there would have been a surplus of these STDs. Exactly. So we know that if we add the number of these people, the new number, then there will be 60,000 odd that would not have STBs. So I would imagine that Treasury should have really made provision at least for the installation of all the STBs that are there in the warehouses. And if we have a problem, we should only have a problem if you have to go to Treasury. If the minister has to go to Treasury, it will be only for the surplus of the 60. Do I understand that? Is that what is that the correct understanding of the position?
Justice Msimang, let me deal with that proposition on the following basis, because the court raised the issue about surplus. But I think let's deal with process first, and then, in other words, registration and the numbers and what that does from a planning perspective, and relative to the 31st of October, because the planning thereof is aimed at achieving a particular target, then there is a category post the 31st that requires planning. The principle being the following. The 3 to 6 months, the minister has indicated, that's an outer period. In other words, the 6 months is an outer period. And because the numbers keep fluctuating, let me give an example. The number of surplus might increase. You might find that 20 of the ones that have indicated that require a connection through STBs no longer need them. I'm just giving an example to illustrate this point. The point being the following, that insofar as the process and the deadline is concerned, the minister explains, he says, for planning purposes, you need to understand what you are dealing with. And this is in the context where the minister has stated that the number that had been projected was even far higher. But given where things are for purposes of planning and the commitment that had been made and clearly communicated, including in the statement of the 5th of October, it is to that category that the promise ought to be interpreted. So in other words, it is easy and perhaps tempting to want to simply look at, well, there is spare capacity and then lump them together, because that loses sight of the case that we are dealing with. The case and the promise must be dealt with first.
But can I just continue?
And if there's no breach on the case and the promise, then we get to the next part where the minister says, understanding that what she had contemplated is national treasury. And the court would know with national treasury, you're not, because procurement is a regulated area, you don't just have a license to spend government purse, just to say, well, there's a need, I'm going to spend. When you apply for deviation, that's a regulated process in our law. The PFMA and its regulations are known. So the issue is not on the part of the minister to keep South Africans that qualify in the dark for the maximum period. It's for that reason that in the last paragraph 22, the commitment to accelerate, even in respect of those post 31st October, is provided. So we submit two things. It is important for a line in the sand to be drawn from the by way of using the 31st of October, because that date has material consequences in understanding government's promise, and against which promise any breach ought to be viewed and interpreted. And on this fact that we're showing, and again I must indicate, subject to returning to Judges Lukaimani's question, there is absolutely no reason why the application ought not to be dismissed based on that complaint, because there is no infringement of freedom of expression at the level of the facts. Forget what the law provides. Simply at a factual basis, there's no breach of undertakings of any sort, constitutional or otherwise, pre-31st October. And it is important to then come back to the question that Justice Leroux had asked. As one of the red flags, this is my description, not yours, Justice. Having accepted or with the need to accept, as we say the court should, that the registration process had been opened for some time, for many years. With the qualification criteria having been stipulated as a precondition for receiving an installation of the STB, with the extensive media campaign read with the various imbizos, digital zongas and so forth, where there is no issue prior to the 5th of October, that those efforts that government says were expended, including the service providers who assisted in that process of flighting of messages, there is absolutely, we submit, no basis to found or ground a case. Now the issue, let's then get into this period, the decision by the minister to announce the cutoff date of the 31st of October. With the need to understand that that is a final call of a process that had been opened for 6 years, there is absolutely, by means of language, not by means of legal test, nothing unreasonable in the minister making that call, coupled with the further additional heightened awareness campaigns that were run. You recall, it's not simply a question that there was a call or the last call and government did nothing. And there were additional campaigns that were ran, and it is for that reason, as we understand it, that Justice Leroux asked ETV whether ETV assisted in that process of flighting of messages to add to that campaign. And I'm assuming, Justice Leroux, that the reason why you had said so is because in relation to the minutes, the consultation minutes that I'm going to deal with, ETV's assistance was requested together with that of the other players to assist the minister in rolling out knowledge, and even on the ASO, which I'm going to deal with later.
I think for me,
yes,
because you are discussing the date now, for me, if you say to me, even in plain language, given everything, there's nothing unreasonable, or the cutoff of 31st of October was reasonable, I still want to know, given all the other information that we have,
yes,
what was the date based on? Because it was not certainly based on the number of set-top boxes available, because we now know that you will have an excess after that. It is certainly not based on the planning that needed to be done immediately after 31st of October, because if we see what needs to happen in the next 2 weeks, no planning of any kind happened for a long time. So I am also wanting to locate the reasonableness of that date within what was everybody busy doing from the 1st of November that we now sit with all the information that we sit with on the 15th of March, and we are in this position. So what was that date based on? What did people need to still be doing?
Yes. Justice Lukamane, the minister explains that, and let me attempt to locate this again in its proper context. You have international obligations to switch off and to migrate. You have the need to release the spectrum. There is a need to complete the process with a view to announce ASO, i.e. finalize the process. And I'm going to deal with the consultation aspect, because it's, if this question is looked at outside of the consultation, it might be easy to simply seek to look at it from the prism of a vacuum. Because the minister, when it deals with consultations, at which I'll take the court, she deals with the various minutes, she deals with the issues that were raised, including the issues by ETV. She deals with why those issues were taken into account, those that were taken into account, why ETV's plan was not going to work. Those reasons are pleaded in the affidavit, and why on those facts that arose from the consultation, she was satisfied that what was needed as pre-requirements, for lack of a better description, had been satisfied. And if I may just go to those consultations next, because as I indicated, there is communication, there's criteria, there is this engagement. And again, I qualify this on the basis that we had initially indicated. As a matter of law, this is entirely not a requirement. But the court, as I indicated, sit in a fortunate position where even after pronouncing that this was not a requirement, it will be able to deal with the consultation that took place and what that consultation yielded and what principles apply.
Mr. Mittal, before you go there, just two questions from me. The first, a very practical one, because I'm anxious about time, and I appreciate that you've been dealing with the court's questions, but we still have Mr. Makari, Mr. Snickers, Mr. Duplessis, and Mr. Ferreira to come. If you were uninterrupted, how long do you think you would need? First question. And then secondly, can you just explain to me the 260 that we now have, the additional registrations post 31 October?
Yes.
That's roughly half of the 507,251 that are still left to be installed.
Yes.
And I don't want you to be giving evidence from the bar either, but let me just tell you my concern is that if half of the number that were registered by 31 October have registered since 31 October, if we shut off the other 4 provinces, we don't know how many more potential registrations would come. Let me then say it rhetorically, because I don't want you to testify from the bar. When does registration end? Because now, because of this affidavit, the court is now apprised of the fact that there are 767,000 people that still need a box. That number might increase, even if it decreases with some people self-migrating. At what point do we have a universe of registration? Let me say that rhetorically for now.
Yeah, no.
Here we are at 23 minutes past 3 on the second day. So we can discipline ourselves.
Yes, no, Justice Leroux, I understand the proposition that you're putting to me. Let me first deal with the issue of time. I'm going to endeavor to finish in less than 20. Against that, let me illustrate. Let me deal with the question. There is on these papers no indication that registration is closed. And in other words, government understands that commitment. In other words, you don't throw the guillotine and say you didn't register by 31st October. That's it. You are not going to receive any assistance. Government has, through its commitment, says come even after the 31st, but there are difficulties with coming after the 31st that requires Treasury's involvement. So it is not possible, Justice Leroux, post the 31st of October, or in terms of the post 31st of October registration, to give an estimate of, well, how soon thereafter will people receive assistance, except the minister has given an outer period of 6 months, which is of course variable because there are a number of factors. Like, for example, the court has pointed, if you have spare capacity, it eats into that number, and that doesn't invoke or involve Treasury's a deviation. And perhaps, and I mean, that's in terms of government policy, they'll decide how they distribute those in terms of registrations. But to come back to the point, just to deal with ETV's concerns. We commence by indicating that the requirements of procedural fairness, both PAJA and our courts recognize that it is inherently flexible. In other words, fairness is not an immutable standard. It is context dependent and thus must be adapted in accordance with the prevailing facts and circumstances. The minister, her predecessors and the department have, over the 15-year period since digital migration was first mooted, consulted extensively with the industry and the public, and that the court will find in the minister's answering affidavit, page 009-24 to 30, paragraphs 75.3 to 97. The minister and the department have consulted extensively with ETV and other broadcasters about the most recent iteration of the plan for digital migration. And this is important for purposes of the questions that were asked. So the department and the minister consulted on the most recent iteration of the plan for digital migration, its minimum preconditions, and the ASO date. That reference the court will find in the minister's answering affidavit, page 009-31, para 99. And we focus on ETV for the reasons that have been advanced in the argument. So on the 8th of February 2021, this is prior to the SONA, the minister held an urgent meeting with the CEOs of Centec, SABC and ETV to discuss an ASO plan presented to the minister by Centec. And the court will recall Centec was appointed as a project manager. The technical requirements of digital migration and the proposed plan to complete digital migration, including the goal ASO date of March 2022, were discussed at that meeting. The reference, the minister's answering affidavit, 009-31 to 32, paragraphs 101 to 102. ETV attended and made detailed submissions on that plan. That's at paragraph 104 of the minister's affidavit. It's important. It's the technical requirements, it's the complete migration, including the ASO date. So the parameters of the subject matter of consultation is important. A further meeting was convened.
That's that AA8 or whatever, that like 7 pages of by receiver, how many households, that detailed plan.
Yes.
That's the, okay.
That's the consultation. A further meeting was convened on the 17th of February under the auspices of the Broadcasting Digital Migration Project Office, which discussed a draft plan for digital migration proposed by Centec. The meeting was attended by the department, the SABC, ETV, USASA, the Post Office, and Centec. ETV raised a number of issues with the plan, including that it could not be implemented in the time frame proposed by the minister. The reference for that is in the minister's affidavit at paragraph 104. On 19 February 2021, ETV was invited to another meeting with the department. The agenda for the meeting and the updated digital migration plans, including ASO readiness, were issues that were discussed and issues on which ETV made various submissions criticizing the plan, which largely mirrors the issues that form the subject matter of this application. That's at paragraph 105 of the minister's answering affidavit. ETV is also part of the project steering committee set up by the minister to guide the digital migration process. Its members include ETV, SABC, eMedia, MultiChoice, Starset, Telkom, Centec, USASA, the Post Office, and the State Information Technology Agency, SITA. That's in the minister's answering affidavit at paragraph 132. On the 20th of September 2021, the steering committee convened to discuss the department's integrated ASO plan for the implementation of digital migration. Importantly, at this meeting, the deadline for registration was discussed at the meeting. That is to be found in the minister's affidavit, paragraphs 134 to 152. So it's important to understand that context of a complaint about, and again I used colloquially, the reasonableness of the cutoff just doesn't come out of the blue. It's discussed. Because we should bear in mind, it's the state of readiness that's being tested, and that's why the role players are being consulted. All parties supported the ASO plan except for ETV. That is in the minister's affidavit at paragraph 147. Against that, the minister requested ETV to make a presentation on ASO at the next meeting. That is in paragraph 150.4. On the 1st of October, a steering committee meeting was convened, or it convened another meeting in which ETV was afforded an opportunity to make a presentation on its ASO proposal. That's in paragraph 156 of the minister's affidavit. Further meetings of the steering committee were held on 8 and 22 October 2021, which addressed inter alia STB rollout, awareness campaigns, registration, and STB chipset availability. That is in paragraph 163 of the minister's affidavit. And ETV contends that these consultation opportunities did not constitute a meaningful opportunity for consultation. The court heard that submission, and that the consultation was not approached by the minister with an open mind. It also contends that its participation in certain meetings was without prejudice. But we say these responses are untenable for the following reasons. We say ETV was afforded numerous opportunities as early as February 2021 to comment on the gist of the department's ASO plans and timelines. ETV communicated the same grievances it now raises in its application during these meetings, which have been addressed above. And this is the point the minister makes in paragraph 106 of her affidavit. The minister and the department carefully considered ETV submissions with an open mind, paragraph 108 of the minister's affidavit. And ETV also contended for the first time at the hearing that it had not been provided with sufficient information of which to make its representations. We submit the requirement of fairness, as the court would know, is for the consultee to know the subject matter of the case that they need to meet. We've illustrated in those meetings information that was shared, and ETV knew what the subject matter of those discussions was going to be. And it is important with reference to the authorities, and if I may just give the court a few of these, which are well known. The Duty versus Secretary of State for the Home Department and others. So, and other appeals. It's in 1993, volume 3, all England's report 92 at pages 108 and 109, which has often been cited with approval in a number of SCA decisions. Minister of Education for the West Cape versus Beaverlawn Secondary School, the Branco decision, and the Dupree. And really that's the principle. Does a party know the gist of the case? ETV knows over a period of 15 years. We are talking digital migration. We're talking the need to complete, the need to free up the spectrum, the need to cut off registration, the need to announce the ASO. All of these are known. But importantly, ETV does not state what information was not shared with it. Because they ought to say, we didn't know this information. If we had known, perhaps this is what we could do, as the cases on procedural fairness require. That is, if it applies at all. And the minister was transparent about and shared her plans at the BDM steering committee, of which ETV was part, and a final draft of that plan was also shared with ETV in February of 2021. And the reference for that is the minister's answering affidavit at paragraphs 134 to 152.
Well, I suppose ETV might say, I didn't know you were going to shut registration 31 October. They can't say they didn't know end of March for ASO. The only missing thing they might be able to say is registration cutoff. Because that, I don't think I saw registration cutoff in those draft plans and presentations. It was always about ASO, not about registration cutoff.
No, but Justice Little, you'll recall what the purpose of the meeting is. The meeting is to test whether it is appropriate. In other words, have all the conditions been met in order to decide on the cutoff. So that's the purpose. The purpose is not for the minister to say, well, I'm saying the 15th of October, do you agree? That's not.
It's not in consultation with. Yeah.
Yes, that's not. So that's the important.
Mr. Mutau, but in any event, the minister is calling on the public and not ETV. So whether there's a cut-off point, has that anything to do with ETV?
It's so nothing to do with it, but we're bringing it closer because it is the party that is complaining in circumstances where all the parties that were consulted, including members of the public, there's no complaint about this. But it's important, Justice Nsimang, that we are pointing it out, that to the extent that the court is being asked to stretch this principle, contrary to well-known authorities, ETV on these facts has no case on lack of consultation and procedural unfairness. Because, and perhaps let me proceed. We're going to make the point that ETV's conflation of principles is something it did not learn from the previous litigation. Because in the previous litigation, the Constitutional Court made it clear that the standard that was expected by ETV fell short and was incongruent with our legal principles on what was required by consultation. And if I can just go there, that there is no agreement that is required. So you don't consult for purpose of saying, well, because we must agree a date, I must tell you a date. I consult because I'm checking readiness in order for me to determine whether I can cut off the registrations. We say ETV labored under the same era in the electronic media case. And the Constitutional Court sought to correct ETV by stating in paragraph 42 of that judgment that consultation as distinct from negotiations geared at reaching an agreement is not a consensus-seeking exercise. It would therefore, the court held, be a misunderstanding of the concept of consultation if one were to approach it as if it is intended to allow parties to exhaustively discuss and iron out divergent views until some mutually acceptable basis to proceed from is found. one should remember this happens in the context of the minister that ought to exercise executive power in terms of Section 85, which is where the power to promulgate the ASO date comes from. It's not, you don't go to the regulations, you don't even go to the policy, you start first with what kind of power is this? This is executive power. The power is regulated in Section 85. We've made those submissions in our heads and we've given the courts the case. Such that whether the minister later on refers to the migration regulations that are published by ICASA, I mean, the court knows ICASA can't give the minister empowering provisions for the minister to exercise executive function. It's purely absurd. And that's why no time needs to be spent on that submission that this is not executive power because of some or other reference to the digital migration regulations. And to apply it then to the fact, and simply to show you why ETV continue to perpetuate this error, they tell you about God had Adam in the Garden of Eden. But they stopped short of telling you that when God had Adam and Eve, it was not for purposes of reaching consensus on whether to expel them from Eden. God had them for them to explain themselves, and we know that the outcome was to expel Adam and Eve from Eden. But that analogy that ETV uses, it is profound because it uses it simply to illustrate its misunderstanding that because God spoke to Adam, more was expected. But that example doesn't even assist them. That example is congruent with the minister's case and the minister's approach, and a number of authorities, including the one from which ETV ought to have learned. And perhaps if I can just deal with the two cases. We know that ETV relies on Scalabrini and Albert. It is important, let's deal with Scalabrini, to note the following. I'm not going to tell the court what the facts are because my colleagues must speak after me. But in that case, there are two reasons why the court said the process of, or the principle of process rationality as opposed to procedural fairness found application, because also ETV conflates these two. There's process rationality as a principle, there's procedural fairness. Our cases, as we've indicated in the heads, are clear. The Constitutional Court in Mutau and all of those decisions, they state policy is executive power. And it doesn't attract the duty to consult. There's no procedural fairness required in the exercise of a Section 85 power in terms of the Constitution. But what the court said in respect of Scalabrini, it was influenced by two factors. It was influenced by the fact that the Office of Refugees, or the Refugee Reception Office, had long experience and special expertise in dealing with the asylum seekers in Cape Town, but that was not the only thing. The departmental officials had specifically undertaken to consult with the applicants on any proposal to close the Cape Town office and had acknowledged the necessity for such consultations. The relevant paragraphs of that decision, the court will find, it's paragraph 70 and paragraph 72. And if I can just deal with Albert. In Albert, the court will recall it was the president exercising the power to pardon the offenders in terms of Section 84 of the Constitution. And these are the offenders who had not participated in the TRC process. And the court applied procedural rationality principle because it said the purpose for which the power was exercised, i.e. to pardon the offenders, had two objectives that it sought to serve. The one was nation building and the other was reconciliation. Who are you reconciling with if you are not hearing the families of the victim? And from a process rationality, perspective, not procedural fairness again, the court set aside the decision. We've cited Law Society in our heads. We asked the court to look at it. The withdrawal from the international treaty by President Zuma, former President Zuma. The court will see why that thread cuts across those, but they do not, as it were, or as contended for by ETV, create a self-standing right. Justices, there is the issue of freedom of expression, and I'm looking at the time. I've illustrated why freedom of expression is not engaged, and I have no doubt that Vodacom will deal with that issue. We have made submissions in our heads, and I have spent time on the facts to illustrate why the right is first and foremost not implicated. And if it's not implicated, then the principle does not apply. But importantly, there is a Section 27 right which has been raised for the first time in the replying affidavit. You recall the right to social assistance. It is framed it's raised for the first time in ETV's reply. And it's important that I deal with it because Mr. Marcus, with reference to the constitutional rights, he kept saying, well, these are uncontroversial. Yes, they don't become controversial if you've raised them in your founding affidavit, but they're controversial if you've raised them in your reply because there's no opportunity for the minister to deal with them. But just simply illustrating the principle in the Section 27 1C right, which each TV raises for the first time in its replying affidavit. We wish to refer the court to the following two decisions. We've cited the decision of Khoza and others versus the Minister of Social Development. It's 2004, Volume 6, SA 505. It's a decision of the Constitutional Court at paragraph 52. And simply, that decision says, the right of access to social security, including social assistance for those unable to support themselves and their dependents, is entrenched because as a society, we value human beings who want to ensure that people are afforded their basic needs. So it regulates a basic need. A society must seek to ensure that the basic necessities of life are accessible to all, if it is to be a society in which human dignity, freedom, and equality are foundational. And that principle must be located in another decision. But perhaps let me just save time. If you go to the right itself, Section 27 1C, you will see that what the right involves, it says everyone has the right to have access to social security, including if they are unable to support themselves and their dependents, appropriate social assistance. And this case, we respectfully submit, has nothing to do with the right to social security or social assistance. These rights are about ensuring that people have basic necessities that are needed to survive and live a dignified life. Like other socio-economic rights in the Bill of Rights, housing, healthcare, food, and water. And those are the right to social security and assistance, which are classified as first-order needs. For ETV in its reply to seek to elevate the right to receive analog service to the rights under Section 27, we submit is a belated attempt to bolster its case because it realizes that it has pleaded a weak case in the founding affidavit. So this case premised on Section 27, apart from it being wrong on the facts and the law, it was inappropriately raised and ought to be disregarded. We've addressed Section 7.2. May I not deal with that? And may I just take an instruction regarding Judge Lukai Mani's issue, just to check whether my team has dealt with that issue. I would propose that will be the last issue, unless the court would wish me to address other aspects.
Only one, Mr. Mutau.
Yes.
Only one. Only one. You know, I raised the issue. Hello. I raised an issue with Mr. Marcus. I raised an issue with Mr. Marcus that he is the Dominus Litis. And if there is any information or statistics that he relies on, he is supposed to come with that information. And the answer was that no, this is the minister must give all this information. Now that we have from the minister to say you only made an offer to the public, to the people who register, and you are committed to those people who register. And the case of the ETB is that there are millions, 8 million people that have been cut off. So it means, because we know that ETB simply says, okay, out of the pool of 3.7, 1 million applied, and there is 2.5 million out of the pool who did not apply. Multiply that by 3.3, it gives you 8 million. I know I've been addressed there, shouldn't it be the ETB that comes with those statistics if that's what they're relying on? I don't want you to belabor the point. I just want to hear if you agree with me or not.
Well, Justice Msimang, thank you for that question. You'll recall I confined the issue to deal with the promise because we know that the promise creates the obligation. We have indicated why those numbers are the numbers read in the context of the policy. ETV says more people. In other words, ETV doesn't accept the minister's approach, and it is again seeking to protect its commercial interests by wanting its viewers to ride on government's infrastructure. And that is why it seeks to posit numbers that are not justifiable, because your yardstick is the policy that sets out the criteria and registration. To the extent that ETV wants to rely on additional numbers, it is entitled to do so. But those numbers are not helpful if ETV doesn't show that those numbers are of people or households that qualify in terms of the policy, that have applied, and who are entitled to registration on or by 31 March. So that's the short answer to that. And perhaps might I just take up this issue? I've indicated to the court that the minister's tender still stands, not for purposes of defeating the dismissal of the application, because the application it ought to be dismissed. But Mr. Ferreira asked yesterday submitted. He said, well, for the reporting relief, forget whether it's drastic and it encroaches on the separation of powers, because the court now tells government how to regulate its business and affairs in circumstances where no case has been made out, because this 8 million has not been brought into the policies. But the minister, outside of that, in other words, the minister doesn't just stop there and say, well, dismiss and that's all. Says, but I saw yesterday that the court might be concerned that I might not meet this deadline. The dismissal of the application should note that my tender to still provide a report to the court. Because you recall Mr. Ferreira said, well, the report is submitted not because the court must do something about it, but it must go into the court file. And because this is an adversarial process, applicants or parties that are affected thereby will then uplift the report, and using the adversarial system, the applicants would come back to court. So there is that inbuilt mechanism from which the court can also take comfort. In other words, the minister has said, I've looked at it, this is the plan, this will work. But I'm not stopping there. Hold me liable. In other words, I'm building into this process. Take the tender, not in terms of the report relief, but the court should build into it for its own comfort and to enable the applicants to still come back to court in terms of, and I'm taking Mr. Ferreira's submissions. The court is not supposed to look at it. It will be put in the file, and parties that are affected thereby will take it and use it to come to court. So that should, we submit, adequately take care of any concerns post the 31st of October.
Mr. Miller, just a question on that. I put it to Mr. Ferreira when we were having that debate. Just your submission on an order, taking paragraph 10 effectively and saying, the 507251 must be installed by, the March dates that are indicated there.
Let me make it easy for Mr. Mutau by 31 May.
Yes.
No, the minister says all this can happen by, some of it even by 20 March. But let's say by 31 March.
Yes.
An order that said, Free State, 34,294 households by 31 March.
Well, Justice, it's not even necessary to make that an order. The court can justify the basis upon which it dismisses the application. So in other words, you don't grant an order for purpose of dismissing the application. You dismiss the application and you outline the reasons thereof. So in other words, there are these obligations and commitments that the minister has made. Under oath, we have taken the minister on her word. We dismiss this application based on those undertakings. And if those undertakings are not going to be kept for some or any reason, it will have a bearing on whether this court ought to have been, this order, well, the order sought by the applicant ought not to have been granted. And we are then in the realm of possibly one of the ministers who finds herself in a position where she's perjured herself and all sorts of things. And you can imagine that based on that, there would be a basis for agency, an urgent application, and a mandamus, and all sorts of things that would follow. So the law takes care of that scenario. So in other words, the fact that the minister has put up the numbers and the process, and that there is some doubt to the court, that's not, in applying Clascon-Evans, a valid basis in which to say, well, based on our reservations, we don't trust this, and we're not going to then take the minister on her word. Rather look to the rule of law and the other protectional mechanisms that Mr. Ferreira told you are available, not linked to the remedy, but the court can give its directions. And perhaps the one point I didn't illustrate is there was some debate, there was some hinting of why would a review on its own not be sufficient and not with a declarator. Here's the problem. The minister's decision is taken after the close of pleadings. The reasons for the decision for the minister are not before the court. You'll recall in review law, it is open to an applicant to waive the record of documents, but it can't, in that waiver of its record, prejudice the minister and not afford the minister an opportunity to explain her decision, which is sought to be impugned by way of judicial review. So that is why that order is inappropriate at the level of those facts, because there is nothing in the papers that require the minister to file some or other affidavit that deals with a decision that she has taken, which she took after the papers have closed or the pleadings have closed. Because naturally, that decision, she says, I took it pursuant to a consultation process that was unfolding parallel to this. And those reasons, including why Parliament accepted, Cabinet, I apologize, why Cabinet had given its concurrence and approval for the ASO. So those issues are not before you. It would not be competent, both as a matter of fact and law, to grant that review based on the doctrine of inappropriateness. If I might then just take an instruction on that last issue. which I was hoping to cover by way of this backstop position and the undertaking in any event, that it ought not to concern and or detain the court because of that inbuilt protection of the tender, which we hope the court will take and build into the judgment. So in other words, that tender would sufficiently address Judge Lukaimani's concern because it absorbs all of those numbers. And the commitment that 572, which Judge Leroux was asking whether should it not be an order, and I said, well, it's not really an order, but it's really in the body of the judgment, i.e., the ratio of the judgment, so that it is clear that it is not obiter. It is the ratio of the decision, and the court will make clear. But for these undertakings and this assurance we were given, we received from the minister, we would have applied the KZN principle, we would have applied the policy, and we would not have allowed the minister to go ahead with this process, so that it is clear what the consequences of that, of missing that deadline is. I didn't deal with
the order, Mr. Mutau, the tender of keeping it open.
Yes.
I wonder if you've got. I know the minister has said that, yes. But are you saying that all the tender is open ad infinitum, or should it? There should be a deadline. I mean, at the end of the day, because I don't want us to make an order. And someone comes to you after 10 years and says, but here is the order, and that's your undertaking, because this is the promise you can't break if it's an order of court. Shouldn't you consider the tender of openness to have at least some limits? Because I'm worried if it's open and it's a court.
No, I'm grateful for that question. Justice Nsimang, you'll recall that the tender was made clear that the minister says within a period shortly after the expiry of the date. So in other words, you can't keep it for longer, because the longer you keep it, if there hasn't been compliance, even along the lines put by Justice Lukaimani, if you extend it, let's say, for example, for 3 weeks, it means that breach or infringement can't be fixed. So you can't stretch it out for much longer, because the longer it is, it doesn't serve the purpose for which it is made. So the understanding, I mean, the court can say within a period of 2 weeks, I'm assuming, after the judgment, so that statistics are collated and so forth. I'm just giving that as a suggestion because of the bona fides that the minister is demonstrating. To the extent that it is still necessary to deal with Judge Lukaimani's point, let me do so. But I qualify that whatever I receive by form of instructions ought not to concern and or detain the court, because there is that greater undertaking which ought to, or through which the minister's conduct will be assessed and evaluated. If I might just be allowed to take an instruction?
Yes.
And perhaps we should check in with everybody how long they think they need, given where we've got to in the debate, and if also maybe a short comfort break once Mr. Matar has completed with his instruction. I don't know.
I do. I need half an hour to get fresh air. I must stretch my back and my legs. I say I need half an hour to get fresh air.
Okay. There shouldn't be a difficulty as long as you pledge to sit until we finalize the matter.
That is so. I pledge to sit until we finalize the matter, but if I don't walk and get fresh air, we might not sit. You might see me disappearing under the table.
No, we don't want that. We don't want that. Let's wait for Mr. Mutau, then we'll have a short adjournment.
Yes.
Justices, that's the only one question that I'm going to address. Might I ask the court's leave that perhaps we take the adjournment and I can understand
No, we can proceed now and take the adjournment out. You can address it now.
Yes, Justice Lukaman, the point I was trying to make is that I have yet to discuss the issue with my team. But as I indicated, there are two things that flow from that. It does not need to detain the court. In other words, until I've resolved that issue, it need not detain the court in terms of the order of presentation. ICASA can present, Vodacom can present, I can come before the replies to the extent that it is necessary that I deal with it. But this is the main point, the second point. Whatever becomes of that issue, we submit an issue that is already incorporated into the tender that has been made, i.e. for the minister's obligation to ensure that people are connected by the 31st of March, and those being people who had applied and qualified. So that's it. That's why I'm saying, Justice Lukaman, we shouldn't just...
That's fine. I understand what you are saying.
And say for those submissions, we ask for the dismissal of the application, the incorporation of the tender, and we ask that costs should be awarded at a scale of costs to include costs consequent upon the employment of 3 counsel. That's what ETV also asks for. SOS and MMA, for their part, they rely on the BioWatch principle. We'll leave it up to the court to determine the applicability of BioWatch in this case. I've illustrated the common factor that they participated on the side of ETV in the previous litigation. They lost. They're coming back after ETV has changed its stance from accelerate BDM to slow it down, and in fact not allow it to go through at all. If whether that conduct requires censure, we will leave it in the hands of the court, unless there's anything else.
Insofar as costs are concerned, Mr. Muto, I'm asking costs for all the council. I see virtually all the teams here, the biggest teams I've ever seen assembled, and your team has got. Where am I seeing? I think it was.
Yeah. No, Justice. If I might just if I might just assist. ETV also has a big team, but they're asking for 3 counsel. We are also asking for 3 counsel.
For 3 counsel. Okay.
Both sides.
Mr. Matawa, I just wanted to know what you're asking. Thank you, sir.
Thank you.
And maybe we are done. Unless my sisters want you to say anything, then we can take the adjournment.
I think Judge Leroux wanted to estimate time before we take a break. I think you wanted everybody to sort of say how long they estimate they need, or am I mistaken?
No, I do think that would be a good idea before we adjourn, so that everyone who's still to come can also try to use the adjournment to really focus what they're going to cover. So maybe we should do it after. Maybe we should let them use the adjournment to really work out and then let us know.
Okay.
Well, as a court, please. Yes, this is William Mukari. Well, in these proceedings, the matter was set down for 2 days. Applicants take the 1.5 day, and then everybody must be put under pressure. I think that's really not really fair. So maybe what we must look at is, are the judges available tomorrow and other parties available tomorrow? Because I don't think it helps that, this matter is treated as an urgent application which must sit until midnight. Mr. Snackers for Vodacom, we've seen that they've put a very extensive affidavit and hates, and they're still going to argue. I'm still going to argue. So maybe then if we can look at that option as well, instead of really the court sitting over the night. The applicants themselves, they allocate a day and a half with them to themselves in a matter that's set down for 2 days. So maybe that's what we can look at. I've spoken to Mrs. Naika.
Yes, Mr. Mukari, yeah, maybe you're making a valid point. Maybe that is why we must take an adjournment and come back. But insofar, I've been thinking about you, Mr. Mukari. In fact, I thought of mentioning it even when Mr. Marcus was addressing us. Because Mr. Marcus says no order is sought against your clients. And if no order is sought against the second and the third respondent, I wonder why we didn't take it up to say why are they here then? Why did you bring them? Why did you cite them in your papers? In fact, I thought before we began today I would mention that, but it slipped my mind for one reason or the other. So in view of the fact that no order is sought against your clients, what's your take on that?
Yes, I mean, I obviously appreciate what Mr. Maka said, that he seeks no relief against us, but was still opposing the application. So we are opposing the application and we'll be making submissions. And of course, they correctly cited us because they are aware that we have a direct and material interest in the relief that they seek. So the mere fact that they left us out in the last notice of motion, but they had us in the previous notice of motion, it doesn't really change the picture. The picture remains the same, that we're opposing the application. But in terms of the order of submissions, I spoke to Mr. Snikers that for Vodacom that he'll come in first if the court permits, and I'll come in last. But basically, we are opposing the application.
Yes, and I think from our side, we came ready to hear you today. So I think we have set some time after 4 o'clock to hear you. That doesn't mean that you will be rushed or anything. It just means that at a certain point, we will assess whether to proceed or not. But I think, to say we break now and reconvene on another day that might take us even longer, I don't think that I'm in support of that.
No, I'm not talking about another day. I'm talking about the role. I'm talking about the rolling matter. Well, of course, that depends on availability. Council, most of the time when they reserve for 2 days, then they've got something the next day. So that's why I thought that is something that councillor involved may look at as Justice Msimang has proposed, that let's use maybe this adjournment to assess availability. But of course, if other councillors are not available, the best thing is to proceed until we finish today.
Yeah, just for the benefit of the parties and my brother and sister, I have other matters set down on my roll starting tomorrow. So given the 31 March issue, I would rather that we sit however late we need to sit tonight and hear the arguments. Yeah, so I mean, Justice, your unavailability already then makes it, the way it takes it off the table anyway. So it means we just have to proceed. Because if one of us is not available, then it means we must just proceed. So there's no need then to even say we'll discuss it over the break time. But as soon as the Snikers has showed up, maybe I want to say something. Thank you.
Thank you, my lord. Thank you, my lord and my ladies. The question is that if it were so that the members of the court and council who are still to be involved were available tomorrow, it would be preferable for the orderly hearing of the matter and for our being heard properly for the matter to stand and to continue tomorrow. If it is impossible, then we are also available to carry on until whatever time it finishes tonight. But then we do ask in the circumstances that the fact that the other parties have taken 1.5 or in fact 2 full days not be a reason why we are not heard properly in the time that we want to present. Yeah. I have about, as I said, and I've looked at it, I have about an hour that I need. Obviously, it depends on whether there's a lot of debate or not, but I probably have about an hour. It's very difficult to say, but mine is about an hour. I have no idea how long the applicants want to reply for, and I understand Mr. Mokari is probably going to be about half an hour, maybe even less. But it's simply a matter of facing the realities. Everybody's tired. Everybody's had a long time, and if it were possible to carry on tomorrow, that would be preferable. If it's not possible, I'm perfectly happy to carry on until midnight or until we'll go through the night, if that's possible.
Insofar as I'm concerned, I am available tomorrow, but it's clear that not everybody is available tomorrow. And then we should just have this adjournment and see if we can be able, I'm sorry, there are always Mr. Snipers, to squeeze you in.
That's what I'm afraid of, my lord.
No, but
No, you won't. We will sit right through.
just another practical suggestion, but it only would address my constraints tomorrow. I mean, my role tomorrow, because one of the council in that matter is in a leave to appeal, is only starting at 10:30. So there is a world where we sit tonight until, I don't know, 6:30, see where we get to, adjourn, and then start 8 tomorrow. It's not ideal.
The risk is if we don't finish tomorrow. I think that is the risk.
I hear you.
Maybe let's have an adjournment. That is why really I didn't want, when we started, I really did not want council to allocate themselves time, because the council allocates themselves will be there for 2 hours and then will go on and on and on. That's what happened yesterday and that's what happened today, notwithstanding those undertakings. But let's adjourn let's adjourn for 30 minutes as my sister asked, and then we'll be able to see what we can do there.
Thank you very much.
Yes, then we'll adjourn, the court will adjourn.
My Lord. I don't know whether Mr. Motau, did he want to say something, or because he's
yes,
on?
yes,
Mr.
please.
Motau wanted to say something.
Yes, please. Yes, thank you, Justices. I had undertaken to obtain instructions to deal with Justice Lukaimane's point. Justice Lukaimane, I'm not able to make submissions on that point because I needed clarity, and I'm told people that I needed to interrogate are not available now, and I didn't want to make a submission which may later on get me into difficulties. So perhaps this is just an overarching submission. The question of the undertaking, as I've indicated, ought to adequately address that issue, because what we lose pre-dismissal of the application, we stand to gain within 2 weeks in the event that the department's word was not good and it did not keep to it. Those are submissions. Thank you, Justices, and thank you to my learned friends.
Thank you very much, Mr. Mutau.
Thanks, Mr. Mutau. Mr. Snakers?
Yes, my Lord. My Lord and my ladies, I have worked to avoid repetition of my learned friend Mr. Motau's points, and what I do ask for is an indulgence to allow for the development of arguments, because you will note that some points are made in outline that are coloured in later when the argument is developed more fully and when elaboration is given. So often some obvious retort that is not at first addressed is addressed in due course. So often the question of, well, what about X, will actually reveal itself if one just waits a little while, I promise. So if I can have a little indulgence then on developing the argument. At first, from Vodacom's point of view, it is critically important to distinguish the review of the decision setting the date for analog switch off on the one hand, and on the other hand, the attempt to legislate for preconditions for digital migration. This is now the interdictory relief, particularly in paragraph 3 of the notice of motion. Declaring it unlawful for the minister to effect digital migration unless and until everyone is given set-top boxes, i.e. interdicting digital migration until the last set-top box has been delivered, whenever that may be. Vodacom's concern is with this latter relief. Vodacom's concern in this address is not with the relief in relation to the date and the review of the date. I will deal in detail, or at least specifically, with the extraordinary concession by Counsel for ETV in its address that the literal terms of the interdict that they seek are, quote, childish, unquote. The literal terms of the interdict that they seek in paragraph 3 are exactly that there must and cannot be any digital migration unless and until every person affected is given means by means of the set-top box to have the digital migration. This is the relief that our learned friend Mr. Gilbert Marcus described as childish. Now, the case for Vodacom is that whatever the merits of the review of the date decision, in relation to which our learned friend for the minister made powerful submissions as to why it should not succeed, whatever the merits of that review decision, there is no basis for the interdict against governmental power, and the setting of preconditions and the bases invoked for this by ETV and the interveners are weak, and they are premised on a clear and demonstrable central fallacy. Against this, the court should consider the effect of the interdictory relief if it is granted. And I need to consider that in quite a bit of detail, because that's something that's fudged, especially in the address, and there's some attempt in the papers to poo-poo the effect that it may have on the release of the spectrum. It is this threat to the ability to free up the spectrum for cheaper data use for all South Africans. The relief entails potentially devastating consequences for ICASA's ability freely to assign urgently needed spectrum for its best uses, with concomitant heavy losses to the economy and a hampering effect on meaningful steps towards actual realization of true enjoyment of freedom of expression on the part of the poor. ETV says that Vodacom, ICASA and the minister rely on what they call a false dichotomy. They say this idea that the use of the contested spectrum for broadcasting or for international mobile telecommunication use, IMT, is a false dichotomy. It is important for Vodacom to stress to the court how very real this dichotomy is, and that the glib retort that it is a false dichotomy is an attempt to pull the wool over the eyes of the court. Whatever this court does as a result of this application, it should be in no doubt of the effect that the interdictory relief sought by ETV will have on the ability of ICASA freely to assign the spectrum in question. It should not be left in any doubt under the consequences that wreaks and the threat that that has for the auction that is underway, that is currently under challenge in court. And we will examine that dichotomy in some detail. The real false dichotomy in this case is the basic fallacious premise which underlies the interdictory relief. The premise is that freedom of expression is set up as a dichotomy against expediency and the privileges of the rich. And this is best illustrated in paragraph 48.3 of the heads of ETV. I could just look at that. That is on page 021-70. Paragraph 48.3 best illustrates this remarkable idea. Vodacom's argument, this is what ETV says, Vodacom's argument is a cynical one, which is impermissible in our constitutional democracy. Essentially, Vodacom argues that those who are reliant on analog broadcasting, overwhelmingly the poor, are simply less important and should make way for those who utilize high-speed mobile data, overwhelmingly the rich, to have even ever more and ever faster data. Of course, the entities that will benefit the most from this trade-off are the mobile network operators themselves, and particularly Vodacom, which is by far the largest and the dominant provider of mobile services in South Africa. While mobile network operators want to push through the door to reach the spectrum their shareholders and users desire, our Constitution does not permit them or anyone else to do so callously by trampling over the indigent and vulnerable who rely on that spectrum to access analog TV for their news, sport, weather, and entertainment. This is the dichotomy, and it is a false and rather mischievous dichotomy. The dichotomy is the foundation for the Section 7.2 obligation, which ETV says is the core of its case for the interdictory relief. The government has an obligation under Section 7.2 of the Constitution, quote, to respect, protect, promote, and fulfill the rights in the Bill of Rights. So this now is the foundation, because this dichotomy is freedom of expression of the poor against the rich and Vodacom. This creates the obligation to respect and promote freedom of speech, and this in turn relies on the right to social assistance. The reasonableness standard that ETV then seeks to apply to measure the conduct of the minister in the instant case is a standard that arises through this Section 7.2 general obligation to respect, promote, and fulfill the rights in the Bill of Rights. So the Glenister case is cited in support to say this measures the extent to which the obligation is met. So this also rests on the central premise of setting up freedom of expression rights on the one hand and governmental expediency or the interests of the rich on the other. Now this premise is just wrong, and with great respect, remarkably so. At issue are contesting ways of using scarce public resources, i.e. spectrum, in promoting freedom of expression. It is all about communication. This is ETV itself recognizes this in paragraph 60 of its heads, page 02173. I'll read that. 02173. It says, in summary, in terms of Section 7.2, the Minister bears positive obligations to effectively manage communications in South Africa and to take reasonable steps to promote, protect and fulfill rights in the Bill of Rights, including the right of freedom of expression. And we say, yes, exactly. It's about ways of promoting communication and freedom of expression through communication. And in relation to that, there is no privilege for television, especially not for private content television by a concern that makes its money out of advertising. The vying communication channels or the freedom of expression benefits from the contested spectrum are, on the one hand, cheaper access for a very specific group of viewers, and I want to examine that very specific group. Cheaper access for a very specific group of viewers to a very specific commercially operated TV content, on the one hand, and on the other hand, cheaper access to data and communication via their cellular telephones for all South Africans, including the group of viewers on the other side of the equation. Now, which is closer to promoting freedom of expression? Well, does the Constitution dictate which is to be preferred? Because that's the job of the court. Does the Constitution somehow answer this question? No, it doesn't. If it did, we say though, the question would be answered in favor of cheaper data. It affects everyone, and it affects the poor more directly in their ability to communicate, and more poor people, than cheaper access to ETV's television content would. But whatever the objective answer to the question, which of the contesting modes of greater enjoyment of freedom of expression rights for the poor has a superior claim to being promoted through being given use of a scarce public resource, the executive policy decision on this question can never be second-guessed by the court as being legally wrong, as if the Constitution demanded that this question be answered in favor of ETV's television content and against cheaper data for all. Now, all the rights off which this 7.2, the Section 7.2 obligation is launched, rest on the premise that cheaper television access is closer to freedom of expression rights than cheaper access to data for the poor and for those affected. So if you look at ETV's heads, paragraph 67, page 02177, dignity and political rights, they write on freedom of expression as being a gateway into these rights. And all of that is 100% correct. But it applies as much and more to cheaper data access than it does to cheaper access to the privately offered television content of ETV. Procedural rights in paragraph 68, this is important. The procedural rights relied on, that's in paragraph 68 of their heads, page 02178, administrative and legality rights and openness and accountability. These have nothing to do with the interdictory relief. Can't rely on those procedural rights to found the interdictory relief. They may be relevant to the review of the date, but they have nothing to do with the interdictory relief. Then one has this extremely tenuous reliance on section 27, the right to social assistance, paragraph 71, which is at 021-80. Mr. Motau dealt with that effectively, if I may say so. Again, if this right can seriously be said to be applicable in the resource allocation decision, and I'm not saying this lightly, if this right can seriously be said to be applicable in the resource allocation decision on use of scarce spectrum, then it is more directly triggered for the greater number of poor South Africans in cheaper access to data than in giving a special class of viewers access to particular television content, that of ETV. And it's clear from the case law that the right to social security relates to progressive realization of ensuring that people are afforded their basic needs, as Mr. Motau developed, the subject being, quote, the basic necessities of life, unquote, in the case law of Khoza and Mahlangu. And that cannot seriously be stretched to encompass a right to subsidized access to ETV's television offering. And again, if this right is in any way implicated in the tussle over spectrum use for ETV television content or for cheaper data access, the latter has a far less far-fetched claim to being closer to basic needs than the former. Now, if I can elaborate on the contest over freedom of expression, ETV or cheaper data. The first point is the peculiar class which is at issue here. and we refer to our heads in this regard, paragraph 72, page 21, 215. So 021, 215. We are dealing here, what are the people at issue in ETV's protection range? Number one, people who own televisions. There's this massive gap here. ETV has got absolutely no concern for people who don't have televisions. So if you don't have a television, you're out. Then there's no problem, because nobody suggests, not least ETV, that there is a right to a television. So if you are so poor that you cannot afford a television, which is a reality for many South Africans, you're out as far as ETV is concerned. So number one is people who actually own televisions. Number two, it's people who own old and outdated technology in their televisions. So those who have televisions with analog. Then it is people specifically who own televisions, but who qualify for earning less than 3,500 Rand a month per household, and who have failed to register for their set-top box despite being eligible to do so, and who will get a set-top box, but will get that set-top box after ASO and not before. That's the special class at issue. You've got to have a TV, you've got to earn less than 3,500, you need to have failed to register, and you will get your set-top box, but you will get it after ASO. That's what's at issue for them. It excludes those who have no television sets at all, and it excludes SABC viewers. Now we hear that, well, what about all these SABC viewers? The SABC is switching off. The SABC is buying into digital migration as the responsible public broadcaster will. It is switching off. Nobody is interdicting the SABC from switching off. Nothing that the court decides today can stop the SABC from switching off. It is switching off. So the idea that the SABC's viewers somehow are being dragged into this and can ride on the ETV application with respect is a wrong one. Nobody can purport to claim or speak for them because the SABC is switching off. And in fact, and I'll develop that a little bit later, ETV actually relies on this heavily for its false dichotomy case. It says, well, the SABC is switching off. Look at all that spectrum that's becoming available because the SABC is switching off. So relying on that is making it a virtue for saying, well, you know, it can stay in this position that it occupies because the SABC is switching off. Then you have the numbers game and the fiddling with the numbers. Now we've had that to and fro, and in the debate, what has emerged are three serious problems, and it is a problem that Mr. Justice Msimang and Madam Justice Leroux and also Madam Justice Lukomani constantly came back to. The gaps in the numbers. There are three populations here in the gaps, and they don't speak to each other. There's the population of households who are under the 3,500 Rand cutoff for assistance. That's the one population. And that's given the number of them being 2.5 million left out of the 3.7, etc. Now the problem with that number is it doesn't begin to tell you how many of them have television sets. So that can't be a basis for indicating that that number is any particular number of people we're dealing with. As has been said a number of times, all that tells you is that they're poor. A lot of them may well have digital access. One just doesn't know. A lot of them may not have television sets. So that's the first problem with that number. Then you have the 36% number. The 36% of viewers who are currently obtaining their television content from analog transmissions. All that tells you is that's what they currently do. 36% currently get their TV content from analog transmissions. It doesn't tell you how rich they are. It doesn't tell you whether they are able to buy digital TVs if they want to. It doesn't even tell you whether they have a digital TV that they haven't switched on. And it doesn't tell you whether they can afford set-top boxes or not. All it tells you is that 36% are currently doing this. Then you have the 65% of viewers that make use of free-to-air access. So we know 65%, that's the 13 million figure that the original decision was based on. Well, that doesn't tell you how many of them have this access via analog. So telling me that 65% do it for free-to-air, we know that the idea is for free-to-air to be done via digital, and many people have been able to do so. So no breakdown is given of how many of these people are ETV viewers and how many are SABC viewers affected by the SABC switch off. Because the SABC, I don't want to say it too many times, the SABC is switching off. Now the interdict is now sought to be granted. This court is asked, and seriously asked, to grant this interdict entirely in the dark as to its effects. And I'll revert to this below. But this is what this number problem creates, is to say, just throw in an interdict. We don't know what the numbers are. Mr. Marcus says we have no idea what the numbers are. Mr. Du Plessis says it's the minister's problem. It's not our problem. They're asking for the interdict. And on the other side of the tussle, the freeing up of the spectrum, we know, will achieve lower data prices, which specifically assists the poor and affects millions more South Africans directly in their freedom to communicate meaningfully. And this is not disputed in the papers. And I can take just a few portions of the papers to indicate why I say what I'm saying. The Vodacom answering affidavit, paragraph 44, that's at 00621. 00621. It says, paragraph 44, a fundamental point for present purposes is that once it has increased its spectrum capacity and reduced congestion, Vodacom will be able to price more aggressively without this impacting negatively network quality. This will lower data prices, thus strengthening competition and improving the benefit to consumers. This court cannot lose sight of the fact that there is a strong correlation between spectrum availability for IMT on the one hand and lower IMT costs on the other hand. This impact on the average South African citizen's freedom to communicate makes the impact ETV complains about of an ability of its viewers to view its television content more cheaply pale into insignificance when it comes to the relative impact of contested uses of spectrum on the right of freedom of expression. And then paragraph 47.4 on page 006-24, again, fundamentally for this application, it is economically axiomatic that further availability of spectrum that can be put to good use will boost capacity and coverage and decrease costs per megabyte, all of which will enable the downward movement of prices to the benefit of the consumer and their realization of the freedom to communicate effectively. And this is not denied in the replying affidavit. One gets pejorative comments about Vodacom not being alive to the plight of the poor. And in paragraph 125 on page 02061, one gets specifically the allegation that data costs are high. Not placing in dispute that access to urgently needed spectrum will significantly cheapen data costs for all. In fact, the most telling response for ETV is from the person describing himself as the in-house economist of ETV's attorneys of record, Mr. Ngwenya, commissioned to respond to the economic report submitted for Vodacom by Frontier Economics. Frontier details the downward effect on data prices that would result from freeing up spectrum for IMT use. See, for example, paragraph 2 under 3.3 on page 007-17. So 00717 in the Frontier report. With higher capacity, operators would be able to adopt a more aggressive pricing strategy and to acquire more customers, as Telkom currently does given its abundance of capacity. With more spectrum, all operators in the market are likely to have the ability and incentive to reduce prices. In a footnote, This is because all operators have an incentive to price in a way that uses up their network capacity, whilst maintaining a quality of service that is consistent with how they position themselves in the market. What does Mr. Ngwenya say about this, and what does he not say? Now, in paragraph 12, on page 02187, he says,
Sorry, Mr. Stickers, 02187.
020-187. So sorry, 020-187.
Thank you.
He says, moreover, the Frontier Economics report assumes 100% pass-through in cost savings from spectrum allocation to consumers. This is an unrealistic assumption which potentially significantly overstates the alleged cost of delaying digital migration. First point is, nowhere is there such an assumption in the Frontier report. It's a completely unfair straw man, but more significantly, Mr. Ngwenya does not in any way dispute the central proposition that more spectrum allocation for mobile telecommunications will have an appreciable downward effect on prices. So this is therefore common cause. Cheaper data is on the other side of the tussle between ETV and the telecoms industry on the use of contested spectrum. Nor can it dispute the obvious point that the poor gain the biggest marginal benefit out of cheaper data use. In addition, Mr. Ngwenya confirms that what is essentially at issue is a tussle or resource allocation and welfare distribution flowing from the use of spectrum. So if we look at what he says in paragraph 5 on page 020183, he says the transfer of spectrum from broadcasters to mobile network operators inherently involves the transfer of productive capacity, which is currently used to produce a quasi-public good in the form of free-to-air television, to the production of paid-for data consumed by the customers of mobile network operators. As discussed in the affidavit of Philippa Rafferty, such a transfer of productive spectrum will inherently leave a significant proportion of poor South African households without access to free-to-air broadcasting. This is a significant negative externality that will impact the poorest households in South Africa over an extended period. So it's a tussle about this transfer of welfare, and he says it's a paid for versus free tussle. But with respect, on both sides of the supply at issue, this is the supplier operates as a private concern for profit. ETV makes profit out of advertising it sells on its privileged access to the spectrum at issue and the viewers or eyeballs that it gets. And on the other side, the mobile operators like Vodacom derive a profit from their users' fees. The real issue is on the other side. The consumer who happens to own an analog television set either gets cheaper access to ETV content via a subsidized STB, or the consumer who makes use of cellular services gets cheaper access to data. Both entail a degree of transfer of welfare to the relevant consumer. The question is which affects communication more directly and which helps more of the poor more directly. The Constitution does not answer this question for a court of law. But if it did, it would prefer cheaper data for all. Also significant is Mr. Ngwenya's response to the analysis by Frontier of the quantifiable benefits to the economy in terms of the growth of mobile telephony. They rely on a doubling of mobile data leads to an increase of GDP per capita of 0.5%. Now, Mr. Ngwenya quibbles with the study and comes to the remarkably tame conclusion in paragraph 19, that's at page 020191, that, quote, the use of the 0.5% figure in the Frontier Economics report would be likely to overstate the impact of doubling data usage on the South African economy. It's telling that this does not take issue with the fact that the impact would be significant, whatever its precise quantification, and there's no suggestion of any similar impact in relation to continued access to analog television content. What it comes down to is that what is at issue is a matter of contesting ways to support different modes of free expression. There is no right to a TV, and there is no right to a cell phone. In relation to both, one needs to buy a device. either a television or a telephone. Many cannot afford to do so. ETV does not cater for those who cannot afford televisions. In both cases, the right to communicate is indirectly affected by the polycentric decision of allocation of the spectrum resource. The decision in question does not bring an end to ETV's rights or to the rights of its viewers. The viewers at issue comprise a very specific group, those who have televisions, but the wrong ones, qualify for an STB but have failed to register for one despite being able to do so for several years, and will therefore get the STB after and not before the ASO. ETV continues to be able to broadcast, and its viewers have the right to receive. What is at issue is the means to do so, of a very specific part of the viewership, and the timing of a governmental commitment to subsidize their means. That is all. That is all that is at issue. There's this extraordinary sense that at issue is some other right, not even to subsidized access, because they're going to get subsidized access. So there's no quibble about the fact that the government is going to give them subsidized access. So all who qualify will get this in the end. But there's some sense here's a right to some kind of seamless, uninterrupted access, despite not having taken the steps required to benefit in this way by registering. So in the circumstances, ETVs is a remarkably specific and a remarkably ambitious demand. Given that there will indeed be subsidizing of STBs for all in this group that ETV seeks to protect, the demand is nevertheless that government cannot take a critical prioritizing resource allocation step before all have been satisfied with their STBs. Not saying they won't get them, and they're not saying that the government will not fulfill the rights claimed to be affected progressively. Then there's a reliance on property and license rights. Not much needs to be said about that. License rights are always subject to the governmental and ICASA regulatory framework, which provides for digital migration and has done so since at the latest 2009. And even if there were a deprivation of a property right involved, one can never say it is arbitrary. Here the test that was applied in the ShopRite Checkers case, if I can just give the reference, ShopRite Checkers and MEC Economic Development of the Eastern Cape, 2015 6 SA 125cc, paragraph 82 in the main judgment of Justice Froneman, where the regulatory legislative deprivation viewed objectively would extinguish the right of choice of vocation or any other fundamental right, would extinguish it for constitutional value. Arbitrariness must, in terms of FMB, be tested against proportionality. In other cases, rationality will be sufficient reason. Here, digital migration has been on the cards since 2009 and was supposed to have been completed by 2015 under South Africa's international treaty obligations. ETV could have had no reasonable expectation beyond 2015. The freeing up of spectrum for IMT use is urgent, and we've seen serves the same rights, at least arguably more closely than keeping spectrum reserved for analog TV broadcasting content of ETV. Nothing is being taken away from ETV. At issue is its demand that viewers who will in fact be subsidized to gain access be subsidized before the migration occurs rather than after. The effect on ETV's property rights must be marginal and tangential at best. If I can then turn to this supposed false dichotomy. Now, the clash between IMT and ETV on 700 and 800 spectrum is real and far-reaching. The false dichotomy instances are given in the replying affidavit, and it's also repeated again slightly truncatedly in the heads in paragraph 50 on page 020, 30 and following. So the first point that is made is, in other words, the false dichotomy is to say you can actually have both. You can have what ETV is demanding, and you can have use of the spectrum by the MNOs for mobile telephony. The first is they say the ITA auction is happening, and, quote, a significant amount of spectrum is being auctioned, including in the 700 and 800 bands. So, in other words, so what's the problem? Now, it's important to draw some distinctions here. The first is a distinction between auctioning of spectrum and its ability to be used. And the second is the relationship between auctioning the 700 and 800 spectrum band and auctioning the rest, and what the relationship between this, the role that this plays in the pending challenge to the ITA, that is the auction process. The first problem is that the use of the 700 and 800 bands that are occupied by broadcasters, that use is not possible in areas where they are broadcasting. This is set out in the Vodacom's answering affidavit, paragraph 61, page 006-31, and this is not denied by ETV in reply. This is, after all, what the whole tussle is about. So there where they are broadcasting and where they are using 700 and 800, you cannot use it for mobile. The second problem is that whether there is other spectrum, even significant amounts of it, available or not, all spectrum is not created equal. 700 and 800 is especially valuable for being capable of covering greater distances and penetrating buildings, and that is set out in Vodacom's answering affidavit, paragraph 23, page 006-13, and Frontier sets out the advantages specifically of 700 and 800 spectrum, page 007-18 and following. So this leads to the next critical point in the ETV false dichotomy narrative, which they obscure. And it is critical for this court to appreciate this. The importance of 700 and 800 is central to the current challenge by Telkom to the current auction. I'm going to say it again. The central role of 700 and 800 is central to the current challenge by Telkom to the current auction. One of the main arguments, which was the main argument in the previous challenge and led to the interim judgments of Mr. Justice Sutherland and Barkwa, referred to by ETV, is the charge that the assignment of 700 and 800 spectrum, when it is not capable of being utilized fully, renders the assignment unlawful. That is the argument. That if you assign the stuff while it can't be used, then that's unlawful. Telkom's argument extends further. Telkom's argument is because of the importance that Telkom attaches to its own ability to exploit 700 and 800 immediately, it argues that assignment of any other spectrum to Vodacom or to MTN for as long as Telkom is unable to enjoy 700 and 800 fully is unlawful. That's its argument. ICASA and Vodacom dispute this argument, but it is one that must be taken seriously. It is a linchpin of Telkom's challenge. This application has as one of its main effects, if the interdictory relief is granted, to add fuel to this potential fire, which is why Vodacom stresses to the court that the interdictory relief has the real prospect of imperiling the successful assignment by ICASA of any spectrum. Of course, Vodacom would welcome a finding by this court that this argument is untenable, that the notion that assigning spectrum in other bands while 700 and 800 remains bogged down without digital migration is unlawful, that notion is an untenable notion. We, with great respect, we would love a finding by this court that that is an untenable notion, but it is a key component of the current attack on the auction. And that precise bogging down of the 700 and 800 spectrum, that precise bogging down that is the linchpin of Telkom's challenge, is what interdictory relief would achieve. One of the arguments leveled against this challenge by ICASA is that digital migration is well underway and imminent. ETV's role in that application is important. First, the debate that Mr. Justice Msimang had with our learned friend and that Mr. Motong also addressed on ETV's volte-face. It sought to distance itself in argument from Telkom's ancillary relief to speed up digital migration, but Mr. Motong pointed out and demonstrated what they were seeking was to support that relief that Telkom wanted. Second, ETV's position is suited if digital migration doesn't happen or gets delayed. That we can have no doubt about. So whatever the court does, it must know. ETV position is suited if there's no digital migration or if digital migration gets delayed, because it threatens the assignment of 700 and 800 for mobile. In the Telkom application, ETV argued that even if 700 and 800 is unavailable, it shouldn't be assigned. It shouldn't be auctioned and assigned, because that would affect ETV's market power and its bargaining position with its advertisers. If the idea gets traction in the market that 700 and 800 is now for mobile and not for ETV any longer. This despite the fact that digital migration was on the cards at least since 2009. So I quote from ETV's concise heads in that Telkom matter. In the Telkom matter, it's in case lines K19. The harm they say that would be suffered, one of the harms they say would be suffered if the 700 and 800 bands were auctioned. They say, quote, once the 700 megahertz and 800 megahertz frequency bands are sold at auction, this will send a message to the market and advertisers in particular upon whom ETV relies for its revenue that ETV services are precarious. And that's also in its affidavit at I-35 in that case lines reference. And one has, so ETV is suited by this. If digital migration doesn't happen, then it's a further pin in the argument that you can't assign and that it's unlawful to assign. And if you can't assign and it's unlawful to assign, well, then you're going to have ETV occupy this position for who knows, many years still to come. And then one has this extraordinary situation, which was raised a few times, specifically raised with Mr. De Beer by Madam Justice Leroux, and raised as a challenge in Vodacom's heads. It's one of the most extraordinary things about this. ETV's own inaction in relation to getting its people, its viewers, to digitally migrate. Now, in our heads, we say in paragraph 38, page 021, -201, and we refer to what is said in our answering affidavit in this regard, paragraph 146, 006-55. We say ETV has not taken a single step. It hasn't told the court of a single message, one message that it sent out on a single day to say to people, hey, you must get a set-top box if you want to digitally migrate. And what do? They don't address that in reply at all. They duck the question from Madam Justice Leroux. We get the response that they don't have any duty at all to do this. That was the response, that we got an argument. And we'll check what the papers say about this. I've indicated to you what the papers say. We say they've done nothing, they don't reply to that. This court must decide this matter on the following common sense inference. Not saying this too lightly. If ETV had any desire to have its affected viewers get set-top boxes so that they can switch to digital, they would have done everything in their power to make this happen. Why have they not done that? Because they don't want that to happen. They do not want their viewers to get set-top boxes to move to digital. Why not? Because in the digital world, they need to compete. If they are in digital and free-to-air, they need to compete with the SABC. If they're the only ones in analog, they don't have to compete with anybody, and they swallow up the whole of the SABC's market share base. That's what this is all about. And ETV invokes the temporary interim spectrum assignment under the COVID Disaster Management Act. Says, well, you've got the temporary, you have these things. Now that is available only until the 30th of June 2022, or 3 months after the state of disaster, whichever is earlier. And I understand the state of disaster has just been extended by a further month. It was coming to an end today, if I'm not mistaken. And that means that the 30th of June date would be an earlier date than the end of the state of disaster, even if that were the last date for the state of disaster. So that comes to an end on the 30th of June. Then you have this remarkable reliance in paragraph 50.9 of the replying affidavit of ETV on the SABC switch off as freeing up much of the 700 and 800 bands for IMT use. Page 020-33. Now, we don't have to trade pejoratives, but this is an extraordinary and a cynical approach. The public broadcaster complies with the timetable for switch off. ETV wishes to free ride on the gap left in the spectrum occupied by SABC. We see this in its replying affidavit, paragraph 50.10.3. That's 020-35. 50.10.3, 020-35. They say the figures demonstrate that there has been a massive shift away from SABC viewership. 20% decrease year-on-year in the Free State and a 46.6% decrease year-on-year in the Northern Cape. Coupled with just shift away from the SABC, there has been a marked increase in viewership of ETV's analog programming. 52.9% increase in ETV's viewership in the Free State and 4% in the Northern Cape. It's a no-brainer with great respect that this is the situation that ETV needs to have carry on for as long as possible. Because we all know that market share once gained is something that is difficult to give up. And if the SABC complies with digital migration, does all the switch off that it's supposed to do, it will eat all this market share. And that is what it wants. And this is why it wants the interdictory relief to say, until everybody has a set-top box, you can't have digital migration. Then you have the solution that they say, move us to below 700 megahertz for the meantime and have analog occupy that sphere. We deal with that in paragraph 65 of our heads, page 021, 211. And what's important about this is that this accepts that analog switch off for 700 and 800 is justified. But it requires legislation on continuing an analog regime elsewhere for ETV. So it's crafting a whole new spectrum allocation plan for government to suit ETV. We must now make space for the outdated analog technology for nobody knows for how long. And it's not even part of the relief that ETV seeks, which is that no digital migration must occur until all has had their set-top boxes. So cobble together a policy implemented in court. With respect, this is not what the court's function is. If a case is not made out for that interdict, and we say a case is not nearly made out for that interdict, this is not the Parliamentary Portfolio Committee on Digital Migration. This is a court of law which must apply legal rights and the Constitution if it demands X or it demands Y. It is not here to cobble together a policy for the minister or a way in which we can achieve digital migration in better or cheaper forms. So now we look at the elements of the interdict, and we dealt with that in our heads in paragraph 23 and following, page 021-197. And it is important that this interdict is recognized for what it is. If this court were to grant it, it would be telling government, you cannot do this important thing, which is digital migration, unless and until X, Y, and Z has happened. And from what we've seen on the papers, and let me not put too sharp a point on it, you cannot do it until the cows come up, essentially. And this is what they are asking the court to do. Now, is there a clear right which they need to make out? Well, there's no statutory or common law right. That's clear. It can't be a statutory right or a common law right. So what do they rely on? They rely on the KZN principle. It's relegated in their heads from its prominent position in the founding affidavit. And if I may just ask the court to go and look at what we say about that in our heads at paragraph 25 and following, at page 021-198 and following. That principle is not applicable in this case, and in fact the judgment supports the minister's right not to comply with ETV's demands. The finding in KZN related to a promise made in relation to the whole academic year. We will subsidize fees for independent schools for the four quarters of the year. We will subsidize it. After quarter number one had passed, and schools had actually budgeted and included in their budgets, and they were relying on this on the subsidies, the decision was withdrawn. We won't subsidize anymore. We'll now reduce the subsidy by 30%. So for quarters 2, 3, and 4, the promise was withdrawn. What did the court say? The court said the government was entitled to withdraw that promise for 2, 3, and 4. I want to say this again because everybody seems to forget about this. The government was entitled to withdraw that promise for 2, 3, and 4. as to Q1, because that right had already accrued, it said, I am going to do X on X date. By X date, that right had accrued. It was only that quarter that it was bound to retain the payment of the fee that it had agreed to be done. Now, in this case, but even if one takes there to have been a promise, and I'm coming to the point of the promise, but even if one takes there to have been a promise that by the date of ASO I will do X, Y, and Z, that date had not arrived, which means that on the KZN principle, the government was free. Government was free to change that policy. It is not tied to a contractual right that anybody has to enforce that as a contractual right. The question of consultation and of arbitrariness and of rationality and the like, those questions come into the decision, but from the KZN principle just doesn't help them at all. Government was entitled to, Mr. Justice Cameron pointed out to the fact that you can't enforce political commitments. Can't have the government gets up and says houses for all. By 2022, we want everybody to have electricity. You can't go to court and say it's 2022, where's my electricity? With respect, it doesn't work that way. You're entitled to withdraw such commitments as long as they don't create an enforceable money right on a particular date that has already accrued. And in this case, the only right one can talk about is the right actually to get that set-top box, if there were such a right. And they're going to get them. They are, every single one who registers will get it. So that's the only, there's at worst there would be MORA in relation to that decision. So if let us say for a moment, let us say the promise is that I will give you X by the date that I'm going to do Y. Let's assume that's the promise. I will give you a set-top box by the date, which is the 31st of March, that I'm going to do digital migration. And let's assume that promise attaches to the population of those who register by the 31st of October. Let's even assume that's a promise. I will give you X by date Y. And I don't do that. I don't give you X by date Y. If you rely on contractual principles and you say KZN applies despite what the court said about being able to change before the due date arrives, you will say the government is now in MORA. You haven't given them that box by date Y, you must now give them the box and do so as quickly as possible. It doesn't translate into an inability on the part of the government to do the Y. It doesn't suddenly paralyze government from the powers to exercise the thing that it wanted to do by date Y. There's no way in which that entitlement, even if there is such an entitlement, could translate into an ability to stop government from exercising those powers. And of course,
Mr. Snickers, I'm sorry, I have restrained myself, but I must just ask you this question.
Yes.
Is the promise not, if you register by 31 October, I'll give you set-top box by 31 March, and isn't 31 October a due date, if I can call it that? I'm performing by 31 March, but isn't the government obliged to give you the box by 31 March because you complied by 31 October?
No, Madam Justice Lulu, because the promise is to do something by the date, which is the 31st of March. So if I am government and I apply the KZN principle, and if I'm going to apply the KZN principle on the way that it has been enunciated in the case law, that means that unless and until that date has arrived, I'm entitled to say I'm not doing it anymore. There could be very good reasons arising before that date for me not to do so. And even if it were so that I said, all right, I've tied myself to giving you something by the 31st of March. If you do something by the 31st of October, and I'm tied into the principle in a way that the case law doesn't suggest I am. Even if that were so, that doesn't mean I'm not entitled to do switch off by the 31st of March. All that means is I'm now in MORA on this obligation.
Yeah, on the set-top box. No, it's separate from ASO.
And yes, if people, as Mr. Mortar says, if people come along and say, if they can make out a case for saying that the set-top box obligation is somehow an obligation that is a constitutional entitlement to get the set-top box, and it should happen more quickly and so on, and they have a case to say it's going too slowly and so on. Let them come and get that progressively realized in the way that the law allows. But how on earth does that translate into no switch-off? How does that translate into you cannot exercise your powers under the ITU? It just doesn't begin to do that. And that's the problem, is that this idea that government is paralyzed into doing that which it is fully empowered and must do by international treaty, because it hasn't done something else which it has undertaken to do. And then there's also an air of unreality about this. The idea was, there was a question from the bench about the undertaking to assist. That's where government's obligations start. So this is the irony. So without a commitment from the government to assist, there would not be any obligation. So you have a situation that because the government said it would subsidize, government says, I understand this creates a problem for people. I will help you. If you register, I'll give you a set-top box. And it's not 3,500 I understand it's 350 rand. But if you register, I'll give you one of these things. So meet me halfway and buy a ticket. But if you register, I'll give you one of these things. Now, suddenly the government is not entitled to do something it would have been entitled to do if it hadn't done that. If it hadn't said, I'll help you. How can that ever be the law? How can it ever be the situation that if the government had said, I'm going to do this because I have to do this, the ITU says I'm going to do it. I'm going to do it because it's important for spectrum. I'm going to do it. And I don't care what it does to people. I don't care whether you have set-top boxes or anything at all. I just don't care. If it had done so, it would have been free to do it. There would have been no basis for it. But the moment it makes political commitments, the moment it says, I'm going to help you and I'm going to subsidize you, now it's not entitled to switch off. That, with respect, can never be the law. And of course, a learned friend is in a difficult position because there are these, one must distinguish between the commitment. There's no question about it. The government made a commitment and tried to make a commitment to say the idea here is to make as much of this happen as possible for as many people as possible before switch-off date. And his client wants to stick to that commitment, and our learned friend is in the position to say we will try and stick to that commitment. But that doesn't translate into an entitlement under the KZN principle or anything else. Nor does it translate into the more important question that they can't switch off unless and until that has happened. Now one has this rather curious feature that what is the promise? And Mr. Mortel went into quite a bit of detail there. Nowhere have I seen a promise that unless and until every set-top box has been delivered, we will not have ASR. Not seen a promise like that. Clear there's an aspiration that comes close to that. That's clear. But there's no promise made to everybody that I will not switch off unless and until everybody's got an STB. And the case for the KZN principle relies on commitments about not leaving anybody behind and the like and so on that supposedly create that as a promise. But when it comes to the push comes to shove, then our learned friend Mr. Marcus says that it is childish. It's childish to demand there cannot be switch off until every set-top box has been delivered. Now, if I read their paragraph 3 of the relief that they seek from this court, that childish relief is what they seek. They don't say 90%, they don't say 60%, they don't say 25%. Nobody knows what would satisfy them, and nobody knows what would satisfy this court, but they seek interdictory relief on that basis, and they come to court and they say, of course it's childish to say that we should all have set-top boxes before ASR. Now, what is the court supposed to do with that? How does it frame its interdict? Until how many has had what? And we agree it's childish. But how seriously can this court take this as being a promise that must be vested with legal entitlement sufficient to found an interdict against government? Where's the line to be drawn? Now, in KZN, the government wanted to renege on its commitment to deliver the subsidy. It wanted to reduce the subsidy. There's no such suggestion here from government. Not saying, I'm not giving you set-top boxes anymore. Not saying I'm giving you a smaller one, I'm giving you a different one, I'm giving you a terrible one. It's just saying you're going to get yours after switch off. That's all. That's the only thing that it is about. Now, where does freedom of speech with respect create the clear right for an interdict. We've seen that nothing prioritizes the ETV content entitlement over cheaper data. And the associated rights all depend on this false premise. Irreparable harm? Well, certainly not ETV, because it's entitled to continue. So who's irreparable harm? The small subset of viewers, and what is the harm? The delay in getting the set-top box access. That's the harm. The non-seamless access that they get. Now, I don't want to bore with respect the court with all the law relating to not interdicting government, not interfering with its functions, except where absolutely necessary to vindicate and enforce constitutional rights. But ETV rides both horses on this delay issue and on the harm issue in the papers. On the one hand, the smaller the delay. So if one takes seriously this 3 to 6 months issue, the more they can say, well, what's the problem? What's the real interference here with government? One sees that in the heads, the interveners' arguments in their heads 72.2, 021-43. This is going to be a couple of months. Let's just interdict, because it'll be a few months. That's on the one hand. But if it is saying that this will last long and will have an effect, then of course that exacerbates the degree to which the interdict will paralyze the efforts to liberate the spectrum. So one thing we do know is that nobody knows how long this is going to take. That we do know. We've seen that the numbers don't look good, just put it mildly. And nobody knows what the numbers are. So how many are actually involved? We've seen the problems with these population groups, and the ETV and the interveners say, in so many words, it's Mr. Du Plessis' words, it's the minister's problem, it's not our problem. The difficulty is, as Mr. Justice Msimang pointed out, they're not just dominus litis, they seek an interdict. So they've got to make out the case for the interdict. They can't say, I don't know how many people, I don't know how long this is going to take, let the minister has not candid, it doesn't display candor to the court, I just don't know, so let's just grant an interdict. What our learned friend says is they don't know how many people are involved, but they say there will be many. So what we can say is we don't know how long it's going to take, but we know it's going to be long. That we know. So Frontier did an optimistic assessment, and I say it's an optimistic assessment, on 2,000 a day. And that if you take 2,000 a day, it'll take 5 years. That we see in the Frontier report 007-11. We know that if you take the whole period, we had 200 a day, and we now know that it looks as is about 800 odd a day on the acceleration that we've had. Now, ETV's opportunism, we see in their replying affidavit, paragraphs 134 and 135, that's page 020-64. They say there's an unrealistically long period of 5 years, and they refer to Vodacom's artificially pessimistic view. Today, both ETV and the interveners beat the drum for all they are worth of this will take forever at the current rate. So, no fair assessment of Frontier's assessment can call it artificially pessimistic. We don't know how long it's going to take. But what we do know is that however long that takes, it mires 700 and 800, it paralyzes 700 and 800, and it fuels the challenge to say you can't auction 700 and 800, you can't even auction anything else until 700 and 800 is available. So this court must be under no illusions. If it grants an interdict that you cannot have switch off until all these people have set-top boxes, if it grants that interdict, 700 and 800 is going to be stuck in this mode for a very long time. And that is not in the interests of the poor, it is not in the interest of the economy, and there is just no basis whatsoever for having made out a case for that. Alternative remedies. Again, we're on interdict. They would say they have no alternative remedies. ETV's own inaction speaks volumes here. They don't say to this court, this is what we did to try and tell our people. People, please get a set-top box. You're getting one for free. All you need to do is to go and register if you earn under 3,500 Rand a month, and then we'll all happily be in the digital world for free-to-air television. And we know why they don't do that. We know very well why they're not doing that. The current situation suits them. Now, they say the relief sought is consequential, and we've indicated that that's not the case. The cases of Black Sash and Metro Rail that we set out in our heads, if I can just ask the court, I'm not going to quote it, the court could just look at paragraphs 45 and 47 to 48 of our heads of argument. That's at 021-204 to 205. That if you find a violation or a degree to which the government has failed in its functions, you don't legislate on how they should unfail when there are various ways open to them to do so. I do make another point, which is an important one, which is that if there is a basis for interfering with the decision, the date decision on review, despite the cogent arguments that Mr. Mokhtar put up in this regard, then there's even less reason to canvass the substantive interdictory declaratory legislative relief that is being sought on the principle of avoidance, which is what Mr. Ferreira, our learned friend for the interveners, candidly conceded to say that if the date review would succeed, then it would be inappropriate to consider the interdictory relief. And that principle goes as far back as the constitutional cases such as Zansi and Khumbudzo. If I can just give the references, Zansi is 1995 4SA 615 Constitutional Court, paragraphs 4 to 5. Khumbudzo is 1995 3SA 867 CC, and Motsepi and Commissioner for Inland Revenue 97 2SA 898 CC. And there is the principle that if one can avoid a difficult question of law by answering an easier one, then one has to do so. So, the lords and the ladies, the position is that certainly as far as this interdictory relief is concerned, no case has been made out in the papers. And whatever needs to happen in relation to accelerating set-top box delivery, making the government deliver more of them more quickly, etc., that cannot, with great respect, that cannot and should not result in any interdict granted in relation to the switch-off date. And if such an interdict were to be granted, then the ability of ICASA freely to assign that spectrum for uses that the country has been crying out for a long time is hampered. And it has a very, very serious potential effect on the economy and certainly on the poor. And there is simply no right, there is just no right on the part of ETV or its viewers to have that happen. If I could just take a final instruction. We are 3, others are 5. There are big teams. We would go with the general flow, as it were, that this appears to be a case where it would be appropriate to grant costs of 3 council. We believe that if the interdictory relief is not granted, and if Vodacom's participation in that regard is regarded as useful, then it would be appropriate for the court to direct that ETV pay Vodacom's costs, and that include the costs of 3 council. Thank you. And ladies.
I think I'm happy. I don't have questions.
You don't have questions? Okay.
No.
Mr. Snyder's, yes, I think everything has been covered. But on the aspect of ETV bringing this action here and not producing any evidence and saying it's the duty of government. 8 million people are not getting any will be left out. And we now know from what Advocate Mutau and the Minister argued that the promise was from a pool and of specific people who applied. And if those people applied, we are going to give them a decoder. And out of that pool of 3.7 million, only 1.2 million applied. And the 2.5 million that has not applied, ETB multiplies that by 3.3 and says there's 8 million people that will be left out there, and is not giving any, does not file any reports, does not say that, and simply even the interveners are not supporting that with anything other than to say, from the Broadcasters Association, there's so many people that are receiving analog. So it means those people are going to be out there. What's your take? Don't you believe that they should really, in order to get an interdict, come with substantial and tangible evidence for them to get the relief?
Yes, with great respect, my lord. As I've indicated, the problem with the figures is that the three pools don't talk to each other and don't give the actual numbers that the court needs. They tell you different things. One pool is who's poor. The pool of who's poor doesn't tell you who's got TVs, and it doesn't tell you who's got digital and who's got analog. Then there's another pool of people who rely on free-to-air. That pool doesn't tell you whether the free-to-air is analog or digital, so that doesn't help her at all either. And then there's a pool, that's that 36% of television viewers who currently use analog. That pool doesn't tell you how many of those people are able to afford the set-top box or even a digital TV, or even have them but aren't using them. All it tells you, and that's all that these surveys can do, is this is what they're currently doing. And the fact, in answer to your lordship's question, is that if I'm seeking an interdict and I want to come to court and I say, this is what you're going to do to government, you have to interdict them, then it's up to me to put all of those facts before the court so that the court knows, so that it can grant that interdict, knowing what the effect of that interdict will be. I can't go to court and say, I don't know what the answer is. The government doesn't know what the answer is. The government wasn't playing open cards with the court. So therefore, just grant the interdict, well, completely in the dark, and let's just while the interdict is granted, let's then get the government to report back on how well it's doing on its set-top box subsidy. That, with respect, is not what one can ever do to get relief from the court. Yes, I am reminded that we should ask for the qualifying costs of the expert frontier to be included in the costs.
Thank you, Mr. Snickers. No questions from me, but just I'm sure speaking for the court to thank you for your patience to get to when you addressed us, and to say that your submissions have certainly been of assistance. Thank you.
Yeah.
Thank you, Melody. I did try to, and if it was slightly faster at times than it might otherwise have been, the reason for it was because I know there's still a lot that has to happen this evening.
This is the benefit of a recording. We can rewatch.
As the ladyship pleases.
Thanks, Mr. Snickers. Mr. Mukadi?
Thank you, my lord. I'm ready to start. The benefit of speaking at this stage is that my two colleagues who are on the same side with me as respondents have already spoken, and I've also had the benefit of the engagement that the bench had with them. But let me start by saying that we embrace the submissions that have been made by Mr. Mutau on behalf of the Minister and Mr. Snikas on behalf of Vodacom, and we do not intend to repeat them. We must also be mindful of the time. However, we propose to deal with a few issues in order to reinforce some of the points made. The submission made by Mr. Snikas that what ETV6 is an interdict is entirely correct. You will see when you look at the notice of motion dated 12 October 2022 at 001-1 that ETV has avoided to craft the prayers in such a manner that there is a reference to an interdict. But of course, one does not say that it is not an interdict because the word interdict is not used. But you look at the nature of the relief and what it seeks to achieve. The interdict which we have submitted is perpetual in nature, is prayer 3 at page 2. So that would be 001-2. It is crafted as though it is a declaratory order sought, but it is an interdict. Let us start by scrutinizing other prayers as well, so that we can be able to demonstrate to the court, or for the court to have an appreciation of the nature of this application before it, and to make a proper assessment as to whether any of the relief sought is tenable. Prayer 1 at page 001-2, you can see that ETV appreciated that it wanted an urgent relief. We know that it did not have a date because this was arising from the previous litigation where ETV intervened as a second applicant to the telecoms application. We know what happened in that litigation, which was resolved by an order by consent on the 15th of September 2021, which ETV did not accept after it had participated in it, resulting in an order by Justice Fori, which resulted in what ETV did by filing this notice of motion on the 12th of October 2021. It still wanted an urgent relief, and that's why it has prayer 1 there. But we know that that urgent relief never came, because ETV impressed on Justice Fori that the DJP should allocate this matter for a date in January. It was any date, if I recall, any date from the 31st of January to the 3rd of January or so. But that never happened because ETV on its own accord wrote to the DJP and said that it is not feasible for this matter to be heard on that date or any of those dates, and we request that you reallocate us to a later date. And that is how we ended up with this date of yesterday and today. But what the point I'm making is that the fact that the ETV had this prayer 1 was alive to the fact that interdicts are by their nature sought on an urgent basis because they are concerned about the future and not the past. They are concerned about stopping or restraining a conduct which is still to happen. In prayer 2, which is couched as a declaratory relief, let's read it and see then whether it still has a place in today's day, as we speak today. It is declared that prior to the determination by the Minister of the analog switch-off date and the date for completion of digital migration, the Minister is required to undertake a process of consultation with affected parties, including but not limited to ETV, regarding the date of the analog switch-off date and the date for the completion of digital migration, and whether appropriate measures are in place to ensure that those in South Africa who are reliant on analog broadcasting are not deprived of their right of access to information by means of receiving free-to-air broadcasts as a consequence of the determination by the Minister. So we can see how Prayer 2 starts. It is declared that prior to the determination by the Minister of the analog switch-off date. We know that this has been overtaken by time. The court is in no position to grant an order of this nature. We know that the date for the switch-off has been determined. We have all seen the Gazette. So Prayer 2 is out of the window. Then let's look at now Prayer 3. Prayer 3, which is an interdict but couched in the form of a declaratory relief, it says, it is declared that the digital migration process may not be completed and or the analog switch-off date may not be proclaimed by the Minister unless and until the Minister has complied with her constitutional obligations and public promises to provide those South Africans who are presently reliant on analog broadcasting with alternative means to access ETV services on a free-to-air basis. Again, this prayer has been overtaken by time because it speaks, as on the 12th of October 2021, to say that the digital migration process may not be completed and or analog switch-off may not be proclaimed by the Minister. We know that the Minister has already proclaimed that, and we know the determination and a decision has been taken to that effect last Friday. So this now then brings into picture the auditoral principle, which is directly against the applicants or ETV, because the auditoral principle says that a decision by a functionary exists as a matter of fact and law, and it has legal effect until it is set aside by court. That is what auditoral principles say, as it was reaffirmed in Cairns by the Constitutional Court in Cairns. So ETV accepts that the Minister, by proclamation or making a determination that the switch-off will be on the 31st of March, is a decision. But this is a decision that was taken after the application was filed. So that actually required that ETV has to file, if it so wanted, an application to now deal with that decision, which was taken last week Friday. So that decision is not impugned, and you can't impugn a decision that is still to be taken. You can only impugn a decision that has been taken. So you see that what ETV sought to do in prayer 4 was to anticipate a decision by way of a review. But a review is about a decision already taken, not a decision that you preempt. So let us look at how prayer 4 is crafted, which cannot be sustainable at all, because one will, in a decision, either refer to the decision and where it was taken, and if that decision is to be supported by a record, and that party will request the record. In prayer 4 it says, to the extent that the Minister has taken a final decision in relation to the determination of the date for digital migration's completion and analog switch off, or take such a decision prior to the determination of this application, the determination then is reviewed and set aside. But then that you can't do, because as at the time when this prayer then is crafted, there is no decision. The first part of this prayer is speculative, because it presupposes that somehow government must have hidden some decision which it does not want to communicate to us, To the extent that it has taken that decision must be set aside. But we know as a matter of fact that at that time, on the 12th of October 2021, the minister had not taken any decision to this effect. So the first part of it is simply superfluous. But the second part of this prayer preempts now the decision. It says that to the extent that the minister is going to take the decision, then I want that decision to be set aside. But that's not the proper way then of review or of litigating. You cannot litigate in respect of a decision that is still to be taken. The same way as one cannot approach court then to set aside the decision by maybe the president to assent to a legislation, because one will have to wait then until the president assents to the legislation, and then you can impugn that legislation. Otherwise, the only way that you can do is by interdict. Hence, we say that prayer 3 is clearly interdict. So when one looks at this application proper, it is not a review, it's not a declaratory type of an application, but it's an interdict proper. So what is it that what is it that ETV was supposed to have done? It was supposed to have squarely ensured that it falls within the parameters of National Treasury versus opposition to urban tolling, the outer judgment of the Constitutional Court. If it can't fall within the parameters of outer, then this application has to be dismissed, because it is an interdict application disguised as a review of a non-existing decision at the time when the application was filed, and declaratory relief in respect of that which at the time had not yet occurred or taken place. But just to give the court the confidence as to the nature of this application, that it is not a review in the real sense, is that if it was about challenging some form of decision taken by the minister, then one would have expected this notice of motion that I'm looking at to request the minister to substantiate for the decision that is impugned. And that you do by, in terms of Rule 53, then you will say that show cause why the decision that is impugned must not be set aside, and give me the record so that you can show me then what informed that decision. You will see at page 0014 of the notice of motion that this is a clear-cut Rule 6 application. It's a Rule 6 application because it was an interdict that was sought. It does not require, the ETV does not require any record. It's not interested in any record. It doesn't know how that decision was arrived at, what information was before the minister. It's not interested in that, because then it knew that there was no any decision that it can review. So that's why you can see at the bottom of page 4 of that notice of motion, it simply says that if you want to oppose this application, file notice to oppose within 5 days and file an answering affidavit thereafter. So this is a Rule 6 notice of motion, which sought an interdict. And you'll see in our heads of arguments that we dealt with those cases which are relevant to an interdict against the performance of a statutory duty by an organ of state. And you see that we have dealt with those cases. Our heads of arguments are uploaded on case lines from page 021-139, but I'm referring to where we start to deal with the case law pertaining to interdicts, and you'll find that from page 021-155. We have referred, for instance, to the case of National Treasury at paragraph 27, which is the leading case where a temporary interdict is sought pending the happening of some kind of event. And we know what ETV say in prayer 3. It says that interdict the switch off or migration until such time that everybody else has a set-top box. So that is really what it wants. And there is no quibble with anybody or by anybody that the restraining order sought is against the minister. And that falls within the parameters of an organ of state. And outer says that the court should not lightly grant restraining orders against organs of state, especially when they are acting within their powers, meaning that acting within the domain in which the legislative or other form of regulatory regime permits them to do, like a policy. So we know that none of the policies that Mr. Mutawa has referred to here in the amended form from 2008 amendment of 2012 and 2015 are impugned by ETV. So the policies are there, and everybody accepts that the policies had a particular intention and purpose that government wanted to achieve. Once you want to interfere with the government's obligation to implement that policy, then you've got to demonstrate the clearest of cases. That's what I would say. The clearest of cases entails demonstrating exceptional circumstances which have not been demonstrated here. And what that entails is that you must demonstrate that in your founding affidavit. It's not something that you can demonstrate in the heads of arguments or in oral submissions, but it must be found in the founding papers so that the other parties have an opportunity to respond to. When you go through the founding affidavit of ETV, including the intervening parties, you will not find any attempt by them to demonstrate a case which is the clearest or trying to show the exceptional circumstances as to why government should be interdicted from ensuring that it implements the migration to digital. But there is actually an acceptance by everybody that South Africa's obligation was already imposed by the resolution of the ITU. South Africa is a member of the International Telecommunications Union, which is a body that is entrusted with matters pertaining to telecommunications, spectrum, and the like by the United Nations. And then we must look at Section 231 of the Constitution, which enjoins South Africa, in terms of international agreements, to comply with those agreements. So it is not open to South Africa as a member of the ITU to say otherwise. ITU has already designated the 700 and 800 megs to be the spectrum bandwidth which must be used by mobile telephony. So the 700 and 800, in terms of the resolution of the ITU, have been assigned to mobile telephony. They can no longer be used for television broadcasting. That is not a South African decision. It is a decision taken at an international level, which South Africa had to ensure that it develops a policy, which the minister did, to give effect to that resolution. And ICASA is then supposed to implement that policy in accordance with South Africa's international obligations. And what ICASA is required to do, by virtue of its own powers derived from section 192 of the Constitution, was to ensure that South Africa complies with that obligation to migrate the entire country from analog to digital. When you look at section 192 dealing with broadcasting authority, it says, national legislation must establish an independent authority to regulate broadcasting in the public interest and to ensure fairness and diversity of views broadly representing South African society. So the Constitution doesn't tell us anything much except to say that there must be legislation which must establish this body, and that legislation was indeed enacted by Parliament, and it is called the ICASA Act. And the ICASA Act then establishes ICASA in terms of Section 3, and ICASA then has powers that we find in the ICA, Electronic Communications Act, insofar as it pertains to the radio frequency spectrum. Then we simply go to Section 30 and Section 31. They will tell us exactly what are the obligations of ICASA in that respect. And I'd like to quickly then go to those sections. If you look at Section 30 under Chapter 5, actually in Chapter 5 of the ICA is dedicated as a topic to radio frequency spectrum, control of radio frequency spectrum. So the control of the spectrum is assigned to ICASA, and it is the one which has to ensure that it is dealt with in accordance with the law. And Section 30 sub 1 says, in carrying out its functions under this Act and the related legislation, the authority controls, plans, administers, and manages the use and licensing of the radio frequency spectrum, except as provided for in Section 34. So Section 34 is clearly not relevant for this purpose. I don't have to go to it. Then when we look at Section 31, it says subject to subsection 5 and 6, no person may transmit any signal by radio or use radio apparatus to receive any signal by radio except under and in accordance with a radio frequency spectrum license granted by the authority to such person in terms of this Act. It is common cause that ICASA has taken the necessary steps to ensure that it fulfills its obligations in terms of Section 30 and 31 by ensuring that it options the available spectrum. But then this is not just available spectrum, it is a high demand spectrum. And the reason why then it is categorized as high demand, it is because of the need and necessity and acknowledgement by the country and everybody that South Africa has to move into the 4th Industrial Revolution, and that the 4th Industrial Revolution needs anything less than technology. You are not in the 4th Industrial Revolution without technology. And this technology, in order for it to be maximally used, you need the high demand spectrum. The last time South Africa was able to assign the spectrum was in 2006. It is already way behind its peers that now we have to, and that's why you see that everybody acknowledges that. If you look at the policy, it keeps on saying that we have to urgently. So it talks about the need to urgently now migrate, and migrating must go hand in hand with making the spectrum available. Two types of bandwidth are implicated here, the 700 and 800. But one has to look at their importance. Why is the 700 and 800? First of all, then what you have to ask yourself is, why the 700 and 800 were actually then used for all this time by television broadcasting? Because they have got this propagation then to penetrate to a longer distance. They can easily penetrate through the walls. So that's why then they are so useful even for that. And that's why then ETV doesn't want to let it go. But then in order to move into the 4th Industrial Revolution, ITU then decided that this type of bandwidth, this type of spectrum, 700 and 800, will be even more useful when it is used in the mobile telephony, because it will result in cheaper data. It will be able to go to travel longer distances so that it can easily reach rural areas, the far-flung areas where they can save lives. I mean, one thing that ETV does not take into account or does not acknowledge when it deals with Section 16, which I will come to then in my closing argument, is what significance the release of the 700 and 800 will do to ensuring that those far-flung areas which were never covered will ultimately be covered. You think of the schools, and when you look at the 2021 ITA, it makes provision of those MNOs which are going to be able to purchase then the spectrum will have certain obligations in terms of freeing data to certain entities, public entities, to schools and so on. That is actually an important consideration. Data will become cheaper, accessibility then of data even to those people in rural areas who never had an opportunity to have that. What about saving lives? That when you are able to, even when you're in the remotest of areas, you are still able to make a call or even to send a WhatsApp when you are in danger or when you are in an accident. Those are the things which the ETV doesn't consider. It restricts Section 16 right to only the right of its own viewers who are using the type of television which cannot adapt them to digital to have access them to ETV. But that is a limited scope to which the ETV then simply focuses. Because when you look at what Section 16 right is, it is a right to receive information, but it doesn't say that to receive it through a particular platform. Mr. Snipers has made a very powerful point in that regard, that ETV as a private entity, which of course is operating in this field, in this area of broadcasting, it is of course then making information available, but it is also a commercial entity. But we have then other platforms within which the Section 16 right can be accessed. We know then, of course, that, in fact, let me say that Justice Leroy actually then touched on this when Mr. Marcus was arguing to say that are there other platforms which then can be used to still then ensure that the Section 16 rights of people is still then realized? Can we find anything in ETV's papers which deals with that aspect? You will not find anything. So the absence of that is quite telling, because this court cannot speculate that it is only through ETV that this 18 or this 8 million people that ETV is talking about can only access their Section 16 right. They can use other platforms, especially when the spectrum is released, especially when the 700 and 800 spectrum is released, which is going to cover even those areas where these people that ETV is regarding as the poorest of the poor will. But Mr. Sniper has also made a very powerful point. This poorest of the poor that ETV is talking about, what about those who don't have television at all? It doesn't talk about those ones. Already those ones, then, their Section 16 right has already been violated by nobody. So these are the dynamics that the court has to grapple with. Hence, then the court yesterday, I think it was you, Justice Msimang, when you raised the proportionality test, to say that, but you have to balance. If you have these competing rights, the right, as one may loosely put it, for ETV viewers to access information through that ETV free-to-air platform, and the right of everybody else, including the poor, to receive cheaper data and wider coverage, speed. It doesn't mean that when you're poor, you're not, you don't deserve speed, you don't deserve quality. You still need quality, because if you make a call which is going to cut time again, when you're in danger, you're still going to be in danger, because then you can't even access, you can't even go through, because then the coverage is so poor. So you don't need to be poor in order for you then not to get proper and adequate coverage. So these are the things which the court has to balance. It is a balancing exercise. So I submit then, to the court that if one looks at the relief that is sought by ETV, it simply doesn't get off the ground, and especially when that relief is being simply accepted by the other applicants. But the relief simply doesn't get off the ground. So it was on that basis that I understood Mr. Mutau to say that this application has to be dismissed, because if the interdict is granted, it is not in essence an interdict against the minister, because the minister has proclaimed the date of the switch off. It is actually an interdict against ICASA. It is an interdict against ICASA that ICASA cannot assign the entire spectrum which it is entitled to in terms of Section 30 and Section 31 of the ICA. And it is only in the clearest of cases that this court will say ICASA is hamstrung, it is restrained from making the 700 and 800 bandwidth, which it has already actually auctioned, because as we speak here, that has been auctioned. If ETV didn't want that to happen, one would have expected ETV to have gone to court the moment then we put this spectrum then to auction and say that, no, wait a minute, you can't make this auction available, and you can't make this bandwidth then available because we are actually using them and we want to continue using them, because we'll be in court actually then to review or to interdict the minister from doing that. They allow them the auction to go ahead, and then from there then they want this court then to come with an order. We say that despite that this IMT 700 and 800 have been auctioned, but those who have bought this must not use it, because ETV then is using it then for the viewers that it says that it is using. But let me even conclude, Justin Simon, with the question that you have put to Mr. Snakas, and I know that you also put it to Mr. Mutau. And that question has not been answered, because you also asked it to ETV, or you asked to ETV, but then ETV answered it in a manner that is not satisfactory. And that's the question when you said that who is the dominus litis here? So basically what we're saying is that who has the onus to prove, who has to satisfy the court that, well, who actually comes to court and say that I want an order? Surely ICASA then didn't just come to court today. ICASA was simply dragged to court because then there was this application and an order which says that, well, you're not going to be allowed then to make this 700 and 800 spectrum available to eminents who are going to buy it, even if they can buy it. So we have to come to court. But it is the ETV itself and these other co-applicants who ought to place sufficient evidence before court to say that we are entitled to restrain the government then from doing what it wants to do. It doesn't shift, then the onus doesn't shift because the respondent is an organ of state or is government. The test remains the same. He who alleges must prove. He who approaches court then for relief then must satisfy the court that I'm entitled to the relief, and the only way to do it in motion proceedings is by putting sufficient evidence in the founding affidavit or founding papers, not in reply or in the heads of arguments or in oral argument. That is not really how things work. So the court must simply accept that on the evidence available, ETV and the co-applicants have not satisfied the court that they are entitled to a relief which will have the effect of ensuring that the 700 and 800 spectrum is not available to those who have bought it in an auction which has taken place. And so for that we submit that the application should be dismissed. But of course we are alive to the undertaking which the minister has made in the context that that doesn't mean that the application should not be dismissed. The application will still be dismissed. But if one looks at that affidavit by the minister, applying the transform events test, I'm talking about the affidavit that was filed yesterday on the request of the court. You'll see in that affidavit that the minister spells out when certain things are going to be done, and I'm looking at paragraph 10 of that affidavit. So the minister will, of course, then through the acting DG, acting deputy DG, in paragraph 10, informs the court about the outstanding numbers of installations and 10.1 to 10.9 as to when this will be done. The only reply that we find from ETV is that this is not achievable because on the previous occasion you're only managing to install only 23,000 per month. But that's not a good enough answer. Because when you are building a house and using only 2 brick layers, then you may finish it then in 6 months. But if you want to finish it in 2 weeks, then you are going to actually do what? You are going to then employ then 30 brick layers, and you're going to finish it in 2 weeks. So this notion that certain things can be done within a certain time or period is simply then false. It's simply false. I mean, it's a matter of record that, I mean, that in certain instances, it will take longer than to finish something just because then there's no will to do it. But here then the minister under oath is saying that this is the will that I'm demonstrating. The same way as China then was able to build a hospital in 3 days, and when the COVID started, it's not a miracle. It's because he just put more manpower into the work. So why will the court disbelieve the minister when the minister says that I'll put more manpower to ensure that I meet my deadline of 31 March? But on the basis of Plascom events, there's no basis for the court to reject the minister's version and accept the say-so speculative version of ETV research that no, that can never happen. So we submit that the application should be dismissed, and of course then we are employing through counsel, but of course we are talking only in respect of ETV. We are not then saying that the same should apply to the co-applicants, but of course then one still has to raise something which is a displeasure that they simply jump into the bandwagon each time when ETV litigates and simply blindly then follow and support ETV. But of course, they continue to be protected by BioWatch, and there's nothing that we can do. The Constitutional Court has set the test that don't mark, NGOs which are trying to litigate with costs. So we are only seeking costs against ETV on the basis that it has failed hopelessly to make out a case in its founding papers, and it has failed to place evidence which was required in order for it to interdict the release of the 700 and 800 IMT, which ICASA has already auctioned, as the court pleases. And of course, this will ICASA.
Thanks, Mr. Mokari. My sisters, do you have anything to ask?
No, not from my side. I don't have any questions.
And more from my side, and just Mr. Makari, to you and your team as well for your patience and your assistance. Thank you.
Thank you very much, Justice Veru.
Thanks, Mr. Mokari, and thanks for the indulgence as you've given to this court.
Thank you very much appreciated.
In reply?
My brother, could I have a quick comfort break?
Okay, Mr. Duplessis, can we have a 15 minutes break?
I would go so far as to call it a discomfort break at this stage, but yes, please.
Okay, the court will adjourn for 15 minutes. Is that okay?
Thank you.
Thank you.
Court will adjourn for 15 minutes.
of the minister's case, but to which we received no benefit of an answer. The first was there was no rational explanation from the minister, of course, the minister's counsel in this case, for why the registration deadline was set at 31 October. There's simply no effort to explain that whatsoever, even though it's a critically important feature of the matter. Excuse me. Secondly, there's no explanation whatsoever as to why ETV and other stakeholders were not consulted as to that registration date. Absolutely no explanation whatsoever, other than to insist, as I'll come to in a moment, that in fact there was no duty to do so because of a mistaken understanding of the regulatory scheme. And then thirdly, no explanation as to why the March date for ASO had been imposed, despite ETV's concerns, which had been raised expressly with the minister, and which had been made clear to the minister would result in very significant problems for indigent households as well as ETV. So those are three issues which were central to the case, but to which we were not given any answer by the minister through her counsel. Let me then deal with what ultimately amounts to thematic points in the minister's answer or address. The first is that the minister filed a confirmatory by Centec. You'll note that there's no confirmatory filed by the minister herself. She's left it to the acting DG to put under oath all of the various statements, but nothing from the minister. But what we get is a confirmatory filed by Centec. You'll see that it was filed in the wrong place under case lines, and that's why you might not have seen it there, Justice LaRue, but it's now, it is there. I'm not sure whether it's been corrected to be filed in the correct place, but it's there. But it's a bold confirmatory, you'll see it when you read it, and it doesn't help because the projection that is set out in the minister's affidavit through the acting DG in paragraph 14 is by the department. The department makes the projections. In other words, it's the minister and the department that the acting DG is representative of. And you'll see that in paragraph 14. We project that the department will have installed a number of particular boxes over that period of time, thus satisfying the outstanding 507,251. You'll see that at paragraph 14 of the acting DG's affidavit of last night. So that's not Centec's projection, that's the department's projection. So it doesn't solve the problem at all. But there's a further and much more fundamental difficulty with the affidavit by the acting DG together with the confirmatory by Centec. And that's because of the decision in Fireblade Aviation. It's a decision, I'll just give you the reference. It's Fireblade Aviation versus the Minister of Home Affairs. It's a decision by Ladyship Madam Justice Pottrell, 2017, JDR 1719 GP, so in this division. And at paragraph 28, the following critical passage really puts paid to the affidavits and the evidence by the minister. The paragraph says, the fact that Mr. McKay filed a bold confirmatory affidavit does not assist the minister in rendering his version tenable. Why? Because the objective evidence does not sustain his argument. And that's the very point that I've been making. In the affidavit, the objective evidence, and I took you through the rates by which the rollout would happen, the figures of those that are left behind because no deviation has been sought in time, the fact that there are many numbers of what I've called the forgotten who are simply not even dealt with. Those are critical features of a reasonable minister's process in switching off, knowing that the public had been promised that they were not left behind. Well, that's unfortunately nowhere near the test met by the minister through this type of affidavit. So that's the first point. It's the evidence by the minister and the confirmatory efforts, belatedly as they were by Centec. The second feature of our learned friend's argument for the minister was this whataboutism point. Well, what about the fact that ETV may, in previous and different litigation, have supposedly adopted a particular position? Well, as the Ladyship Justice Lakamani, you pointed out, well, the minister had also changed her position in that case on encryption. That case was about encryption. It wasn't about this digital migration process and the indigent poor and whether they're going to be left behind at an analog switch-off date. That case was entirely different. But in any event, what's forgotten about ETV's position in that case is that it can't be said that ETV was attempting to delay in that matter, in as much as we know that the Supreme Court of Appeal found in favor of ETV's points. So it was a perfectly bona fide argument that that ETV had raised around numbers of difficult positions in a policy-laden context, and in that case, it had at least been successful before the SCA. By the time the matter went to the Constitutional Court, the case had also by then included, of course, SOS and MMA, and whatever might have been said by the Constitutional Court about ETV's changing of its position there, that criticism wasn't directed at MMA and SOS. So it really doesn't help at all to complain about what might or might not have been ETV's previous position, when in this case you are confronted with two applicants, one of whom was not criticized by the Constitutional Court at all in the form of MMA and SOS. And they represent the public in this case. They are the public interest representatives that are before the court. And they are seeking similar relief to ETV for very similar reasons because they're concerned about the poor. So this whataboutism with respect is not helpful. I do need to correct with respect, and I won't go into the actual paragraphs, but it's an unfortunate slurring by our learned friends to suggest that ETV had tried to jump onto the Telkom bandwagon because Telkom wanted to expedite, in that case, the particular rollout in digital migration. But as has already been highlighted by our learned friend, Mr. Marcus, leading our team, we've explained that it was only in respect of the principal relief that ETV had sought to intervene in that case, and we've set that out in our replying affidavit, where we've dealt squarely with this very point at 020-65, paragraphs 136 to 137. And in that particular set of replying paragraphs, we've highlighted that this suggestion that somehow ETV was being hypocritical is simply not correct, because we in paragraph 11.3, that's the principal relief. And you'll see that we have set out that in our finding affidavit for interventions at paragraphs 7 and paragraph 6. And those are contained, again, I'm just giving you the references so that this slurring can be corrected if necessary in a judgment. At case lines 020-172, you'll see that paragraph 7 and paragraph 6 of the ETV finding affidavit for intervention makes it very clear there that that's the primary relief, which is the review relief, not the switch off of the timing relief. And that is the relief that ETV said that it was wishing to intervene to support. But as I say, really, this whataboutism doesn't help at all in a case where the court is confronted with two parties. Whatever you might want to say about motives of one party or the other, here you are confronted with the reality of the minister saying, accepting her obligations, that she needs to, at least in respect of those that had registered by what she calls the 31 October deadline, that those individuals and anybody else who might have registered later end up being switched off and ultimately kept in the dark without television. That's this case, whatever might have been the background to another case in respect of which ETV at one or other time was involved. The third point by our learned friend is in respect of consultation, and really this is, in numbers of respects, this is the heart of our learned friend's argument, because according to our learned friends, there's no duty to consult because of what he called the architecture, the legislative framework, and the policy change. You'll recall he said there was a 2012 policy, and then there'd been a midstream removal in 2015 rather, of a duty to consult with the relevant stakeholders, and he said that was as a matter of statutory change. Well, with respect, it misses entirely entire swaths of our constitutional court's jurisprudence. Whether something is said in a policy or not about whether a duty has to be discharged or not is utterly irrelevant to the much more important question: what does the Constitution require? Does the Constitution, in the context of this case, our learned friend very correctly said that procedural fairness is always context specific. Well, in the context of this case, what does the Constitutional Court's jurisprudence around consultation require. So the power to declare the ASO is from the regulations, and the duty to consult flows from the constitutional obligations. And the government can't, by editing a policy, remove an obligation to consult with affected parties. And moreover, both Justices Southwood and Bakwa, who were unfortunately slurred by our learned friend as well, who suggested, well, there's an adventurism by judges, you go and write judgments beyond the remit of what's before them. Well, not at all. Both those justices, and you go and read Justice Southwood's judgment in particular, he details the legislative framework that he thought was applicable to this process and the interaction between the minister and ICASA, and he specifically came to the conclusion that there was a duty to consult with affected parties. And those judgments were written after the policy had been amended in 2015. But in any event, our learned friend repeatedly makes the mistake of saying that the duty had to be located, he said, in the instruments that regulated this process. But as I've said, that's not so. There was always an outside, overarching, superior source of a duty to consult. And in this case, it's the constitutional duty. In other words, ignores Scalabrini. He attempted to say something about Scalabrini, but ignored the central feature of Scalabrini. The Supreme Court of Appeal in Scalabrini made it very clear, and our learned friend Mr. Marcus stressed this, where the court knows in the context of a case, as part of the principle of legality, so quite aside from administrative action, where there's a question of context and an impact on rights, and here critically, and the court is aware, or the minister in this case, the decision maker, is aware that there are interested parties with special expertise in relation to the decision in question. Here, those special parties are SAS and MMA. There can be no debate about that. Then it is a constitutional obligation to ensure that there is consultation with those parties, as our learned friend Mr. Marcus pointed out, not just to show them respect, but also to ensure that the minister gets to take the best decision possible. So that was Scalabrini. But quite aside from Scalabrini, and ignoring all the other cases that our learned friend Mr. Marcus pointed to, including numbers of older common law cases and the constitutional court cases that went with it, our learned friends have astutely, they've assiduously ignored the constitutional court's decision in Joseph, which we referenced in our note, and Mr. Marcus had included in his note for oral argument, but it's necessary just because it puts to bed this entire debate about consultation through some or other duty to found consultation in the instrument. It really puts that all to bed because of what is said in Joseph. And you'll see it in our heads of argument. It's at case lines 021-95. The court recognized as a central feature in that case, akin to the central structure of our argument, which is there an obligation on the minister in light of threatened impact on rights? Is there an obligation on the minister? That's what this case is about. Vodacom attempts to distort our case. I'll get to that in a moment. This case is there an obligation on a minister in a constitutional state where her decision, policy or otherwise, is going to impact severely on rights or threaten rights? That's what this case is about. Now you'll see in our heads of argument at 021-95, we've given you the reference to Joseph, and I'd ask just to read this to you because it really is the full answer to much of the efforts by our learned friends to run away from the duty to consult. Said the court, you'll see we explain what was in issue in the case. The nature of the obligation was emphasized by the Constitutional Court in Joseph. The primary issue in that case was whether the applicants were entitled to procedural fairness before a decision was taken to terminate their electricity supply. Unanimously reversing the decision of the High Court and ordering the reconnection, the Constitutional Court highlighted that in the light of the rights that were given effect through the provision of electricity, including in that case housing and dignity, the applicants were entitled to procedural fairness in the exercise of the right. Why? Well, the court explained. You'll see we've quoted the passage. When City Power supplied electricity to Enidale mansions, it did so in fulfillment of the constitutional and statutory duties of local government to provide basic municipal services to all persons living in its jurisdiction. And this is the critical point. Where you receive a particular benefit, where there's a particular service that you've come to enjoy, in our case, clearly the right to free-to-air television, the right to be able to have your freedom of information provided to you, even if you're poor, including through the provision of set-top boxes, because analog television is how many millions of people receive their television. Well, said the court the following: when the applicants received electricity, they did so by virtue of their corresponding public law right to receive this service. In depriving them of a service which they were already receiving as a matter of right, City Power was obliged to afford them procedural fairness before taking a decision which would materially and adversely affect the right. So you can't remove something from somebody that they've been enjoying, whether you want to call it by way of legitimate expectation, by right, or by, in this case, a duty which is already accepted by the minister. The minister is accepted in this case. I'm going to show you in a moment that she has a duty to ensure that you have got this particular free-to-air television, right to information, analog television for the poor. That is something you do not take away from them without proper process and fairness. Now, that's true through Joseph, but it's also true through what our learned friend Mr. Marcus described as the policy decision. It's an implementation of policy in this case. Our learned friend for the minister repeatedly tried to say, well, this is policy in a Section 85 context, where under the Constitution the minister sets policy. But our learned friend has failed to grapple with Edu-College, and our learned leader referenced Edu-College, where the Constitutional Court, through Justice O'Regan, said, you mustn't make this category mistake, which the minister makes. There is broad policy set under Section 85. For example, are we going to have a particular basic education grant? Are we going to have a particular basic income grant? Are we going to be able to, for instance, roll out whatever it might be that is of an important policy basis? That's policy with a capital P, if you want to put it that way, under Section 85. That is not what we're dealing with in this case in the slightest. We're dealing with policy in the small sense of the minister's policy determinations in implementing the legislative scheme, the ECA. That's what the minister's doing. And the regulations, the digital migration regulations make that clear. In Regulation 3.1, there is a dual migration period. And the regulations say that that period begins when the minister notifies in the Government Gazette that that period is opened, and it ends when the minister, through Government Gazette publication, determines the analog switch-off date. It's through the regulations that the minister then determines the policy, in a small p sense, of the analog switch-off date. That is critically different to policy of some form of broad executive policy-based nature. It is the classic Edu-College example of the implementation of legislation, which is the noticeable characteristic of administrative action in PADGA. So our learned friends get nowhere close to explaining why this isn't immediately also requiring consultation under either Section 4 of PADGA or Section 3 of PADGA. They don't even deal with the argument because they seek their refuge incorrectly in Section 85 as policy. So our learned friend in that context has, as a result, pinned his colours to the mast. He has said there was no duty to consult. He said it. No duty to consult because the policy had removed that duty to consult with the public. He said that. So it's an error of law, a fatal error of law. And Mr. Marcus highlighted that where you commit a fatal procedural error of law, everything goes. That's the no difference principle. He's highlighted that. There was no answer to that. Secondly, we know there was no consultation on the ASO date. None. I'll get to that in a moment, but there was no consultation on the ASO date. Why? Why was there no consultation on the ASO date? Because nobody knew when it was. The minister's legal team didn't know when it was. ICASA, the statutory regulator, didn't know when it was. Their heads of argument were filed, and they were still talking about how the ASO date has not been determined. They obviously didn't get the benefit of the minister's legal team who had been given notice that this was about to happen, so they held their heads back for a day so that they could try and fix their heads to that in that respect. There's a lurking hangover where one passage still references in their heads the fact that the ASO date has not been determined. The fact is, nobody, even in the minister's legal team, knew that the ASO date was being determined. So there was no consultation. It's the end of the consultation debate on ASO. So there's never been a consultation on the ASO date with the public, with the affected stakeholders, with SAS and MMA, with ETV. There's just never been that consultation. And so our learned friend not only makes the category mistake of saying there's no consultation by ignoring all of the constitutional jurisprudence, he commits himself to an error of law before this court. He commits his client to an error of law before this court. And as a result, this court is comfortably in the position to say that there is not only a reviewable irregularity, if you don't consult when there's a duty to do so, it's reviewable. Under section 172(1)(a) of the Constitution, you have to, as a court, declare that unconstitutional. Go and read Justice Bakwa, who said exactly that in his judgment around procedural fairness. But then separately, there is, quite aside from that, there is a need for the declaratory relief, because the declaratory relief is specifically aimed at declaring that which the Minister's Council has said to you straight-faced today. There's no duty on my client to consult whatsoever. So it's necessary, therefore, for the declaratory relief as well. So that's as to consultation. The fourth theme of our learned friend's argument was about rights having been violated. And he picked up something of a Vodacom cold here, because he came with the argument, well, it's freedom of expression, but through a particular medium. Where is the right to freedom of expression? You don't have a right to freedom of expression through a particular television set or through an analog set, box. Well, the problem for our learned friend is that his own minister disagrees with him, because she's accepted under oath in this case. We've pointed this out to you in our heads of argument. The minister's accepted that there was a government promise to ensure that there would not be a switch off unless set-top boxes had been provided. There's a quibble about how far that promise extended. I'll get to that. But the minister accepted under oath that there was a promise and that there was a duty on her to fulfill that promise under Section 7 of the Constitution. That puts an end to all of this interesting semantics about what freedom of expression really entails or not, whether it's a Vodacom type freedom of expression, which is best satisfied through Mr. Snickers' idea of a trade-off between mobile operators providing wonderful data services to the poor, or ETV providing television to the poor alongside SABC. Irrelevant debate, an utterly irrelevant debate. Nice for the halls of a lecture theatre, but that's not useful in this case, because this case is about what the minister has already under oath said she accepts, which is her obligation to ensure that there is going to be set-top boxes provided to the poor. Why? So that they can continue receiving their information on their television sets. That's what the case is about. We're talking in this case about that promise being broken and about losing all the analog broadcasting, not only ETV's broadcasting. It's very unfair. Our learned friends repeatedly make as though it's just ETV arguing about ETV. No. We've spoken repeatedly in the 6 letters that we wrote to the minister, and in the affidavits, and in our heads, alongside MMA and SOS, we've said this case is about, yes, ETV's rights, but alongside public broadcasters like SABC, and of course including the poor and the public, who are in large numbers making up the affected parties in this case. So that is where this case is in respect of rights violation. And again, Justice Lukamane, you put the point to our learned friend squarely on this. You said, but when government interferes, this was your question, and with respect, it hits the nail on the head. You said, but is a right violated when government interferes with the existing mode of receiving free-to-air television? And that's exactly the point. Yes, if that's what the means is by which millions of people receive their information, their news, their sport, their educational programs, their weather, if that's how they receive it, and in this case there can be no debate that millions do. There might be a debate about the outer figure, but that millions do. 90% of South Africans own a television. Well, then that's the debate. And it goes back to the Joseph point I've already made. Our learned friend, in response to my lady's question, didn't answer it. He didn't answer it. In a number of other ways, he didn't answer a number of other questions. His answer was to say, well, it depends. You must look at the consequences. You must look at the consequences. When you're asking the question of whether government is allowed to interfere with the existing mode of receiving free-to-air set-top boxes, my lady's question was answered by him saying, well, you must look at the consequences. Indeed, absolutely. At least because, as we know, procedural fairness is a context-laden exercise. So you ask yourself the question, is a duty to consult triggered when rights are violated? Absolutely, because of the context in this case. Secondly, the minister knew that there would be consequences for the poor, which is precisely why they were encouraged to register. Why was the minister trying to get them to register? Because she knew there would be consequences for them if they didn't. And we know that they weren't small consequences. The minister must have realized, even if she hadn't done any study, even if she'd done none of her due diligence, as I put it earlier, to appreciate the impact of the cutoff date, she must have appreciated on her own stats, whatever the debate may be about how many of those millions of poor people actually have televisions, she must have appreciated that it is at least in the realm of millions of people that are likely to be affected by her decision. So that's the consequences that you have to ask yourself the question about. And here, and it's a critical point I'll come back to, despite that threat to millions of rights, the minister never took the time to do a report, to get an expert body to give her any advice about what the impact would be if she imposed the 31 October deadline in order to ensure an ASO of 31 March. The fifth theme of our learned friend's argument is what was for us a rather startling trawl through numbers of policies. So he took us on a journey through policies, the digital migration process from 2008 onwards. But he again never answered the question, and Justice Msimang, you put it to him when he started this exercise. You said to him, he'd been doing it for about 10 or so minutes, and then at one point you put to him, isn't it preferable to look at, these were your words, Justice Msimang, you said, isn't it preferable to look at where the promise was first made, to try and understand what this promise is, rather than trying to back-end it right at the date of 5 October of 2021. Let's try and get to the heart of the promise. And that's absolutely correct, because if one looks at the 2008 digital migration process, it's in 001 26. It starts at 01256. And our learned friend read from certain passages of the 2008 policy, but first of all, he read over them, in some respects not recognizing how damning they were for his case, but in other respects he just didn't read applicable passages. And I'd just like to read for you 001-261. You'll see if you see it, this is the executive summary, so here you get the context. You'll see the third paragraph from the bottom. Here's the minister recognizing the promise, recognizing the need for the undertaking. It says, in order to continue viewing television using the current analog TV sets, the public will be required to use set-top boxes which convert the transmitted digital signal to analog. Then, if you look over, so there's the recognition. Without it, they cannot continue watching their television. You know, it's otherworldly, just to digress. We hear Mr. Snickers telling us that, oh, we don't know about televisions. We don't know how many televisions. You know, it could be on their phones they're watching these things. Well, I'd rather that we focus the case through what the minister understands her obligations to be. She speaks there. She says, in order to continue viewing television using the what? The current analog TV sets. The minister's not confused. Mr. Snickers, with respect, should not suggest something that the minister's case is not. The minister knows that this is about analog TV sets. If you look at 001-262 on the next page, you'll see that the minister has recognized the critical need to ensure that the poor are able to continue doing so. You'll see it in the second last paragraph. As a means, you'll see it there, Justices, as a means to achieve universal service and access, in digital territorial broadcasting, basic STBs will be made affordable and they shall be sourced primarily from South African manufacturers in order to ensure universal service. Again, everybody asks us, well, how can ETV say that the minister's committed to doing more than just those that would register by a particular date? Well, there it says, to achieve universal service. And if you go on 001-267, there are the paragraphs that our learned friend, Mr. Mutau, read, 2.1.3.2.1.4, but with respect recognizing the import of what's said there. That's the policy promise. Universal service and access, or the availability and accessibility of broadcasting services to all citizens, is a key component of successful digital migration. In order for households to continue to receive, and again, I wish for you to underline it, television services on their current analog TV sets after the analog signal is switched off. This case is about televisions, not about Mr. Snicker's Vodacom devices that people might be able to access television on. That's the government's promise. And then you'll see that at 2.1.4, we've already all read to you that paragraph. I shan't repeat it. It's about how the government commits to doing this in order to ensure that there is a meeting of our poverty reduction goals. And then at 2.2.3, our learned friend skips it over, but it drives into the heart of this case, why this is a matter about freedom of expression and information through these television sets for these poor people who have their analog sets as the means by which they receive the information. Globally, it says poverty is associated with low access to information and knowledge. Government, therefore, not Vodacom, government, therefore, regards greater information and communication flows within and between communities and regions as an important tool in the war against poverty in South Africa. The digital divide is to some extent a cause as well as a consequence of poverty. The entire focus is about ensuring that you can, through these set-top boxes, ensure that that digital divide is limited for the poor. And if you go over at 001-270, you know that that's the feature of what the government is doing, because just have a look at the heading of this policy promise. The television set-top box, not Vodacom devices, the television set-top box as a tool for bridging the digital divide. So the divide I've just read for you, which is the poverty divide, the government has identified that the television set-top boxes is the tool for bridging the digital divide. And so, and very critical, at 4.1, our learned friend skipped over this paragraph. It says at the bottom of 4.1, something which really, we didn't think we needed to debate much. It's obvious. It's the heart of this case. It says, the timing of the availability of set-top boxes in South Africa will have a significant impact on what? On terrestrial digital broadcasting rollout decisions. In other words, you need to know how many set-top boxes are available. You need to know how many of them can get to your people on time before you switch them off. You need to know how many set-top boxes are actually going to be not just claimed by registration, but actually installed on time, because set-top boxes don't install themselves. Those are the types of questions that will have a significant impact on terrestrial digital broadcasting rollout decisions. And this really gets to the point that has been somewhat annoyingly suggested against us by all parties, that we're being childish. We're being childish in suggesting that there should be a demand that the minister meets her obligations to ensure that there's full coverage of these set-top boxes. Well, we take the minister at her word. If you have a look at 001-273, 001-273, rolling out of the digital terrestrial transmission infrastructure. Do you see it, Justices? It's a sufficient important page. Justice Msimang, I see you still looking for it. Okay. Here the government is committing. How is it going to roll out the digital terrestrial transmission infrastructure, the set-top boxes? And that's what they're talking about. The rollout of the digital terrestrial transmission infrastructure shall aim to achieve the national coverage of the digital broadcasting signal in a phased manner. And how? Aiming to cover 50% of the population. I would ask you to underline, of the population of the country, not of those that have registered, not of those that have managed to meet a 3-week stipulated deadline, aims to cover 50% of the population by the end of 2008, 80% of the population by 2010, and then you'll see, and close to 100% by 2011, thus enabling analog switch off in South African areas that are difficult to reach will be covered by satellite means. So that's why there is a fulsome embrace by us of the Minister's own commitment to ensure that the full population coverage, 100%, up to 100%, as close to as possible, will receive set-top boxes. That's why we keep the Minister to that promise. So those are the commitments. I would just very briefly, while we're at 001, ask the court, again, our learned friend read for you from this 001-312. He was speaking again through his very long journey through the digital landscape and the processes. At 001-312, it says the following, and he read this, he embraced this as a reflection of the commitment. It says, more than 5 million poor television household owners will receive free set-top boxes from government, stated the Department of Communications in a release on Monday. So the government intended and it promised to give all indigent households a box. Remember our learned friend said, he was saying, well, that 5 million correlates to the indigent people that had been referenced earlier. Well, that's the point. The government had committed to giving those indigent people, 5 million households had been identified, they were going to get the set-top boxes. So the concession is correctly made by our learned friend that the promises had been made by the government to ensure that at least 5 million set-top boxes were ensured for those 5 million households, rather, received their set-top boxes. Then, if I might continue with the points that our learned friend raised under this theme, there was a long suggestion. He said that there had been consultations and liaising with various members, including the ETVs and others of the world during these policy moments. You remember he mentioned the digital Zonga, for instance. And he suggested, well, no, there have been all these moments where everybody's been told and kept abreast of these developments. But with respect, that is absurd. The digital Zonga was only active in 2008. It's more than it's decades ago. You'll see that at paragraph 80 of the Minister's answering affidavit, case lines 009-25 to 26. And of course, whatever there might have been by way of discussions with various people along the way about this immense problem of how to migrate, we accept it's a problem. Nowhere in the papers is there any evidence that there was a consultation on the 31 October registration date. Nowhere in the papers is there any evidence of consultation on the ASO date itself. So our learned friend finishes off his arguments about this long trawl through the policies by saying that one must not judge that 6-year process. You'll recall he said this, don't judge the 6-year process by the last couple of months. But why not? Why not? As we've said, there was entirely no progress made on any of the installations. It had been stalled for a long period. Government had stopped installing set-top boxes in January 2019. That only appeared to have restarted that in October 2021. So for nearly 2 years, there was inactivity. There was no installation whatsoever. So registration was entirely pointless. What was the point of trying to go and get a box, stand in a queue in a hot day, somewhere outside a post office, shuffle your way forward to get a set-top box, but you knew that it wasn't even being installed. There was no installation being undertaken by the government over that period of time at all. And never before had it been suggested over this period of 6 years, our learned friend could not point you to one place. And again, Justice Lukamane, you asked our learned friend, where was the change in the policy? Where did it happen that suddenly people were told, hang on a moment, the promise we made is about to be qualified, you've got to register, and if you don't, you're going to get cut off. The first time that happened, Justice Lukamane, was on 5 October in the Minister's announcement. That's the first time. Before that, there was not, over that 6-year period, ever an indication that registration was going to be a guillotine, and you people who are watching analog television are going to be cut off if you don't, within a short space of 3 weeks, register. And so our learned friend asks, well, don't judge the 6-year process by the last months. But of course we must, because it's the last months that the minister takes her decisions which have the impact on rights. It's those last months, October onwards, where the minister decides that she's going to impose numbers of deadlines. And the question is, are they reasonable? Are they going to take account of the poor? And are they going to keep abreast of her promises? And for all those reasons which you've already heard from us, clearly no, they do not meet her constitutional obligations. And that's why we are focusing on those months. Then the next theme in our learned friend's argument, and I think it's an important one, is that he says registration is a reasonable proxy. You'll remember, he said registration is a reasonable proxy for who qualifies. That's not so with respect for 4 reasons. Firstly, we're grateful to our learned friend for recognizing that the word reasonable proxy, phrase reasonable proxy, should be used, because that's the test. Is this a reasonable process by which this is used as a proxy? It must be reasonable, and you have to justify this registration proxy of 31 October. But as I've already highlighted, nowhere in the papers, and nowhere by our learned friend in oral argument, did he ever attempt to justify, or did his client ever attempt to justify 31 October as the registration date? No explanation is given for why there wasn't more notice given. Simple point. The SONA was in February. If the minister knew that she was going to be aiming for 31 March the following year, why not use that period of time from February 2021 immediately to try and give notice to people that they needed to get registered, say 6 months hence, at the end of October, in order to ensure that they got their set-top boxes? Just no answer, no explanation whatsoever. All you have are the facts, and the facts are demonstrable of unreasonableness. The facts are 5 October, out of the blue, comes the notice. You've got 3 weeks or you're going to get cut off. So there's no evidence at all for how this registration could constitute a reasonable proxy. So it can't be a reasonable proxy. You need evidence to be able to explain why you've chosen a particular date. And particularly where you know that there are very many large numbers of people that are looking to you for set-top boxes. I've already read to you the policies from 2008 onwards. The government had already recognized these policies as critical to poverty reduction, the digital divide, and information that they continue to receive, not on cell phones, but on their analog televisions. And we know it's not a reasonable period. It's not a reasonable period at all, the 3 weeks, because of the minister's own affidavit filed last night. On the minister's affidavit filed last night, she tells the court that after 31 October, 260,868 household registrations occurred. Up until whenever it was, the 10th of March or something. So what was happening? These were people who were desperately trying to register. They'd now heard the news. Well, we're not going to be able to receive television. And what has happened to those individuals? Nearly 860,000 of them, nearly 1 million South Africans. None of them will get a set-top box. The minister's affidavit says so, because she hasn't sought a deviation. So it cannot have been a reasonable period, because the facts speak to the unreasonable result. The unreasonable result was they cut off already those that were eligible in the numbers of 260,000 households. They're simply not going to include them. They're not going to get a set-top box. I ask you to imagine this. I'm giving you the example of a social grant. So the poor. 10 million of them in a particular province receive a social grant. They've been receiving it for a number of years. The minister sends out a notice to say, we've changed our service providers from CPS to the post office. So you need to register to continue receiving your social grant. You've got 3 weeks to do so. And those of you that register to be moved from the CPS grant database to the post office grant database, you're good to go. Can you imagine if at the end of that 3 week period, it turns out that because people were poor, or because they didn't have information, or there was just too short a period of time, of those 10 million people who we know needed those social grants, 8 million of them didn't register on time. Could it possibly be right that one says, well, they should have put up their hand, they were given an opportunity, tough luck to them, they just didn't make it? It can't possibly be correct. They've got a right to receive this. The government knows that without it, they are in trouble. Or in the same way, the government knows that the individuals that they've recognized as to the tune of 3.75 million poor households, those potentially are affected if they don't have a set-top box before switch off. It cannot be the case that one says, well, tough luck, they didn't get around to registering, so therefore we must assume that they don't want a set-top box. No. What one must assume is that the notice period was too short. That's what one must assume. And the reasonableness of this is clear, or the unreasonableness, as I say, is clear from the fact that we know that there were 260,000 households that tried to register after the cut-off period. Yes, Justin.
When you say, using this argument that 260 people registered after the deadline was given, I mean, they were told, you must do this field in which you won't get the set. Then, I mean, these figures that you see are huge. Doesn't that lend that thing credence to what is being said, that it's because of a deadline? There is this apathy that people, when are asked to do certain things, they don't do it. In these few months, you get a deluge of registration, whereas over the past 5 years, your registration would have been maybe, I don't know, 50,000 or even less per month. What do you attribute that to?
Well, it may well be that the news got out that you needed to register. No question about that. The question, of course, though, Justice Basimang, with respect, is, was the 3 week notice, which, as we've highlighted, I don't want to take you through the time, you'll see it in your own studies. It was far less than 3 weeks for numbers of people. But the question is whether that 3 week period was a sufficient amount of time to ensure a large enough coverage of people so that you didn't leave out an unnecessarily large number of millions. That's the point. And so, yes, some people may have attempted to register, but we know that that in and of itself didn't help them because, as we've already highlighted, 260,000 households, the ministers just decided we're not going to be able to help you because we didn't get the deviations in time anyway. So on either context, it doesn't work. The figures don't help.
With Judge Musimang's question, it actually occurred to me now, and I mean, it should have occurred to me earlier, but it now occurred to me that I'm wondering what the date did to other people. For example, I'm wondering if other people didn't give up once they missed the cutoff. They thought it's done for us. So, I mean, it's just a question that I'll try to find information on about. But it occurs to me that some people might actually have thrown up their arms to say we missed the cutoff.
Yes, well,
continue.
No, thank you, Justice Lukamane. I think it's a valid point, and it raises the concerns. A learned friend say that it's unfortunate that ETV keeps saying, well, we don't know. Well, no, it is. It is unfortunate for the court we don't know. These are the types of things which ultimately the minister had a duty to provide. And I'll come back to that when I deal in a moment with the suggestion particularly embraced by Mr. Mukari around ETV having to be dominus litis in the matter. I will come back to that in a moment. If I might turn then to the next point, which is that our learned friends said that there'd never been, nobody says that there was a problem with the manner of registration. Those were his words. He said nobody has complained about the manner of registration in this case. So his theme was, it's fine to use registration as a reasonable proxy for who qualify. And then he went on to make, with respect, an entirely unfounded accusation or assertion. He said that nobody says that there are problems with the manner of registration. That's absolutely not correct. We, as ETV, certainly complained about the sudden imposition of the cutoff date. I'm just going to give you the pages. It's in our finding affidavit, para 16T.2, 160.2, 001-65 to 66. And we also said it in our finding affidavit, paragraphs 142 to 144. That's case lines 001-58 to 59. So we had criticized very severely this particular manner of the registration being imposed, and we said it was entirely irrational. There was no reason for it. There was no explanation for why it had to be done on this basis, and it clearly was going to impact upon numbers of people's rights. And we said something which MMA and SOS have also said. We said, how could the minister have done this when she had no report on her side? No due diligence, as we've said. None. She simply had no idea what the impact would be of imposing a 31 October deadline date. She might have liked to have thought, Justice Msimang, that this might encourage people. That might have been something that she thought was a good motive. Well, let me get people to really get out there and start registering. But that's not good enough. The question is, what would the impact be on their rights by such a short deadline across these provinces for people who otherwise had for years thought that nothing was happening with digital migration? Set-top boxes weren't even being installed. So the critical question is whether 3 weeks, and in many respects less than 3 weeks notice, was reasonable as a knockout blow. And as we say, there's simply no evidence by the minister as to why 3 weeks was chosen, why 31 October was imposed as the deadline. And there's no evidence at all of any consultation with any affected parties about that deadline. MMA and SOS say that emphatically in their affidavits. They say that there's this accusation that everybody knew about 31 October because they were involved somehow in these steercom meetings. But as MMA and SOS say, we weren't at those meetings, and we represent the public. We were entirely blindsided by the 5 October notice, as were the public, that 3 weeks hence they would have to register. Then our learned friend, the next theme in his argument is our learned friend suggested that he was attempting to explain, as I understood him, I hope I understood him correctly, that they hadn't sought to file a further affidavit in the case on behalf of the minister. Because, as I understood him, he said, even though this is a constitutional case, the usual rules on pleadings work, and it's not permitted simply to file a fourth affidavit in the case. So ETV filed its reply, and the minister was not permitted to file a fourth affidavit. But that misses again entirely two things in this case. One is the judgment in Tantush, which I think the court is well aware of. It's 2008, volume 1, SA 232T, that's by His Lordship Mr. Justice Murphy, again in this division, at paragraph 51, where he said emphatically that if something is said in reply that calls out for a response, and here I've already highlighted how ETV called upon the minister in reply to explain how many had registered, what was being done, how were you rolling out. Then said His Lordship Mr. Justice Murphy in Tantush, it is appropriate for you to seek leave to file a further fourth affidavit and to put those facts before the court, failing which the probabilities will then tilt in favor of the applicant who said what they'd said in reply. So that's precisely why, unfortunately for the minister, her efforts not to have put evidence before the court tilt the probabilities in our favor. But in any event, as I say, it's a bit of a sterile point by learned friend because he eventually put up the affidavit late last night. And I've already highlighted how through that affidavit, there is simply no real answer to any of the points. So that's the next feature of his address, which was in response to a question by Justice LaRue about the rate of installation. Because I think Justice LaRue said that she was concerned about whether the rate of installation could give comfort. That, for example, there would be a sufficient rollout of, in particular, the 507,000 set-top boxes that had to be done in the 2 weeks left between now and 31 October. Those that did register, in other words. And our learned friend's answers were revealing. He had been warned correctly by, I think, Justice LaRue, that of course he would have to say what he could, but without giving evidence from the bar. So he was limited to saying the following. He effectively gave these four answers. First, he gave the answer that, well, it's the minister, it's her ipso dixit. That's what she said. And so one should, I suppose, infer that she's to be trusted on that score. But the problem is it's not what the minister said. There's no confirmatory from her. It's what the acting DG said. Secondly, we know that the acting DG's affidavit filed last night, I've already highlighted this morning. We know that post ramp up, after 31 October, is only 107,000 set-top boxes installed in households over the last 4 to 5 months. It's 23,000 per month. There's just no response from our learned friend to that, nothing. Other than, well, believe the minister when she says she can do it faster. She can go from 60 kilometers an hour to light speed. That's really what he's asking the court to believe. Well, that's implausible, and it's against his own facts, which we've highlighted, and there's just no response from them on it. And then the fourth point is that the further report after 31 March that he promises, our learned friend, remember, says, well, the minister will give you a report and it will be given to you at the end of this period after 31 March. Well, that's with respect, that's of no value at all, because by then, under the government gazette, the switch-off date would have happened. Switch-off would have happened. It's the equivalent of the minister saying, well, give judgment, and I'll tell you afterwards if I made a mistake. Well, with respect, it doesn't work like that. The court is duty-bound to tell the minister on the facts, and that which she hasn't explained, that she has already made a mistake, fatal mistakes, refusing to accept the duty to consult, refusing to give any information or reasonable explanation for why she's chosen 2 dates, any explanation for why she's not consulted on those dates, and other than for the idea belatedly raised in heads that, well, there was a change in a policy at some other point, which meant she didn't need to do so anymore. And by the way, on that policy point, it's something that Justice LaRue highlighted. The policy point, even if our learned friend were right on it, only helps him out on the ASO date determination. It doesn't help him out at all on the 31 October deadline, because the ASO date point is obviously limited by him through his understanding of the regulations as read with the policy. So that's in respect of the rate of installation. It doesn't give any comfort. And then let me just finish off on that point briefly, if I may, by Justice Lukamano's points. You said, I wanted to have information, you said. I wanted comfort of information that had actually been dealt with. And you raised, with respect correctly, the problem of provinces that have already been switched off, Justice Lukamano. Why is there no information about why they have been prioritized or not prioritized? What's happening to the people there that have already had their television switched off? They've been left behind and they're still sitting with nothing. And the separate problem is, of course, it never deals with at all. You said you wanted information to give you comfort. As I've said, there's just no response at all about the real problems of 23,000 per day. But there's a further very, very important feature of this case, which both the Minister and Vodacom have overlooked entirely, and that's what I said earlier. Registration is one thing, but set-top boxes don't install themselves. There's a very big difference between registration and installation. And you know that there are significant problems with installation when it comes to the post office. The post office has said so in 005-379. It's at case lines 005-379. I just want to make sure I've got the right one, sorry. Yes. You'll see at 005-379, it's a press release by the post office. Now's the time to apply for a subsidized TV decoder. By the way, you'll note that's 21 October, 9 days to go. Everybody who happens to go to the post office gets to know that they've got 9 days left to go. And then it says a whole range of things about how this must be done. The President's State of the Nation address, qualifying households will receive a decoder and so on. All South Africans with an income of 3,500 per month or less qualify. What you need to bring, South African ID document and so on. And then you'll see the 4th last paragraph from the bottom. Once an application has been approved, the information is given to Centec to appoint a local installer to install your set-top box. The SA Post Office is aware that some families registered for a set-top box at the beginning of the campaign. In other words, from 2015 onwards when all of this started. But the installations have not been done yet. This is on the 21st of October. This goes directly to your point, Justice Likamane. Who even knows whether those who've got set-top boxes and who registered before this time were even having them installed? Installations are done per province and appointments of local installers are done by Centec and via local municipalities. So with respect, the idea that it's all good and well just to highlight how many people have registered is enough to satisfy, to give you comfort as a court that people's rights are not being violated or threatened is on the post office's own evidence clearly concerning. And then the 9th theme of our learned friends' argument rather, is this question of the additional households of 260,868 households who'd registered, but there was, as you will have seen in the affidavit, absolutely cold comfort for them. They were simply left off. They're not going to get set-top boxes by 31 March. Why? Because there's not even a deviation that's been applied for them. And our learned friend never dealt at all. He read to you what was in paragraph 18 of the minister's affidavit at one point, but he never explained at all what that actually meant. How was this the case that they could have been left behind in this way? The best answer he could give was to give no answer with respect. And he read paragraph 22 of the minister's affidavit because he was asked about this. He was asked, well, how do we get comfort about these individuals? 260,000 odd households, 800,000 odd people. And his best answer, as I say, was to give no answer because he read paragraph 22 of the minister's answering affidavit filed last night. This is what is said there. The department is satisfied that the deadline of 31 March will be met in respect of households that registered by 31 October 2021. That's it. They are satisfied. Ipsa dixit. And it will accelerate installations for those that registered post 31 October 2021 when, once the aforementioned unknowns have been ascertained, i.e. the information is crystallized. That is such scant, vague, bland assertion that with respect, it is the type of rights violation that calls out for this court to not only declare it so, but also to grant the relief that we have suggested is required under the Constitutional Court's remedy jurisdiction. Then our learned friend dealt in detail with ETV having sat in various meetings, and he said that they had notice, and so therefore everything is fine. Well, I have to just give you the passages where we highlight that all of those meetings were effectively, and unfortunately the case, we say a sham, and we say that without, I'm just trying to find my note, I had it here somewhere, apologies for a moment. We have set this out in our affidavits, you'll see at case lines, finding affidavit, paragraph 17, case lines 001-18, and we have highlighted how the process was an utter shambles. We were called to meetings with no notice, no agenda was given to anybody. We were asked to arrive, and then we were told that the plan that we were invited to come and consult on had already been approved by Cabinet. It was an utter shambles.
Well, that was actually something that occurred to me, because on my notes, I actually did a correlation or some sort of a correlation of the meetings as they took place and certain announcements being made. So there was some sort of, the meetings would take place and something would happen, or something would have happened immediately before. Maybe it's just a coincidence, but all the meetings were almost linked to something happening as a decision or an announcement. But you may continue.
It may or may not be. I'm not sure whether it's coincidence or not. But what I can say emphatically with those references that I've given you, CLO 001-18 and CL 001-167, that there certainly was nothing more than a fig leaf of consultation as regards ETV. That's the first point. The second point is there was absolutely no consultation with SOS or MMA. They've said so in their affidavits. So the public wasn't consulted in any of those meetings. So even though there were meetings with broadcasters and Centec and others, the public never had any indication of what was going on in those meetings. And the
Mr. Duplessis, on that score,
yes.
Insofar as we talk about the interveners,
yes.
And what now, after Mr. Mutau has, after Mr. Mutau's presentations, it will appear that these interveners have been there all along. They've been there all along and they know these processes and they've been part of litigation. Why? And it doesn't appear from any of the documents that they were ever involved in these meetings and all that and all that.
Yes,
so my question is that the case? And why do they make an appearance only when it goes to court? But if they really and truly are, what's the word I want to use? If they really are, I want to say those watchdogs for the public, one would have expected them to have been proactive. And some of these meetings should reflect their presence now that they've been in other litigation involving the same parties.
Well, Justice Masimang, first of all, you're right that they had previously been involved in other litigation. So there can be no debate that they were interested parties. In the Scalabrini mold, they had special expertise in relation to these very issues. So there, in that respect, you're correct. But with respect, you're not correct when you say, well, they should have found their way into these meetings. They weren't invited. They say so in their affidavit. They were not party to these meetings because those were closed meetings with stakeholders and they were not invited. The minister invited certain people, but not SAS and not MMA. They say that under oath in their affidavits, and I'm sure Mr. Ferreira can deal with it further. That's why I'm saying it's striking that an interested party who had otherwise been involved in litigation and who the minister knew represented the public was not involved in those meetings. That's a failure of consultation on that score alone. Under the Scalabrini test, quite obviously they had an interest in being able to understand, at the very least, what was going on with the registration dates and the ASO. And as regards ETV, who was at those meetings, Justice Masimang, you will not find anything in the record that says to ETV that there is a consultation with them around the question of the ASO date and the question of the 31 October date, in as much as, is that a right date? What are the impacts going to be? How many people might be affected? Quite the opposite. It's simply a case of the minister is going ahead with this plan. That's what she wants to do. So that leads me to I'm nearly on to Mr. Snickers's point. I'm sure everybody will, Snickers's points, I'm sure everybody will be happy to hear. But unfortunately, there was a very long argument, and I do need to do justice to what the Minister's Council had said. There are two further points by the Minister's Council, and I'll wrap up on that score. The first is the question from Your Lordship, Justice Msimang, that ETV must prove that there are 2.5 million households. What you said to Mr. Matau, what do you have to say to that? And Mr. Matau, interestingly enough, again, he ducked the question. He ducked the question. He said, well, we have confined the approach for the minister to those that registered. In other words, their case is only those people that made the 31 October deadline. So if we're right on that deadline being unreasonably short and set without consultation, his entire case falls, because that's his case, nothing more. But the difficulty for him is that those numbers are indeed set out clearly in the affidavit that we filed this morning. So, Justice Msimang, you have in numbers of ways, I think, been troubled by this problem. And I did attempt this morning to take the court through those numbers in detail. I shan't do it again, but I'll just give you the references, because it is critically important to know that where we have provided the numbers, those numbers have been provided off the minister's evidence, what the minister gives. So to understand the concept of this argument, the Bill of Rights protects people's rights. In this case, the minister has accepted a constitutional obligation in relation to those rights when it comes to digital migration. So there's no debate about the obligation and the rights. There's no debate about it. She's accepted that. The question is the policy decision that she's adopted consistent with the Bill of Rights, or do they threaten the Bill of Rights? Does her decision threaten, or does it respect rights? We've highlighted on her own figures that there is a very real risk to very many millions of people's rights. We know that, not only by virtue of their own showing that at least 200,000 odd households are going to be left behind, 800 million people, because they didn't register on time by 31 October. But we also know that there is, on those figures which I highlighted in this morning's address, the Broadcasting Research Council that the minister has embraced as her answers. The minister has accepted those figures. So Justice Msimang, in respect of her obligation, she knows that those are the figures, she's not disputed them, and there are currently 15.8 million television households in South Africa, over 90% of the population. And it's undisputed that 36% of them, that is 5.7 million households, still receive free-to-air television via analog transmission. That is undisputed. Our learned friend Mr. Snickers says, well, how do we know how many of them receive television on televisions rather than devices? Well, it's undisputed that 36% of TV households, 5.7 million households, still receive free-to-air television via analog transmission on their televisions, because you don't receive analog on your cell phone. So that's the point. Those are the figures, they're there, and we commend to the court in your own time to go through paragraph 41 of the affidavit that we filed this morning, where we've attempted to collate for you each of those figures, the references in the record, where they're not disputed by the minister, and we've tallied those figures to show to you that on the minister's own evidence, she accepts, on her stats SA numbers, Justice Msimang, she accepts that there are 3.6 million households that are still reliant on analog transmission. She accepts, that's her figure. We say there are 5.7 million households, and she hasn't disputed that. But then in her own affidavit, she goes on, she tries to diminish the number, and she says, according to her figures on the stats SA, 3.6 million households are still reliant on analog transmission for their television services. And that, as we say, is strikingly similar to the 3.75 million households that she says are eligible and have been promised government set-top boxes, given that they earn less than 3,500 a month. So those are the figures. And Justice Msimang, it's not for us as the applicant as a dominus litis to try and prove what rights have been violated. We've proved that there is, on the minister's own promise, to provide set-top boxes, an obligation to ensure that those rights aren't limited or violated or threatened. It's now for the minister to show why she can justifiably show that those rights are not going to be violated. And we've done so. We've done so with the note that I gave to you this morning, and I'm going to have to remind you again of it just for purposes of time. It's 021-327. It's the note that we provided this morning, ETV's case authorities for argument in response to the minister's supplementary affidavit. And you'll see it's under the heading, the duty to justify. And Justice Bisimang, in a constitutional matter such as this one, where rights are implicated and the legality of the minister's conduct and the reasonableness of that conduct is impugned, as it is here, not just by ETV, but also by MMA and SOS, then there is an evidentiary burden or a duty to justify. The Constitutional Court uses different language in order to show that you as the minister have acted reasonably. And in the Nuclex case, I haven't given you the actual paragraph. It's a different judgment from Justice Nwalbo's judgment, but if needs be, I'll put it up as well. We've cited the Nuclex case. But what's interesting about that case, because it goes directly to your point, Justice Bisimang, Justice Nwalbo says, where information is exclusively in the knowledge of the decision maker, here it's the minister. The minister must know. The minister is in charge of this. It's the Minister of Communications. Then it's for that decision maker to provide that information to the court in justification of what is a threatened rights violation. If that hasn't happened, then the minister cannot justify. And then that means, at the end of the day, there is a rights violation. Let me finish off this point very quickly by highlighting that, remember what my learned leader, Mr. Marcus, said yesterday. If you embrace, as the minister has entirely, the fact that there is a policy here that is the basis upon which they can act, that the minister determined the ASO date through the lens of policy, not through the digital migration regulations. Remember, that's the argument. They're trying to get away from consultation to say that this is through policy that they've done this. The moment that is so, it's not a law of general application. And you cannot limit rights other than through a law of general application, a law of general application. You cannot limit rights through a policy. So they fail that test on that version as well. And then finally, from the minister's side, there's the minister's tender.
Before you leave that point,
sorry,
before you leave that point, because what I put to them, I also want to put to you. To say, if the minister says, I'm working from Stats SA, and according to Stats SA, there are so many households that receive that have television sets, and there are so many households that earn less than 3.5 million rands per month. So I would then identify 3.7 million households and say, from these households, 3.7, that's where I want to attract, that will be my pool, where I would attract families that are within that category and receive analog. And the minister then invites those families to say, I will give you decoders because you fall within this category, within this pool, but all you have to do is to apply. And out of that 3.7 million, about, let's say, 1.2 million applies. And the minister provides this 1.2 million. And then there is 2.5 million, for some reason or the other, have not applied. Is ETV's case that those 2.3 million must be multiplied by 3.3 according to the figures of Stats SA, as that those are indicating that what average family is, and then use that and say 8 million people or 8 million people or households, in fact 8 million people from those households do not, will be cut off. So I say, the minister can prove her 1.2 through the registration, but if ETV, the applicant, wants to come here and say, I must accept that 8 million of those families have been cut because they didn't apply and the minister doesn't provide for them, shouldn't it be the applicant that proves that 8 million to say these 8 million people will not get television because they are on analog and they've been cut? Should that not be the honors of ETV? That's the question I was asking to everyone.
The applicants did provide the court, Justice, with the BRC figures. So we've met the test. So I would ask you to please read paragraph 41 of our affidavit, which we put up this morning. So we met what you've suggested was required of us if we were a dominus litis in your example. We have provided that evidence. But there's a second answer to that, and that is that it's not that we need to prove that all 8 million people are going to be cut off, all 8 million households. That's not the point. The point is that they are at risk. Their rights are threatened. And you recall, Justice Masimane, that I said this morning, under Section 38 of the Constitution, a party like ETV is entitled to come to court and is entitled to relief from the court by saying either that rights have been violated or that they have been threatened. On the facts that you have before them, we can emphatically say that those rights are at risk or threatened, even if there isn't clarity about the actual final amount. And then finally, on your point about the pool, Justice Masimane, I've already given the arguments about why we don't think that this was a reasonable means by which registration could be a proxy for limiting the number of people that came into that pool. The pool was made incredibly small. It could have been much bigger, Justice Masimane. It could have been far bigger had there been 5, 6, 7 months worth of notice given to people, proper campaigns. Instead, there was 3 weeks given, which in many cases was far less than that. And that's why the pool was constricted. And it was constricted to a point where, at the end of the day, numbers of people in the millions were no longer able to be in that pool. And that's the argument. Then the debate is, does the minister satisfy the test of explaining why she chose that mechanism to make the pool that small, knowing that numbers of people outside that pool would not be able to get television any longer? That's the case.
And the argument of the minister, the way I hear it, and that's why I want you to engage you on that.
Sure.
The argument of the minister is that from the 21st of October, they were now anticipating a cut-off date. This program has been going on for the past 5 years. That's what she says. And they say there must be a cut-off somewhere. It can't run ad infinitum. What do you say to that argument?
I think I already gave the answer earlier, Justice Masimane, where I said the idea of the minister saying, well, don't look at the whole, why are you only looking at the end of the process? Why look at the end of the process? It's been 6 years. Well, no, as I've already highlighted, for nearly 2 years in that process, from January 2019 all the way through to October 2021, there were no set-top boxes being installed. That's the first answer. Secondly, we know that even for those people that did get set-top boxes, we know that the post office, from what I read to you, said that we know that there have been problems with installation. People have got set-top boxes, they haven't even had them installed. And then there's the third and most critical problem for the minister, and that is there's a 3-week period. Why? Right at the end, telescope 3 weeks for people with no notice to them. After all this inactivity, out of the blue, they've never been thought that there was a problem for them if they didn't register, so much so that they'd have their televisions cut off. Not just a case of doing, well, we must register so that we can get onto the government database and we can be able to show that we're interested in the government's policy. If they don't register, they will be cut off. Their televisions will go black. They will not be able to watch it any further. That is a very significant constraint. And you don't do that to people with 3 weeks notice, with respect. So those are the arguments, and the court is either with us or against us on those points. So we would finish off that point though, Justice Masimane, just to ask this question. You said 2/3 of the poor didn't register on time. And ETV extrapolates that to say, well, that amounts times 3.3, it amounts to a very large sum, 8 million people. Well, 2/3 of the poor, one just has to ask the question, are offered, if they're registered on time, a free set-top box to continue watching television. The poor who earn less than 3,500 Rand a month. MMA and SAS have already highlighted in the affidavit that it is cynical to think that people who earn less than that have the means to get television through other packages, through cell phones and data packages and so on. They've made that point. They are the experts in this field, not me. So the question for you, Justice Msimang, must be in that context of 2/3 of the poor. Why would these 2/3 not take up this offer to continue receiving television? There's one answer, which is, it's implied, it's inferred. It's that, well, they were recalcitrant, or they were lazy, or they didn't get out and get their houses in order fast enough. But that's simply not the position. The much better answer is not that the poor were dysfunctional or slovenly or didn't do the necessary to register, as is required of them. It's that the system by which they were to register was dysfunctional. That system of a 3-week period was entirely unreasonable. That dysfunctionality, rather than the poor being blamed for not registering on time, is the real issue in this case. So if I might then deal very finally with the minister's tender, because as we understood the tender by the minister, and he will accept that we're attempting to make sense of his tender through his argument, it's that the tender is that they will install 507,000 set-top boxes by 31 March. In other words, those that did register on time. So those 507,000 remaining in the next 2 weeks will be installed. That's the tender. And that the court will get a report from the minister sometime after 31 January that it has done the installation.
31 March.
Is that the tender? 31 March, sorry, thank you. So the tender is effectively, we'll install by 31 March and we'll report that it has been done to the tune of 570,000 set-top boxes in households by 31 March. But of course there are numbers of problems with that. Firstly, it leaves out the 260,868 who are registered late. It leaves them out entirely. So it doesn't help them in the slightest. There's no tender in respect of them. And there's obviously nothing that the minister's willing to offer in respect of reporting or in any way giving you any of the facts, Justice Msimang, that you say you want around the millions, the forgotten millions. There's no tender by the minister in that respect. So the court's in no position to know how many of those indigent millions will actually be impacted. Just don't know. So the tender is, with respect, rather meaningless for the remedy that's required in this case. And of course, if the promises are not kept, people will have been switched off. It'll be too little too late for the minister to come to court and say, well, sorry, we didn't make the deadline. We didn't get to, in fact, migrate everybody like we thought we might. There were problems with Centec, and there were riots in particular towns, or whatever the answers may be. We don't know. But if the promises are not kept, the reality is people will be switched off. Rights will be breached. And you can't undo those breaches of rights. That's precisely why you come to a court when rights are threatened under Section 38 of the Constitution. And so we know that this will happen on 31 March because the ASO is a hard deadline. It's been gazetted. There will be a blackout. There's no means to correct that. And so the tender with respect is meaningless beyond 31 March. The next problem for our learned friends finally on this is that he insists on remedy that we can't review the ASO date. You'll recall he says we can't review it because the minister's decision on the ASO was taken after pleadings had closed. You recall that. But there were 3 quick points. Firstly, we set out very clearly in our affidavits, including ultimately anticipation that the minister might actually proclaim this ASO date, because she'd been keeping her cards close to her chest, not wanting to tell anybody, refusing to make any public comments about this, and refusing to consult on it. So we reserved our rights to say that if the minister does in fact set the ASO date, we, for these reasons, and we set them out clearly in our affidavits, substantively and procedurally, the minister's decision will be unlawful. So there's no need for us to have any new arguments or affidavits filed about that. We'd already set that out in detail in our final affidavit. The minister chose not to justify. The minister chose not to answer that. Why? Because she adopted the position, I haven't yet set the ASO date. That was her argument. So she attempted to shield from judicial scrutiny a vital regulatory decision of her own by not taking it. Then when she took it on the eve of the court hearing, she then through her counsel says, haha, too late. You can't review my decision because I took it after pleadings were closed. No, that's again, that is a failure of openness. It's a failure of 165.4 of the Constitution, and it requires, as we say, a simple consideration of all the arguments we'd already made in our affidavit to explain why we're entitled to that review relief. But even, there's a second point, even if you don't go through our affidavit, on the minister's own showing now at this court, she insists through her counsel that there was no duty on her to consult on the ASO. As a matter of law, you don't need facts for that. It's a matter of law. We've all argued it. As a matter of law, she says I didn't need to consult because this was a change in the 2008 policy when 2015's amendment came in. But if she's wrong on that, which she emphatically is, then that's an error of law. And the court is perfectly entitled to say that there's an error of law. The minister has not understood her own process. And of course, to the extent that the minister insists, as she has through her counsel, that she was taking the ASO decision not under the regulations, but under the policy, well, that's another error of law. And again, you don't need facts for that. The facts are all there. She's put up the government gazette, or we had to put it up because she didn't, but it's there on case lines. There's the government gazette which says, I took the decision as the minister to gazette this date, and I took it under the digital migration policy. Well, we've explained she's wrong in that score. It's certainly an error of law. So the review can be granted without a problem. If I might then turn to Mr. Snickers' argument. Firstly, Mr. Snickers for Vodacom entirely miscasts our case. He turns it into what would be helpful for him, which is an argument about interdicts. And he repeatedly makes the case that this is a matter about interdicts. Of course, before I go any further, one central strut of his case has been taken from him because his argument in his head was, well, you can't interdict the minister from setting the ASO date because she hasn't yet done it. Well, that's all gone now. But he entirely miscasts our case because he wants to make it about an interdict case. But our case, as I've attempted to belabor this point, unfortunately it's been necessary, our case is about the minister's obligations, where she's made a promise to people who need a set-top box to continue watching their analog television. That's the case. And our focus on this case is declaring that the government has a duty in that context, a constitutional one. And it undertook that duty. And the ministers accepted her obligations under oath. And that's why we say if the minister's obligations have been accepted under oath, but she says her promise doesn't extend as far as we say it does, that her promise only gets to 31 October and everybody that's registered, but we say it's more than that, then there's a proper debate about that obligation. And then our case is about whether we're entitled to have the minister told by this court that she's wrong about having set that date. And when the minister says to this court and to us, I didn't need to consult about any of this, and she turns out to be wrong in it, as she is, then we're entitled to ask this court to declare that she was wrong about that. And the declarations that we seek are under that framework. That's what the declaratory and reporting relief requires. You need to migrate people, and it needs to be something that's done without violating their rights. You've accepted an obligation in respect of those rights. And so therefore, with great respect to our learned friends for Vodacom, it's an unfortunate twisting of the case to make this repeatedly about an interdict. So it's also important to remember that we never sought to interdict the process. Our relief that we've prefigured and now appears in the notice of motion was always stressed in each of ETV's 6 letters to the minister. Go back and read those letters. We said to the minister, what are you doing about consultation? How many set-top boxes are available? What is your public awareness campaign going to be? How many people are you actually going to be able to get set-top boxes to in time? Those were our questions. Why did we ask those questions in the letters? Because we had identified in those letters the public promises that the minister had made. Our engagement with the minister wasn't to try and interdict digital migration. Our engagement was to try and get digital migration done, but properly, by these promises being respected. So that's what our case was. And so you know that that's the correct framing of the case, because that is the same approach that the parties who represent the public, and they hear before the court, MMA and SOS, they similarly make the same points and they seek similar relief. So it's entirely inaccurate to suggest somehow that this is a case just about an interdict in disguise in some other way. The second point our learned friend makes for Vodacom is he says, well, this is a case where I think he put it flamboyantly, we make fundamental errors, he said, in understanding freedom of expression rights. Well, we don't agree, because we've seen this case through what the minister's obligations have been. We've read them to you in the 2008 policy, where she said it's a universal promise. I want universal access, and I'm going to make sure that this happens by rolling out set-top boxes to all of South Africa's population. That's what she says. And so why does she say it? Because as I read to you from that policy, she recognizes that a critical feature of the digital dividend is ensuring that people continue to get freedom of their information through their analog set-top boxes, TV. That's what the case is about. And so we recognize that as the Section 7.2 obligation. Our learned friend's entire argument against us, in all of his argumentation this afternoon, he mentioned ETV on numerous occasions, but he made not a single mention of MMA and SOS's case. He made as though they and the public that they represent don't exist, but they do exist. And SOS and MMA have explained precisely why it's critically important to understand what their rights might mean in this process and how they are threatened. And he also misses the point with respect that this case is a concern not about just allowing ETV and its viewers to continue after switch off receiving analog television, or television rather, on the analog television sets. It's also about the SABC. We've spoken about that in our case. We've said it's SABC, it's public broadcast, it's not just ETV, and that's of course what MMA and SOS have also said. And this is not a case, our learned friend is quite wrong with respect. It's not a case about two goals: cheaper access to either data through Vodacom and other mobile operators, or cheaper access to television like ETVs. That's not what this case is about. The minister has already told the court what she accepts this case is about. Vodacom's efforts to try and shift this case away from what the minister has accepted is telling, but it's unhelpful. The minister has already committed that she will assist access for the poor who cannot afford to view television without a set-top box. And she has accepted that the right to freedom of expression is as set out in her own policy. And the minister, it's the minister that's keeping her promise in this case to keep free TV for analog viewers. There's a debate about how far she says her promise must go, but she's accepted there's a promise here, and that she needs to make sure that those set-top box viewers who are needing them for analog television to continue to receive their TVs get government assistance. And so this case is about the service they enjoy, and it's about the service that, as I've highlighted to the Joseph case of the Constitutional Court, will be taken away. This case has got absolutely nothing to do with what Vodacom suggests is some or other tussle between freer or rather cheaper access to data on the one hand versus cheaper access to ETV's television. And so there's a further reason why our learned friend is wrong about his freedom of expression categorization. It really is the cake, it's a case rather of the proverbial eat your cake moment. It's this sort of example of, well, it's too bad for those who might be switched off. Because, you know, we as Vodacom can give them our data. You know, if they would only recognize that it's going to be good for them if they just got switched off, they would all be able to get data from Vodacom. Well, with respect, that doesn't lie in the mouth for a corporate entity to make that type of claim, where you've got the evidence of MMA and SAS saying that these individuals, these poor people, who are recognized under the statistics that we've highlighted, do not have the sums of money to be able to access what Vodacom suggests is accessible. That's precisely what the minister's recognized. I can't repeat this enough. Why would the minister have recognized her policy? Why would she have adopted it? She recognized that the poor needed set-top boxes, not so that they could watch and stream soccer matches on their Vodacom phones, but so that, as her policy says, they could continue watching television on their analog TVs. That's why she's adopted the policy she has. And so this is not just a case rather of proverbial eat your cake from Vodacom's side. It's a proverbial let them eat our cake. The minister doesn't want that position, but Vodacom does. So it's not correct with respect to recast the case in that way. And while Vodacom would proverbially love for large numbers of people to eat more of their cake, that's not this case. This case is not about their cake or ETV's cake. This case is about, dare I say it, analog televisions that people in their millions use to access TV. Our learned friend then next says that ETV is no concern for anybody who does not have a TV. So it says ETV seems to be totally fixated on people with televisions. Our learned friend says our case is ETV is concerned with people who earn less than 3,500 Rand and who own a TV. Well, absolutely. We're in very good company in that school. First of all, it's not only our concern, as I've said, it's the ministers. I've already highlighted all the passages from her own policy where she speaks about that concern for people who own these TVs. Secondly, we're in good company because MMA and SAS similarly are worried about these people who own these types of TVs and who otherwise won't have access to their information after switch off without a set-top box. And then thirdly, it just so happens that 90% of our population own televisions. So 90% of the population are TV watchers. That's how they receive their information. So when ETV is concerned about TV viewers and TVs owned by people, well, no surprise. The bulk of our population watch television. And you'll see that in our affidavit filed this morning at paragraph 41.1. We reference the statistics. You'll see from MMA's finding affidavit by the Broadcast Research Council. It's the Television Audience Measurement Survey, it's the TAMS survey, which, as it says at 41.1, there are currently 15.8 million television households in South Africa, which is over 90% of the population. So yes, we do have a commendable concern for televisions, and that is our focus, but for good reason, as we say. Then our learned friend says, well, you know, just notice that the national broadcaster, SABC, is doing its public duty and switching off. That's not an answer at all. What's the result of them switching off? Justice Lukamani asked the question, well, what happened to those people who had been switched off over the past couple of months? What do we even know about them? What about those that have been switched off that the post office specifically says We don't even know whether people are getting their boxes that they're registered for, because installation, we know, is actually not really working out so well. So that's precisely why one should be particularly concerned about the SAB switching off. That's why people need set-top boxes to access also the SABC. So we're not sure how the SABC point helps. It seems to go the other way for Vodacom. And then our learned friend points to what he says of gaps. And he picks up on what I've been highlighting, that, well, he says we don't know the figures in respect of TV viewers and how many indigent people there are. I don't want to repeat myself. I'm going to simply lay store by paragraph 41 of the affidavit that I highlighted we'd filed this morning, where we gave the evidence, we gave the figures. And it just so happens that there's a correlation, a very neat correlation, between what the minister says are 3.5 million indigent households and 3.7 million people who are needing set-top boxes. So that's in respect of gaps, and I can't do better than what we've set out in some detail at paragraph 41 of our affidavit, but which our learned friends for Vodacom have simply blithely dismissed. But it's not to be dismissed, because those are facts and figures that the minister has admitted. Vodacom can quibble with them all they want. The minister has accepted those figures. Then our learned friend speaks about the false dichotomy, and he says that 700 and 800 is central to the current challenge by Telkom, he says. And he highlights that in Telkom's case, they say that if you can't use it fully, then it would be unlawful. Well, again, it's not helpful with respect to cherry pick out of what's been said in some other case and try and fit it into what's happening in this case. Because as our learned friend himself conceded, he said it very quickly, but he was absolutely correct in saying so, ICASA disputes that in that case. It hasn't been decided by anybody. It's what's said by Telkom, rather, in that case. ICASA disputes it. Who knows what the court will decide about that? What we do know is that for Vodacom, they want to free up the 700 and 800. We accept that it must be freed up. I can't tell you enough times that ETV, in its finding affidavit, emphatically said, we're not wanting to hold up digital migration. But we recognize, alongside MMA and SAS, who came in later, that there will be very significant impacts if it is railroaded in the way that it is currently. And so therefore, we're asking for these particular steps to be taken and declare it as granted. Why did we ask for them to be granted? Not to get some interdict in place. With respect, that is a belittling of our case. It was because we had repeatedly, over 6 letters, unanswered, asked the minister for confirmation of those very things. What are you going to do about your promises? What about the fact that very many people are going to be affected? What about the fact that we don't know that you're doing any form of public awareness campaign? What about how you're going to get Centec out into various outlying areas? How many set-top boxes have you got? Do you know that there's a chip shortage? These are the problems that you need to measure up against your public promises. And we need to know, alongside the public, whether what you're racing towards is going to leave millions of people behind. That's what the declaratory relief ultimately comes to reflect in this case. It's not an interdict that we're seeking in order to be difficult. It's a declarator in order to ensure that people's rights aren't violated. So our learned friend repeatedly makes the point that if there's a delay here in the freeing up of the spectrum, well, that's something that is going to be particularly problematic for Vodacom and others. Well, I'm terribly sorry to say this, but if a short delay in this particular case, the minister tells us she's going to be doing all of this very quickly. Well, let's let her report back in due course with the court getting proper reports from her. If she can do this very quickly over the space of the next 3 to 6 or 10 months or whatever it may be, let's assume it's 10 months' time that this has to happen. After having waited this long, another 10 months to ensure that this court gets proper figures and ensures that proper rights are properly respected in this case. It's a very small price to pay for large companies to have to sit and wait for a little while longer, not to earn very significant sums from being able to get through that spectrum, and yes, assist numbers of other people to be able to have access to the spectrum, but not at the cost of very millions of people who otherwise have no means, because they earn less than 3,500 Rand a month, to be able to buy the necessary packages and other things to watch television despite the promises that have been made to them. I must just give you the reference because there's been a suggestion by a little friend that somehow ETV was idle and that it was only too happy to try and sit back here and ensure that there was a stalling of all of the digital migration process. As I've already said, that's simply not correct in light of the affidavit and the letters that were written to the minister, where we repeatedly said, you can do this quickly, you can do it properly, but not at the expense of people. I'll just give you, ETV itself proposed a plan to the minister. It's at paragraph 62, case lines 020-40. And the plan is PR 23. It's also referenced at paragraph 54 of ETV's reply. It's the case lines 020-37. And you'll see it said there, ETV tried not to hold up digital migration by offering a plan that is reasonable and achieves the minister's objectives of freeing up 700 and 800, but not at the expense of leaving millions without free-to-air television. And that plan, I don't have the time to take you through it, but that plan sets out how ETV proposed that the minister would be able to achieve all of this. The minister did not accept that plan. The simple point being, it's not as though ETV was sitting back trying to hold up the digital migration policy by litigation or clever arguments disguised as interdicts. Not at all. It was actively attempting to resolve for the minister the problems that it had identified, going so far as to offer a plan. Then our little says,
Mr. Duplessis, I remember seeing that plan. I'm sorry to interrupt you. I remember seeing that plan, and I think it also involves registration of identifying and registering the viewers that would need the service. Isn't it so?
I'm not
sure. I remember seeing it somewhere. I thought I would ask about it, but I don't remember where I saw it. But it also involves the registration.
I recall, Justice Masimang, that what it entailed was that ETV would switch off various of its towers and it would move itself off various parts of the spectrum to allow access to the mobile operators in a staggered fashion so that they would be able to get onto the system faster. That was what it offered. But alongside that plan was what ETV was proposing, that the minister should take a longer period of time to ensure that people had proper knowledge of what this set of box registration process would entail, and that there needed to be obviously proper notice given to them of when the ASO would be. So they were aligned. But yes, the idea would be that ultimately the minister would get to do the job properly rather than in a rushed fashion, and that ETV wasn't sitting on the, trying to sit on the process and slow it down. It was attempting proactively to provide answers for the minister's problems as best it could. Then
I think the issue was also directed in terms of what ETV tried to do, in terms of informing your own viewers. Yes. That was part of what I think was being said.
Yes, yes, and it's correct.
Do you have any information?
And our little friend is correct. There isn't any evidence on the papers of ETV sending out notices to its viewers that they should go and register in order to get a set-top box. And our learned friend, then there's no information on it. There's no evidence of it. I can't say positively or otherwise.
Do you know why on the post office's notice that you read, do you know why of the channels that they talk about, ETV is not actually one of the channels that they refer to as people will be able to access these channels? I mean, they list a lot of channels, starting off with SABC channels, SABC News, even radio stations, but they don't list ETV. Do you know why that was?
I can't speak.
The notice that you read, yes, right towards the end, yes, that was the post office saying to people, come get your whatever. Right at the end, it says, these are the channels that you will be able to access. I can't remember where it is off here. So it lists from SABC 1, 2, 3, SABC News and radio stations, but it doesn't list ETV. I mean, do you know why that is the case?
No, I can't give you an answer. It may have been a mistake by the SAPO notice, but I had no idea. And I'll double check if there's anything in the papers about it, but I don't know the answer to why they left it off. But what I can say is that there's no evidence one way or the other to explain why it was. I mean, there's just no evidence that ETV was giving notice to its viewers that they should migrate. And I don't want to speculate as to an answer. It's just simply not dealt with in the papers. But what I can tell you is that Mr. Snickers, our learned friend, then draws the inference. He says that they don't want to get their viewers to get set-top boxes to move to digital. And he said that the inference was they wanted to eat up market share or take that from the SABC. But that's also not on the papers. I mean, that's an inference that he's attempting to draw, but it's not on the papers. And had that been said in the papers, we would have been able to deal with it. But there's another problem with that, is that, as I've already highlighted, we're not against migration. We've highlighted in numbers of ways that we are happy with migration subject to it being done constitutionally and lawfully. And we have constantly said, get out the boxes. Get the boxes out. We're not the ones switching off SABC. The minister has switched them off, but get out the boxes and make sure that they ultimately are switched off in a manner that doesn't harm the public. That's our answer all along. So that's in respect.
Mr. Duplessis, I think I found my note about ETV's plan.
Yes.
The practical step. Because if you look at the minister's plan and the ETV's plan, it says identification of qualifying households. Those are ETV's plan. And then data it also uses the data of 2018. May have increased. It says that may have increased the data of 2018. And it says must register, and I've just put on question marks there. And self-registration was 1.1 million captured. That was captured. I know it's as you writing notes, as you're going on, you that thing. But the most important thing is ETV's plan, also similar to the minister, required the identification and the registration of qualifying households. Do you agree with it?
Justice Basimang, I haven't seen what you're saying, but to the extent that it's there, I accept that. But of course, ETV has always accepted registration alongside what the minister's doing. The registration's been part and parcel of what is the appropriate means by which people are encouraged, obviously, to ensure that they are able to get access to set-top boxes. That's, we've said, is a perfectly understandable way of ensuring that that happens. But the answer really is, well, how is that done? Is it a reasonable process by which people are asked to register? How big is the pool? How much notice are they given? That's what this case is about. So it's not about whether ETV's plan is good or bad, or whether it includes registration or not. As I say, I don't know. I haven't read what you've highlighted for me. I would have to look at it with a bit more time. But what I can say to you is that this is the minister's plan, which one has to look at. And that is the case before you. And the minister's 3-week deadline for registration has had the result that it has, and was palpably unreasonable, and there was no notice of it and no consultation around it. Our learned friend next dealt, and I've got just 2 more points of his to deal with. He dealt with the KZN promise, and it got rather technical. I accept that at times I struggle to follow the argument, but as I understood it in outline, he said, well, under the KZN principle, you can change the promise. So I might decide, he said, not to do it by 31 March, for instance. So Justice Lukamwana, I'm happy to see you nodding so that I got the point correctly that he'd articulated. But the difficulty is that that's, again, it's divorced from the facts of this case, because the promisor in this case, being the government, being the minister, they've stood by the promise. They've stood by the promise. They said, we're going to provide set-top boxes to people by 31 March. But they say they haven't broken their promise because they made the pool smaller by their 31 October deadline. So the debate isn't about whether there's a promise that's been changed. That's the promise. The question is whether the promise has been reasonably implemented by virtue of the registration date. And so the promisor here stands by the promise. There's just a debate about whether they've actually given proper effect to it. And as Justice LaRue put it to our friend, so do you accept then that the promise is, in this case, that if you register by 31 October, I'll give you a set-top box by 31 March. And that must be correct. That must be what the promise entails. The promise is to give the box, not in the vacuum. The promise is to give the box in order to ensure a proper, reasonable switch-off by 31 March. Otherwise, what's the purpose of giving you the set-top box? And everybody hearing from the minister how she's racing around now trying to, at light speed, accelerate set-top boxes for the remaining 260,000 households by 31 March. What's the purpose of it? It's to ensure, why are you doing this? You're trying to ensure that there's a proper and reasonable switch-off by that time because people aren't left behind. That's the debate. Our learned friend says, well, the minister is empowered to switch off under the ITU, and there is no way, he says, it's just not the law, he says, it can never be the law, said our learned friend, that the minister is not empowered to switch off because of these promises that have been made. But with respect, he's wrong. His problem is threefold. Firstly, he only looks at this through the KZN principle. But he's forgotten, with respect, what our learned leader, Mr. Marcus, pointed out yesterday. The KZN principle is only one strand of our argument. Our argument is also about the duties under Section 7.2 of the Constitution, which go way beyond promises. They go to obligations accepted by the government in this case. And our case goes to the question of rationality and reasonableness, and whether the minister's conduct in this case meets those standards. So the KZN principle only assists our learned friend so far. The second, or his attempt to knock it down, only helps so far, I should say. The second problem is that our courts have repeatedly said, and our learned friends have not dealt with this jurisprudence at all. They've made again as though it doesn't exist. The TAC decision of the Constitutional Court, Mr. Marcus read to you, it stressed emphatically Section 7.2 of the Constitution is a quite separate basis for a court to grant the relief that we're seeking. And when a policy is implemented, this is what TAC says, when a policy is implemented by the state and it is in violation of rights, then the courts will grant relief. So that's the law. It doesn't help for Vodacom to tell us what the law isn't, when the Constitutional Court has made it emphatically clear that that is the law. And it's unreasonable, we say, in the circumstances of this case, and I shan't repeat all the arguments, for the minister to have done what she's done precisely because of the impact, the threat, the risk to millions of rights holders in the country. Lastly, our learned friend, under the guise of his arguments about this being an interdict case, I'll just deal with it quickly, even though that's a misconstrual of our relief. He says, well, there's no harm that we've proved. There's no harm that we've proved. Well, the loss of currently enjoyed access is harm. It's harm on the Joseph test, which I read for you. It's such harm that the Constitutional Court has said that if a party has enjoyed a particular service, whether it's by government promise that it's been given, or by government past practice that it's been given, or whether it's because that is a service necessary to ensure that rights to information are received, well then the loss of that service is harm. Our learned friend goes on to say, and he made it quite tellingly, he said, well, the numbers in this case don't look good. I'm not sure which numbers he was meaning, but if he was meaning the numbers by way of which the minister is going to be able to meet her deadlines and roll out set-top boxes and so on, well then indeed, numbers of people are at threat. Numbers of people's rights are at risk. And our learned friend then very enthusiastically said, ETV beats the drum, he said. These were his words. ETV beats the drum that it will take forever. Well, that's not a drum that we've beaten. We have said that 27,000 people per month does not meet the projection. We're not saying that it will never be met or it will take forever. We're just simply saying that the minister's case is that she will do this light speed rollout by the end of this month. And we're saying on 27,000 per month, as per your own figures, you're not going to make it. That's our case. We're not beating any drum other than a drum that says on your own version, you're not going to meet your projections. And on our learned friend's own argument, he cited the Vodacom report where he'd said 2,000 a day. Maybe that's what he meant by his numbers. The numbers not looking good. He was referencing their own economist report. Well, 2,000 installations a day. Let's just assume for the moment that we use Vodacom's figures. Well, even then, that's not going to be a forever moment. My maths is not the greatest at the best of times, but I understand that that will mean it will take 250 days to migrate the 507,000 that registered by 31 October. 250 days. If on Vodacom's numbers, there will be installations of 2,000 a day. That's not forever, but that's what it takes if you're going to do this properly. And if you're going to ensure that people's rights are not violated in the process. Finally, there is the argument then by our learned friend, Mr. Makari, and I can deal with it quite briefly, partly because he's echoed in large parts what has been said on behalf of Vodacom by our learned friend, Mr. Snickers. He's got 3 points, really. His first point is he says that ETV's review relief is dead because it was anticipatory relief, but I've already dealt with that. He tried to suggest that it was overtaken by events, but as I've already highlighted, we pretended that those events would happen. We accepted that it might, and therefore reserved our rights to review and set aside if that was the case. And if necessary, prayer 4, our learned friend read it out. He says, well, but prayer 4 of our notice of motion for review relief can't make sense anymore because it speaks about if the minister takes this decision. Well, with respect, the court is at large to do the obvious and simply insert or change to say the minister's decision taken on whatever the date was a week or so ago to set the ASO date is reviewed and set aside for all the reasons that we've given. And this court is perfectly entitled to do so under its broad, just and equitable relief under the jurisprudence of the Constitutional Court in EFF versus Speaker. I'll just give you the authority. EFF versus Speaker, 2018, Volume 2, Essay 571 CC. There the court said the power to grant just and equitable orders is wide. It allows courts to formulate an order that does not follow the prayers in the notice of motion. It empowers the courts, said the Constitutional Court, to address the real dispute between the parties. And by now, with respect, the real dispute between the parties has emerged for this court. It's crystallized. It's whether the minister's failure to consult around those 2 dates could ever be reasonable or in compliance with procedural fairness. And we say not. And so therefore the declaratives that we seek needed to be given. It's whether the ASO date could ever have been determined in the way that the minister did. We say not for the reasons I've articulated. So the review relief needs to follow. And then the question is, does the court have enough to be satisfied that the permutations of what the minister has done, accepting that there might be concerns around the borders of these large figures, requires reporting so that the minister can do a duty to explain what the impact will be on rights. And so that would do justice to the issues between the parties and that have crystallized before the court. Our learned friend next point, his second point is outer. He attempts to, with respect, retread a number of the arguments which are often heard in cases where there are interim interdicts sought to stop the exercise of a statutory power. But this is not this case. There's a decision that's already been taken by the minister. She's already set the ASO date. We're not seeking interim relief against the minister. She's already done what she's done and we're trying to set it aside. And there's just no answer from her around the error of law points that I've highlighted on duty to consult and the fact that she thinks she could do so through a policy decision, when in fact it's obviously through the regulations. So in that sense, this is not an outer case at all. It's about us dealing with conduct and decisions in a final hearing. And we have said that the minister's conduct and her decisions are unconstitutional. And we have done so relying on 30 years of constitutional court jurisprudence. Glenister, Treatment Action Campaign, Causa, those cases which have already been set out on their heads, that show that there is a duty on courts to protect rights when they are threatened under Section 38 of the Constitution is the standing provision, and the duties to do so flow for the court under Section 172 of its remedial power. It is the duty of courts to protect rights by ordering government to act constitutionally. That's what we seek. And so in the Treatment Action Campaign case, paragraphs 99 and 101, our learned leader, Mr. Marcus, I think, in fact, read those paragraphs to you yesterday, but we commend them to you again. I shan't read them, obviously, in reply. But they really are the full answer to this argument by both the ICASA's counsel, Mr. Mokari, our learned friend, and to Mr. Snickers' argument, our learned friend for Vodacom. So we commend to the court those particular passages. And then our learned friend finally, we say with respect, effectively gave evidence from the bar. It certainly wasn't in his papers as we understood it, where he asked, well, can one use other platforms? Can people in fact use other platforms? That's the question. How many other people might be able to use other devices to be able to access a television ongoingly after the 31st of March? Well, that with respect again, read paragraph 41 of the affidavit we filed this morning, where instead of evidence from the bar through counsel, we gave you the evidence of the minister that has been confirmed, she's not denied it, and which is from the leading experts that MMA have cited around the figures. That's the evidence. And then the question is, can people who number in the millions, those that didn't meet the deadline, the lost millions, the forgotten millions as I've called them, can we simply ignore them on the basis that, well, they could probably afford it. They might be able to afford it. That's effectively the argument by our friend Mr. McCoy. Well, they might be able to afford it. Who knows? But that is contrary to the evidence given by MMA and SOS, who've explained that that type of argument is entirely cynical, and they've done it in their affidavits. It's at case lines 019-26 and 27, where they've explained that people in this situation who are earning less than 3,500 Rand a month, they simply do not have the means to do this. And so therefore there's the particular concern for protecting their rights. I've just quickly got to finish one last point in response to what you were asking me, Justice Masi, Mang, around the ETV plan and whether they also sought registration. We've had an opportunity now to look at the plan. It's at PR 23 00-233 to the founding affidavit. So it's an annexure there. That's ETV's plan. And there is no reference to registration. It's not what ETV had contended for, as we understand it. And the reference is to analog households, and you'll see that at 001-247. So it's just a clarification that I wish to provide. Finally, but in as brief a way as possible, and pivoting off what I've just given to you about the relief that I've said to you under the Constitutional Court's jurisprudence in EFF versus Speaker, two things. Courts can grant relief even if it hasn't been the relief asked for by the parties. And second, the courts must do justice to the issues as they've then crystallized in the case. Well, we stand by the relief that we've sought in respect of our declarators. But we accept, we've listened to the debates, and that we accept that the declarators might be slightly refined and that they could be improved in light of those debates, just to be clarifying of what it is that the minister should then be told by this court. And I will simply highlight that for you. I'll send it on case lines as well, what we regard as the draft orders on those two declarators. But if I might just read them to you for now. So the declarator, as it's currently framed, would simply stay as it is, but where we speak about the minister is required to undertake a process of consultation with affected parties, including but not limited to ETV, we think it would be useful for the court to have MMA, SOS, and representatives of indigent qualifying households, to make it clear that those are the parties that need to be consulted with, so that the consultation process is focused. And in the final paragraph of that declarator, we would add that in order to ensure that those in South Africa who are reliant on analog broadcasting are not deprived of their access to free-to-air broadcasts as a consequence of the determination by the minister, so that clarifies that that's what the violation has been through the determination of the minister. The second declarator would be in respect of the completion of analog switch-off date, and there too we'd simply suggest an addition or a slight clarification. We would say that it's declared that the digital migration process may not be completed and the ASO date may not be proclaimed by the minister unless and until the ministers complied with their constitutional obligations and public promises. And then we would suggest the following clarifications: to take reasonable and justifiable steps to provide indigent qualifying South African households who are presently reliant on analog broadcasting with means to access free-to-air broadcasting via digital broadcasting. So we would put those up to the extent that they're necessary and hopefully of assistance to the court. We would finally make the point that to the extent that the court, so we would prefer for obviously those declarators to be granted together with the reporting relief and the review relief, as we've said as well. But we accept that to the extent that the court is minded to focus its attention on the review relief, then it can do so, as MMA and SOS have said, and that it can set aside the ASO date, with one clarification on that score, and that in its writing of the judgment, it would have to explain, even if it didn't want to issue the declarators in hard form, it would have to explain why that review relief was granted, and it would then end up having to explain that that was because of the minister not having properly consulted and the minister not having properly taken the necessary steps to ensure that reasonable accommodation had been catered for people who were otherwise going to lose television. And it is therefore something that would be of guidance to the minister, so that she'd be in a proper position to understand why the court was setting aside a decision. But as I say, our primary position remains that our relief as tweaked with those declarators should be granted, together with the review relief and the reporting relief. But to the extent that the court wishes to go down the road of the MMA SLS review relief only, then it should do so by writing a judgment which expresses very much the types of duties which we say are necessary to emphasize by the court, particularly because the minister's refused to acknowledge that she has a duty to consult, and because the minister has insisted that she's entitled to do this through a policy. I'm indebted to the court and to my colleagues, of course, for having to have sat through as much as they have, and I now would ask for an opportunity to hand over to, I think, Mr. Ferreira.
Yes, thanks for staying long and for the presentation, and as repeat once more, for having assisted overnight. This is probably the second night that you're going to put up late, but thanks, Mr. Ferreira.
Thank you, Justice Musimang, and just to reassure the justices, due to the comprehensiveness of Mr. Du Plessis, I can promise you that I will not be very long. I really only have a few points which are made. I won't repeat anything he has said. Justices, the primary point is in relation to the review relief, which we sought, I think it's paragraph 2.3 of the notice of motion. You will recall that the bulk of my address in chief and the bulk of our heads of argument was devoted to making out really 4 grounds of review of the decision to determine the analog switch-off date. We argued that it was irrational due to a failure to investigate its impact on expression rights, irrational due to the impact of the 3-week deadline imposed on October the 5th, which resulted in many being excluded, and it was irrational because it failed to balance the dual purpose of the power to strike a midway between protecting broadcast, the public function of broadcasting, while also securing efficient use of spectrum and that it was a retrogressive measure. Now, there has been not one word from not one of the respondents in defense of those grounds of review on the merits. Not a single word. Vodacom doesn't deal with it at all. The Minister and ICASA say only that the review relief is incompetent because it came, essentially it's a ripeness point. And so if you reject that technical defense and find that the review relief is competent, then there's no defense on the merits before you, and effectively the review is conceded. So let me just briefly explain why the submission that the review was incompetent is wrong as a matter of law. What the Minister says is, look, you can't bring your review in these circumstances, because at the time that you issued your notice of motion, the final decision had not yet been taken. The Minister was still considering, and we know that there was this sort of tap dance where the President announces a year before it's going to be the 31st of March. This application is issued towards the end of October. The Minister says, I haven't decided. And then a week or so before the hearing, big surprise, the Minister takes a decision, and oh look, it happens to be the 31st of March, just as the President promised before. But they say that chronological tap dance by the Minister to attempt to avoid taking a final decision until after the papers were ripe results in the review being incompetent. We submit that is not a good defense to the review, and the reason is really that the complaint in its essence is that the review, when it was launched, was not yet ripe for hearing because there had not yet been a final decision. So it's really a complaint about ripeness. There was no authority provided to you which says that a review of this kind is not ripe for hearing if a final decision has not been made. And in fact, our law is to the opposite effect. If I may give you a reference to a judgment of the Supreme Court of Appeal, it's the decision of Chairman State Tender Board v. Digital Voice Processing. Sneller Digital is in the name of the case, and the reference is 2012, Volume 2, SA 16, a decision of the SCA. And the judgment was written by Justice Plaskett. He was acting at the time. And the case related to a tender, as many reviews often do. And what happened there was that a tenderer was excluded from consideration, but that exclusion was never communicated to the tenderer. And before the decision to exclude the tenderer was communicated, it brought a review. And the only defense to the review, as in this case, was that having brought the review before the decision had been finally taken and communicated, it was not yet ripe for hearing by the time that the review was heard. And Justice Plaskett held as follows at paragraph 20. I commend to the court paragraph 17 to 20, but paragraph 20 in particular is where he reaches his conclusion, and he says the following: generally speaking, whether an administrative action is ripe for challenge depends on its impact and not on whether the decision maker has formalistically notified the affected party of the decision, or even on whether the decision is a preliminary one or the ultimate decision in a layered process. So let me just say that's exactly where we are. This was at best for the Minister, at the time that the notice of motion was issued, a preliminary decision leading towards the final decision that was ultimately gazetted about a week ago. Justice Plaskett then says, many examples spring to mind, but one will suffice. If, for instance, a liquor board cancelled a trader's liquor license without informing him or her, and the police then took steps to close the premises or seize the trader's stock, I have no doubt that the decision would be ripe for challenge the moment those steps were threatened. To suggest that the trader is without a remedy and is precluded from protecting his or her rights until the liquor board has communicated the decision to him or her only has to be stated to be rejected. Ultimately, whether a decision is ripe for challenge is a question of fact, not one of dogma. And he says it's about impact, it's about prejudice. And we submit, justices, that the decision to set analog switch off for the end of March was one which manifestly had an impact from the time that it was taken, even although it was not yet gazetted at that time. And so the ripeness objection is bad in law and falls to be rejected. So once that's so, what does the complaint boil down to? Well, our learned friends for the Minister say, Well, you failed to comply with Rule 53 because you haven't required a record and you haven't given the Minister an opportunity to provide reasons. That submission too is unsustainable. The Minister's opportunity to provide her reasons for the decision under review was in the filing of the answering affidavit, and she duly did provide those reasons. She's attempted to justify the decision. To the extent that our learned friend for ICASA complains that you had to follow Rule 53, that objection is not open to him in these proceedings, because if a party has followed a wrong rule or taken an irregular step, the remedy is under Rule 30. You have to bring a Rule 30 notice to set aside the irregular step. But if you, instead of doing that, yourself take a further step in the litigation, you lose the ability to object about the irregular step. That's in Rule 30 brackets 2 brackets B of the High Court rules. So there is simply nothing to this objection that the review relief is incompetent. The review was ripe at the time that it was brought, and it has only ripened further in between that time because the decision has since been promulgated and gazetted. And so given that, the review simply has to succeed because there's no defence on the merits of the ground of the review. And Vodacom expressly limited itself to what it called the interdictory relief. So none of Vodacom's submissions are of any relevance in the context of the review, and Mr. Snake has expressly said, and he did not address the grounds of review which we sought to advance. So that's the primary submission we make in reply. The secondary one, Justices, is in response to this late affidavit which came asserting that the acceleration in relation to people who have already registered, which is contemplated to occur in the next 2 weeks, is good enough, and that this court can take comfort from the fact that the Deputy Director General has gone on oath saying that that acceleration can occur. I already submitted to this court that those astronomical increases in rates of installation are simply not possible on the version. It is totally unrealistic, and Justice Lukaimane raised the very pertinent point that if all of this was possible, why has it not already begun to occur? There are provinces where people have already been cut off and blacked out, and yet we are asked to believe that these accelerated rates of installation are only going to start to occur from tomorrow. Why not yesterday? Why not the day before, if it was possible? And we submit too that the confidence of the Minister's Counsel in those assertions is also betrayed by the fact that when he responded to Justice LaRue's question saying, well, what happens if we give an order which says the Minister is required to install X number by X date, taken directly from the Minister's affidavit? He says, well, you shouldn't give an order, it's good enough because perjury provides a good enough remedy, because she said on affidavit that that is possible. But he knows very well that that affidavit is phrased very carefully. It would give rise to no claim for perjury in due course if those dates are not met, because all that is said is that we project that the following dates will be possible. And those projections we have submitted to you are valueless because of the historical failure to meet anything like that kind of rate of installation. So we submit, if the Minister's Counsel had any confidence that those projected target dates could be met, he would have gladly said, yes, put it in an order, because an order has the consequence of contempt of court, and if it's in an order, then there is a remedy. But if it just comes in the reasons that we note that the Minister has given these projections, well, perjury has no purchase because of the very careful terms in which that affidavit is phrased. So we do not accept that that provides an adequate remedy. I'm not going to respond to our learned friends from Vodacom in detail, other than to give the court 2 references. I did give the court a wrong, off the top of my head, fact in relation to the price of a set-top box. In Vodacom's affidavit, they say that the price of a box is around 500 Rand. The price of a new smart TV is 2,700 Rand. That's at page 017-19, paragraph 47. And finally, to say that Mr. Snake has made the submission that if the constitutional issue in this case can be avoided without reaching it, that is a long-standing principle of our constitutional law. That principle is no longer good law. It was rejected by the majority of the Constitutional Court in the matter of Jordan versus Tshwane, 2017, volume 6, SA 287, judgment of the Constitutional Court, paragraph 7 to 8, Justice Cameron, for the majority of the Constitutional Court, made clear that the principle of constitutional avoidance no longer forms any part of our law, and in fact he says on the contrary, the duty is the opposite. It is where there is a constitutional issue that arises, that issue must be determined at the outset and must colour the court's approach to those issues from the outset. Finally, Justice Musimang, you raised with our learned friends for ETV the factual question of why, if the interveners are so committed to these issues, they don't appear in meetings leading up to the decisions or and didn't appear to have any interest until the time came for litigation. That question is premised on an incorrect factual assumption. If one looks at the replying affidavit from paragraph 17, page 019-9 to 019-21, what is set out in exhaustive detail is the numerous attempts by MMA and SOS to make many written submissions, and that's why the replying affidavit is so long, because all those submissions are annexed to the Minister, to ICASA, to USASA, to the state, concerning to raise their concerns about digital migration. They have always been actively engaged as NGO corporate citizens on this issue. Why they don't appear in the SteerCom meetings and why they were never consulted appears in paragraph 19 of the replying affidavit. They say that they were left in the dark in relation to those consultations. They were never invited, and it doesn't, we don't understand the Minister or any of the respondents to suggest that my clients were consulted in relation in particular to the end of March 3-week deadline or in relation to the determination of analog switch-off. I beg your pardon, end of October 3-week deadline, end of March final date of cutoff. Justices, on behalf of all my colleagues, we are very indebted to you for sitting so late in such an important case.
Thank you, Mrs. Nakas, and also thank you for the indulgence of staying up until so late, yesterday and today. If none of my sisters have got anything to ask you, maybe we may excuse you. Dear sisters,
I have nothing from my side, brother.
No, from me, just to echo your thanks.
Thanks, Mr. Ferreira. Yes, we've virtually come to the end of the sitting. Is there anyone, any more of the council who, I would imagine everyone is tired, no one would want to, there's nothing we're leaving out, yeah? I can safely adjourn the matter.
As the court pleases.
Thank you. The court will then adjourn.
Thank you.
The matter, judgment will be reserved, and me and my sisters will put our heads together as to who's going to be settled writing this judgment, and you'll probably hear from us.
Thank you.
Thank you.
As the court pleases.
May I please?